My lords, this is a KLGP matter, my lords. KLGP matter, my lords. We had filed two applications for dismissal and for vacating the interim order. Both have been confirmed, my lords, and cognizance has also been taken on a ground that because super built up area is more than the cital area, there is encroachment.
area encroachment agata.
Yes. And in fact,
Judgment is always horizontal, alwa.
please, ma'am. And several of our contentions have not been considered. Matter is on 5th, if I may request for Wednesday, my lords.
Wednesday, third.
Grateful, my lords.
Okay.
Respect of the LGP matters concern, my lord. I have no concern for the grabbing, madam. I am not a halati, I am not a grantee, I am no concern, though they are made a party to the. Kindly, 9th was posted for the charges, my lord, for the treason.
9th ಇದೆಯಾ?
9th ಹಾಕಿದ್ದಾರೆ ಅದಕ್ಕೆ ಈ ಮಂತ್ ಈ
ಹಾಕೊಳ್ಳಿ ಯಾವ್ದು?
5th or 4th or
ಯಾವ್ದಾರ
5th.
ಒಂದು ಡೇಟ್ ನೋಡ್ತೀನಿ. ಆಲ್.
Ejectment suit is decreed.
Huh.
I had already surrendered possession.
Huh.
But the court has awarded mean profits, damages to the property also, that is challenged.
ಹೌದು ಮತ್ತೆ ನೀವು ಅಲ್ಲಿ
And I have not caused damages. In fact,
damages is not a damage.
no, I understand mean profits. This is the court has.
Next week. Good.
Your Lordship, memo for being spoken to, there is a slight mistake.
In that blinds matter.
Yes, slight mistake. Instead of DDPI Hassan, Udupi, it has mentioned as DDPI Hassan.
ನೋಡೋಣ ರಿಪೇರಿ ಮಾಡಿ ಅಂತ ಹೇಳಿ. ಚೇಂಬರ್ ರಿಪೇರ್ ಮಾಡಿ. ಚೇಂಬರ್.
And in one of the case, my spelling is also wrong.
Your
One-
name is not
In
right.
one of the
Spelled
case.
out. ನೋಡಿ ಎರಡು ಅದ್ರಲ್ಲಿ ಬರ್ದಿರಾ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ?
Yes, yes.
My lords,
ಚೇಂಬರ್ ರಿಪೇರ್ ಮಾಡಿ.
my lords, it's a GM consumer matter, my lords. It's a GM consumer.
Brother Faruqi, you go to chamber, sit with my steno there.
Yes.
Just see what can be done.
Yes, sir.
Thereafter, we will finalize that draft.
Shall I come during the lunch hour?
Good. No, for lunch, I have not brought lunch for you today.
No.
I have brought only for you. You are most welcome. Welcome. Okay.
In some time, I'll finish.
All.
My lords, my lords, it's a
My lord, this is the original side appeal, my lord. The matter is coming up before the CPIC for evidence on Wednesday, my lord. So I pray that it may be had on Wednesday, my lord.
Can't you take time there? Short accommodation they will give, na?
No, my lord, we've already sought time there,
Good.
my lord. So that's why.
My lords, it's a consumer matter, my lords. I am the landlord, my lords. The developer has not completed the project and he has taken the money from the consumer and ran away. So they have filed the original complaint before the consumer district. my lords.
Against you also.
No, not my lord. Against not me. It is against the builder they have filed and the consumer court has ordered. In the execution, they have implicated me, my lords, and they have court. I have already undertaken to construct. I have completed the construction also, but the court is directing me to.
Next week, we'll take that matter.
My lords, last week I had moved on Friday. My lords had
They
given.
moved already.
Yes, my lord.
ನೋಡ್ರಿ ಮೂವ್ ಮಾಡಿದ್ರು ಅಂತ ಯಾಕೆ
My lords, the difficulty is I had asked for.
ಫೋರ್ತ್ ನಾ ಯಾವತ್ತಿದೆ ಅದು ಮ್ಯಾಟ್
My lords, next week ಅಲ್ಲಿ ಇದೆ.
ಬಿಡಿ ಮತ್ತೆ ಫೋರ್ತ್ ನಾಡ್ದು ಅಲ್ವಾ ಫೋರ್ತ್
My-
ವೈ ಸೋ ಮಚ್ ಹೇಸ್ಟ್
Please.
ಎಸ್
Serial number 18 become infructuous, my lord.
18
18. It is
Sorry.
transfer matter.
matter is disposed of as having become infructuous, comma, as submitted by learned counsel for the petitioner and not opposed by the learned counsel appearing for the caveator.
Government.
Government AG, yeah, by the other side, counsel for the other side. First, ordered accordingly. Yes,
Seal number 26, my lordships.
26.
I appear for the appellant in this case, my lordships. A short accommodation, my lordships.
RSA,
Yes.
2013 matter, we have read this file actually.
RFA, my lordships, first
Huh?
appeal, my lordships. Suit for partition partly decreed, my lordships.
Huh.
A small is a
All
short accommodation. my lordships.
immediately after vacation at the request of, have you informed the other side?
Lordships, other side is there, my
You're
lordships.
informed.
Obliged.
Serial number 28, my lord,
28,
28. And for the appellant, my lord, a short accommodation may be given.
2016 matter,
Yes, my lord.
call in the second week of February,
Obligation.
My
Great.
lords, serial number 24, my lords.
24th.
My lords, my senior's mother has been admitted in the hospital today.
Mother is admitted.
Yes. Would kindly have it on Thursday, my lords.
Call next week
Grateful. my lords.
on health ground of counsel, of mother of counsel for the
Respondent number 1 and 2.
first respondent. Okay.
Grateful. my lords.
I guess we are actually, they wanted to settle it. Anyway, they can't escape. Yes. Somashekar.
Lordship, for the appellant,
Ah.
short accommodation, Lordship.
Okay.
Our steps in respect of R4.
3 times you have taken steps already.
Yes.
ಅದೇನು ಇದೆಲ್ಲ ವಾಪಸ್ ಬಂದಿಲ್ಲನಾ? Insufficient redress. Steps by substituted mode of service. Within 10 days. Yes, sure. 10 days. Failing which appeal stands disposed of as having statutorily abated. Okay.
Respond 2 and 6 minutes.
As far as appellant is concerned, paper books are filed on 28/10/2022.
Yes, sir.
That's one thing. Second thing is, Millard, the prayers were 25/1 without permission of the government, factory is closed. The second thing is, the unlawful retrenchment.
Ready,
Only-
start
only-
the argument.
We are ready.
You ready?
We are ready, my lords.
Yes. Kodi. Your friends can go for coffee round. Perhaps it will take some time. Yes.
ನಾಳೆ ಹಾಕೋಣ.
All right.
ನಾಳೆ. With the understanding
not
that
do.
Millard,
ನಾಳೆ
the-
ಆಗಲ್ಲ.
The situation has become piquant for the reason that there was an order passed by this honorable court accepting the undertaking of the advocate not to alienate the property. And the application is filed saying that OSA is dismissed. Therefore, the intermodal is also gone. Undertaking, specifically the party must be relieved from the undertaking. And two is when the matter is restored, according to 3 judges' decision rendered in 2004, all intermodals are revived. And by making a wrong representation, when last week I was away from
No,
India.
sir. No, sir. That matter is referred to 5-judge bench.
Yeah. No,
Whether-
last week it is
That's
referred to
last
5
week it is
judges.
referred.
Unfortunately, the matter in which reference is made became infructuous, and it is the rest of the matters are there. I have got all the information in
Yeah,
Supreme
fix it.
Court. That is withdrawn only on
When you want,
24.
when you want.
Tomorrow is possible.
Tomorrow.
Allappa,
We have Hyderabad, Karnataka matter. ಫೈಲ್ ಮಾಡಿವಿ ಅಂತ ಹೇಳಿದಾರೆ ನೋಡ್ರಿ, ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ನೋಡ್ಕೊಳ್ಳಿ. Thursday ಹಾಕೋಬಹುದು.
in my absence, an order of injunction is vacated by a wrong representation. Very sad, very sad.
The contempt has been dismissed, my lords. It is not that the injunction was vacated.
I'm saying the same thing. Contempt is got dismissed. It is not dismissed. Got dismissed by a wrong representation.
5th Thursday will argue the matter.
Please.
5th, all right, sir.
Please.
The understanding that it will be heard finally, my lord.
No,
because
I
of
want it to be
time.
heard. I want.
He wants it tomorrow. We are saying not possible.
Very well.
With that, always that understanding only. Understanding is never to adjourn the matter.
Grateful.
Okay.
In the matter, my lord. My senior is out of station 2 weeks and
Thursday.
2 weeks time, my lord.
2 weeks
Senior is
now.
out of station.
No, not,
Allah,
cannot be
because
given.
we are the only contesting party right now, my lords. Therefore.
2 weeks question will not arise. We have, how many times we should read the papers? They are not that attractive pleadings we have seen. Yes,
Grateful.
sorry to say that. Yes. ಏನಾರ ಪ್ಲೀಡಿಂಗ್ಸ್ ಓದಿದ್ರೆ ವ್ಯಾಲ್ಯೂ ಅಡಿಷನ್ ಆಗ್ಬೇಕು ನಮ್ಗೆ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಲಾ, ಲ್ಯಾಂಗ್ವೇಜ್, ಫಿಲಾಸಫಿ, ಲೈಫ್. ಹಂಗ ಆಗಂಗಿಲ್ಲ. ನಮ್ದು ಇರೋದೇ ಪೊಲ್ಯೂಟ್ ಆಗಿ ಹೋಗ್ಬಿಡ್ತು. ಆ ನಮ್ನಿ ಪ್ರಾಬ್ಲಮ್ಸ್. ಅವ್ನು ಹಗಲೆಲ್ಲ ಓದಕ್ಕಾಗಲ್ಲ. ಎಸ್.
Lords, I appear for the appellant, my lords.
Serial number 3, I appear for the appellant in serial number 3. 3.1 is the connected matter. In that our respondent number 3, who is my mother, passed away on 7/6/2021. I have filed a memo reporting her death, and her LRs are already there on record.
ಯಾರು?
That is respondent number 1, 2, 4, 5, 6, 7, 8 to 10, my lord.
1, 2.
It's a suit for partition.
All right. Who are they?
Respondent number 1, 2, 4, 5, and 6.
You said 9 also, something. Yes.
That is the grandchildren of the respondent number 3, my lord. 7 to 9 are the grandchildren.
Barkam. Third respondent is reported to have died. And it is unanimously submitted at the bar that respondent numbers 1, 2, 4, 5, and 6 being the LRs represent estate of the said deceased. And therefore matter does not abate. First up, we agree. First up, appellant to make a remark beside the cost title to this effect. Okay.
One more submission, my lord. respondent number 1, 2, 4 and 5 are represented by their counsels in the connected matter who are in 3.1, my lord, they are
Fine.
respondent
All
number
right.
1, 2 and appellant number 1 and 2, my lord.
Appellant numbers 1 and 2.
1 and 2 and respondent number 1 and 2. in
Brother,
the
you can
connect
accept
matter.
notice now, you appear for them.
My lords, I appearing for R3. This is my lord. I don't
have any
further instructions.
But do you appear for the LRs in the companion matter?
No, man.
Who is the counsel who appears for the LRs in companion matter?
My lord, respondent number 1 is
Appearing for
represented
R1.
by Mohammed Akil.
Yes, I'm
appear-
appearing for R1, sir.
Then you have to appear for them also.
Yes, your lordship.
Counsel appearing for ಯಾವ respondent ಗೆ?
Number 1.
1,
Respondent
2,
number
2, 1, 2, 4 and 5, my lord.
No, companion appeal ನಲ್ಲಿ ಯಾರಿಗೆ appear ಆಗ್ತಾರೆ ಅವರು?
That is for appellant number 1, appellant number 2, respondent number 1 and respondent number 2. They have been represented by their counsels, my lord.
1 and 2 happen to be
Respondent number 1 and 2 is represented by Mohammed Akil and Sanghavi. And 4 and 5 are
ಆಯ್ತು, ಒಂದ್
represented
ನಿಮಿಷ
by
ಇರಿ.
Chidanandaya, my lord.
Quite.
Mohammed Akil appears for R1.
In first matter, Mohammed Akil appears for respondent 1.
HJ Sangvi for R2.
ಅಲ್ಲ ಈಗ
Connected matter ಅವ್ರು appear.
Shri so and so Mohammed Akil, learned counsel appearing for respondent numbers
1, my lord.
respondent number 1 in companion RFA 707 of 2017
Yes,
on
my
our
lord.
request appears for respondent numbers 1, 2, 4, 5 and 4 and 1 ಅಷ್ಟೇನಾ?
Only
1, 2,
respondent number 1, my lord.
Respondent number 1
Respondent number 2 is
in
HJ Sanghavi, my lord.
in RFA 948 of 2017. Full stop.
Similarly, HJ Sangvi for R2.
Similarly, respondent number Shri HJ Sangvi, learned counsel appearing for respondent number 2 in RFA 707 of 2017 appears for respondent number 2 in RFA 948 of 2017.
Please, my lord. And appellants, appellant number 1 and 2 in 707 is arrayed as respondent number 4 and 5 in this appeal, my lord.
ಬರ್ಕೊಳ್ಳಿ. Shri L.M. Chidanandaya, learned counsel appearing for the appellants on request appears for respondent numbers 4, 5 and 6.
Only 4 and 5, my lord.
4 and 5 in companion appeal in RFA 948 of 2017.
My lords, and
Yes,
we
my
are
lord.
the.
6 to 10 notice has to be issued, my lord.
707.
Respondent number 6 to 7 notice has 6 to 10 the notice has to go, my lord.
Issue emergent notice to ಅವ್ರಿಗೆ. So and so steps, if steps are taken in respect of R6 to R9.
R9.
R10, my lord.
R10 also.
My lords, only
10, my
R9, my lords, R6 to R9.
10 you
No,
appear.
in
No,
our appeal,
I appear for the
R10 is there,
appellants.
my lord.
Only R9 is the last party.
In 948, my lord, R10 is there, my lord.
All. ಅಲ್ಲಿ by way of emergent notice.
Please, my lord.
ಎಷ್ಟು ಇದ್ದಾರೆ ಉಳಿದಂತ ಎಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಗೆ? Okay.
Grateful. My lords, and I pray the interim order of status quo to be extended
Interim order, if any, shall continue.
on 28/4, this on 2017.
All
This on
right, all
code.
Next.
Grateful, grateful, my lords.
Highly obliged, my lord.
Okay. 4.
Respond to 6 and 8, my.
5, 7, madam.
Yes.
Petition, my lords, came to be dismissed on 13/9/2024, my lords.
What is that?
For restoration of the petition, my lords.
The other bench has made this order.
Yes, sir.
Yes,
Other bench made the order.
Yes, your
lords. The coordinate bench had made the order.
matter has become infructuous, your lordship.
Infectious.
Yes,
How?
that is, they have,
How?
if I may be permitted. There is a appeal filed in the Supreme Court which has concluded, and this writ petition was filed based on the interim order in the Supreme Court. And the Honorable Apex Court has passed the final order, and the matter, this petition has become infructuous. Therefore, the interim order was vacated in the July, month of July Two dates were given, nobody represented, therefore it was dismissed.
3/7/2024. It has been dismissed for non-prosecution. If it could be restored, my lord, sir.
If
may
it
be
is
heard
restored,
by-
you file that restoration application.
I have filed, my lord, sir, already.
If that is restored,
No, my lord, sir, that is a separate matter which has already come to an end
No.
after the Supreme Court has been seized of the matter, my lord, sir.
no,
Your
No,
Lordship,
this is a parallel proceeding.
Adadmel you can make submission.
Only one submission. Your Lord, my friend has filed a memo on 5/4/2024, enclosing a copy of the orders of the Honorable Supreme Court. Your Lordship may kindly see that.
Says it's a different matter, anta.
No.
No.
That
It is not an
I
extension
can,
of
I
this
can
case,
show
my
the
lord.
parties.
It's a different case, my lord.
ದಯವಿಟ್ಟು ತಾವು ಒಂದು ನಿಮಿಷ ಅದು ಆರ್ಡರ್ ಓದ್ಬಿಡ್ಬೇಕು. 3/7/2024, respondent number 3 and 10 are filed.
What was challenged before the tribunal?
Before the tribunal, the rules framed by the Employment Training Department, my lord, the selection to the method of recruitment of the post of Assistant Director / Principal Grade 2.
What we suggest is,
Yes.
we will restore this. We will have it next week. Next week you make, otherwise it may reflect on the conduct of the council.
That I understand, my lord,
Barkali.
but the
The
it would be
coordinate
futile
with,
exercise, my lord, that's all my
The
suggestion.
order dated 14/8/2024 had dismissed the writ petition for non-prosecution. First off. Now, one day application,
One application.
An application is moved supported by an affidavit seeking restoration of the matter to the board by recalling the said order. First off. No objections are filed to this.
Copy is not.
Copy ne kuch-
Copy ne ಕೊಟ್ಟಿಲ್ಲ. They are not served the copy.
Better. Next. Having heard the counsel for the parties and having perused the petition papers, we are having become infructuous, dismiss for default, having become infructuous first. Okay? Next, having heard the learned counsel for the parties and having perused the petition papers, the order dated 14/8/2024 is recalled and matter is restored to the board. First off, however, this order shall not be construed that the contention as to it having become infructuous is foreclosed. So that you can argue that. Otherwise, tomorrow he may say you have recalled on the ground that it has not become infructuous. Therefore, here the matter on merits of the help. Therefore, we have put you to that.
Correct also.
That's okay.
Call next week. Okay. Yes. Brother, I'll give one or two books to our library. Which book you will give?
Your lordship's suggestion.
Whichever book. Law in a Changing Society
Much okay.
by Wolfgang Friedman. It's a very good book.
Much okay.
See that.
Yes.
Subject to condition that the petitioner shall present a Law in a Changing Society by Wolfgang Friedman to Advocates Association Library.
Much okay.
Immediately. Okay.
Yes.
Okay. You also read that. It's a very good book.
Much okay.
Yes.
And for the petitioner, madam,
Ah.
during course of the day, madam. Second time notice.
Second time.
Yes.
Steps finally within 2 weeks failing which petition stands rejected.
Appearing for the appellant in the matter, my lord. My apologies for appearing online.
Nodi. Accepted ಮಾಡ್ಬೇಕಾಗ್ತದೆ. Service.
I've taken out paper publication with respect to R6, which is Shantam.
Notice in respect of respondent number 6, Srimati Shanta was taken by substituted mode with the order of the court. First off, name of the said respondent is called out thrice in the open court and there is no response. First off. Next paragraph. In view of the above, service on the said respondent is held sufficient. Okay.
Grateful. But if I make a humble submission in the matter.
You can make a strong submission also. Why humble? We need not be humble in law.
Grateful. My lords, I've engaged learned senior counsel in the matter. If I may kindly request this court to post the matter for final arguments.
Whichever date you want, we'll give. We are not on the ground that senior counsel, all our senior counsels to us.
Grateful. 17th, if I may request for 17th of this month, my lords.
17th.
Please, my lords.
All right. 17th, we'll have that matter.
Grateful, my lords. Grateful.
On 17th. All are respected, very respectable members of the bar, especially for Bangalore lawyers. Say what a bar. Yes.
Obliged, my lords, grateful.
Entry model to continue. Okay. Purushotthama. Translation. In translation. No, translation not. Purushotthama knows Kannada, we also know Kannada.
Yes, my lord.
Yes, Purushotthama.
My lord, government has to file the reply statement, my lord.
Why do you worry? Can you insist the defendant should file the WS?
Because
If they do not want to file, they do not want to file. You argue your matter.
it is a matter of reservation. I have not been given the reservation post. That is the case before this honorable.
Are you ready in the matter? You don't want to file objections?
ನಾ ಹಾಕಿದ್ದೀನಿ.
The hearing
I-
ಆದ್ಮೇಲೆ ನಾನು objection
I
ಹಾಕಿದ್ದಲ್ಲ.
have filed the objection.
You have filed objection. Objection ಹಾಕಿದಾರಂತಲ್ಲ.
Government ಹಾಕಿಲ್ಲ ಅಂತ.
Government has.
ನೀವು ಹಾಕ್ತೀರಾ ಇಲ್ಲ? Reservation ಇದ್ದಾಗ ಹಾಕೋದು ಒಳ್ಳೇದು. Making it clear. Call this matter on 17. Please. 17. To enable government to file objections, if any, failing which the right to file one stands forfeited. Yes. Dispensed with. Yes.
Appear for petitioner, my lord. The office objection is, my lord. I served the copy on the government, my lord, the minor objections.
But
Quoted, my lord. And also
office
speaking-
objection is complied. Okay.
My lord, this is before this courts where there is a rejection of compassionate appointment to petitioner, my lord. On the
Rejected
ground-
on what ground?
My lord, on the ground that, my lord, the rules prevailing as on the date of death of employee has to be considered, my lord. Without considering,
No.
the judge,
Apex court said, as on the date you take up the application for
Yes, madam.
consideration,
Right.
that rule should be followed.
Yes.
We held that way. There is that judgment.
That is not followed, madam.
along
Kindly
with
say,
Varale Saab. We have held that way. Not as on the date
yes,
of the death,
that was the
nor
reason.
as on the date you applied for compassionate appointment, but the date on which your application is taken up in hands for considering.
Yes, for
That
that,
date is relevant. ಅಂತ
for
hold
that
ಮಾಡಿದೆ.
reason only my application has been rejected, my lord.
On that ground only. What's
Yes,
correct
my lord.
ಇದೆ?
Kindly see, my lord, para number, my lord. Ink page number 29.
ಅಲ್ಲ ಆಯ್ತಲ್ಲ ಲಾ ಹೇಳಿದ್ರಿ ನಾವು ಲಾ ಹೇಳ್ಬಿಟ್ವಿ ಏನು ಅಂತ
ಅದೇ, my lord, for that
ಅಷ್ಟೇ.
reason only, ಅಷ್ಟೇ.
ಅಷ್ಟೇ ಬರ್ಕೊಳ್ಳಿ. The challenge is to the,
Court has referred to Supreme Court decisions. Your Lord.
we also referred and we said, as on the date when application is taken up, what was the law?
That is, of course, amendment was there.
Amendment was there.
Amendment.
Then ಆ ಬೆನಿಫಿಟ್ ಕೊಡ್ಬೇಕಾಗತ್ತ ನಾವು.
But the Supreme Court has said there is inconsistent view on that, Your Lord. That order itself, it is referred to, Your Lord. Taken it to page 21, Your Lord. Page 21. Therefore, it requires some consideration. Page 21 and 29 is relevant parallel. 29 page. I am also referring to full bench decision of the Honorable Apex Court reported in 2020 10 496 state. So also I am referring to another decision of Honorable State of Madhya Pradesh. The Honorable Apex has made it clear that any amendment to the rules are having prospective effect unless it is specifically mentioned in the said amendment that this amendment rules are having retrospective effect. Another
How,
aspect is made
one
clear.
second. One idea, when you trade one idea, you should give some time to the judges. At least I'm not that intelligent to grasp immediately. That's the reason. How that amendment was it by substitution or by insertion? Read the amendment. Yes, brother, read the amendment.
Amendment, I don't have.
If it is by substitution, then it goes to the first day of incorporation of the statute. That's how standard books on interpretation of statutes like Crawford.
Substitution of the next.
Hangagi, it goes back to the date of incorporation. Aspect ಮೇಲೆ ಏನ್ ಹೇಳಿ? If it is substitution, brother, if it is substitution, there are at least at least one dozen judgments which I have seen. Maybe my brother has seen more. All standard writers like Crawford, Sutherland, they have held that wherever the amendment is by way of substitution, what was there is substituted by amendment. And it dates back to the first day of incorporation of the statute, unless there is an indication to the contrary. That indication you show that.
Tomorrow, my lord.
ಏನು ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕಲ್ಲ ನೀವು ಏನು ತಯಾರಿ ಮಾಡಿ ಎಲ್ಲಿದೆ ಬುಕ್ಸ್ ವೇರ್ ಆರ್ ಯುವರ್
Tomorrow I will prepare, my lord. I will prepare and come.
ಎಲ್ಲ ಪ್ರಿಪೇರ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಹೆಂಗಿರ್ಬೇಕು ಲಾಯರ್ಸ್ ಐ ಟೆಲ್ ಯು ವೆರಿ ಹಂಬ್ಲಿ ಐ ಆಮ್ ಟೆಲಿಂಗ್ ಯು ವೆರಿ ಆಫನ್ ಐ ಟೆಲ್ ಯು ಹೆಂಗಿರ್ಬೇಕು ಲಾಯರ್ ಅಂದ್ರೆ ಎವ್ರಿಥಿಂಗ್ ಶುಡ್ ಬಿ ಆನ್ ಹಿಸ್ ಟಿಪ್ ಆಫ್ ದ ಟಂಗ್. ಇಂಥ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಹಿಂಗಾಯ್ತು, ಇಂಥ ಲಾ ಹಿಂಗಾಯ್ತು, ಫ್ರಾನ್ಸ್ ನಲ್ಲಿ ಹಿಂಗಿದೆ, ಜರ್ಮನಿಯಲ್ಲಿ, ಸ್ವಿಟ್ಜರ್ಲ್ಯಾಂಡ್, ಯುರೋಪ್ನಲ್ಲಿ ಈ ರೀತಿ ಇದೆ, ನಮ್ಮಲ್ಲಿ ಈ ರೀತಿ ಇದೆ. First judgment is this, latest judgment is this, law has taken the graphical movement this way. That is lawyering, not quoting some section and going away. ಯಾರು ರೆಸ್ಪೆಕ್ಟ್ ಕೊಡ್ತಾರೆ? ತಪ್ಪು ತಿಳ್ಕೊಬಾರ್ದು, ಹಿಂಗೆ ಹೇಳ್ತೀನಿ ಅಂತ. ಓದ್ಕೊಂಬರ್ಬೇಕು ರಿಗಾರ್ಡ್ಲೆಸ್ ಆಫ್ ಏಜ್, ರಿಗಾರ್ಡ್ಲೆಸ್ ಆಫ್ ಸ್ಟೇಜ್. ಓದ್ಕೊಂಬರ್ಬೇಕು, ನೋಟ್ಸ್ ಮಾಡ್ಕೋಬೇಕು, ನೆನ್ಪಿಟ್ಕೋಬೇಕು, ರಿಟ್ರೀವ್ ಮಾಡಬೇಕು. ಅದೆಲ್ಲ ಮಾಡಿದ್ರೆ ಲಾಯರಿಂಗ್. ಅದು 2 ಸೆಕ್ಷನ್ ಓದೋದು ಹೋಗ್ಬಿಡೋದು. ತಗೊಳ್ಳಿ, ಯಾರು ಕೇಳ್ತಾರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ. ದಟ್ ಈಸ್ ದ ರೀಸನ್ ಅದರ್ಸ್ ಕಮ್ ಫ್ರಮ್ ಔಟ್ಸೈಡ್ ಅಂಡ್ ಪೋಚ್ ಆಲ್ ಯುವರ್ ಬ್ರೀಫ್ಸ್. ವೇರ್ ಡು ಯು ಸ್ಟ್ಯಾಂಡ್? ಎಸ್, ನೋಡಿ.
Date may be given, date may be given, madam. Date may be given, madam.
Call it, next week ಹಾಕೊಳ್ಳಿ. Call next week at the request of learned AG. ಒಳ್ಳೊಳ್ಳೆ ಬುಕ್ಸ್ ನೋಡ್ಕೊಂಬರ್ಬೇಕು. Nothing attracts human mind than the novelty of idea. ಹಂಗಾಗಿ ವಿ ರಿಮೆಂಬರ್ ಅರಿಸ್ಟಾಟಲ್, ಸಾಕ್ರೆಟಿಸ್, ಪ್ಲೇಟೋ. ಯಾಕೆಂದ್ರೆ ಐಡಿಯಾಸ್ಗಿರುವಂಥ ಅಟ್ರಾಕ್ಷನ್ ಇದೆಯಲ್ಲ, ದಿಸ್ ವಾಟ್ ನೋಬಲ್ ನೆಪೋಲಿಯನ್ ಬೋನಾಪಾರ್ಟೆ ಸೇಸ್. Society remembers ideas and not the wars which I have fought. Therefore, they will remember my Napoleonic codes. 32 wars I have fought. Nobody will remember all those things after 200, 300 years, but they will remember me as the person who gave France the code of laws. A good book, read Emile Ludwig on Napoleon Bonaparte's life story, biography. Yes.
I am appearing for the petitioner, my lord. This matter pertains to appointment to the post of forest watcher, my lord.
Forest watchers.
Last week, your lordship has ordered notice in this matter.
ಏನಾಗಿದೆ? ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ನೋಟಿಸ್ ಮಾಡಿದೇವಾ?
Similar. There are 7 writ petitions.
Learned AGA is requested, issue notice. Learned AGA is requested to accept notice for
Respondent number
ಯಾರು? 1, 2, 3. All respondents.
all respondents.
Issue emergent notice to private respondents. Call this matter along with WP number.
WP number 10835, my lord.
Please ಬರ್ಕೊಡಿ, ಬರೋದನ್ನು ಸ್ಟಾಪ್ಲರ್ ಹಾಕಿ ಇದು ಮಾಡಿ ಸೈನ್ ಮಾಡಿ ಕೊಡಿ, ಚೆಕ್ಕದು. Yes.
Office objection is
overruled. Okay. Overruled.
The office objection is the production of.
Why you have come to Bengaluru?
But your lordship 10 years back asked me.
Yes, what is this?
Translated copies of office objection.
Translation dispensed it.
My lord, on merits, my lord, the only request that I have made before the tribunal was to consider my request for consideration of annexure A2 and A4 before the tribunal. High power committee and the head of the department has recommended our claim for promotion. Drivers ಇವರು 30 ವರ್ಷದಿಂದ ಮಾಡಕತ್ತಾರ, ಅವ್ರ promotions, that is the only request that I have made.
Lord, may I request, my lord. The petitioners are drivers. They are claiming promotion to the post of excise officer, my lord.
Excise officer.
Additional commissioner excise 2, my lord. Prior to 5th January 2002, my lord, there was avenue for that in earlier rules. Subsequent amendment that was removed. That was subsequently made like that, my lord. The avenue was for that promotion. The feeder cadre was that must have put in service not less than 5 years in the cadre of joint commissioner. That was the change in rule, my lord. Now The state cannot consider their promotion. Because of that reason, it was not considered.
ರೂಲ್ಸ್ ಅಮೆಂಡ್ ಆಗಿದೆ ಅಂತನಾ?
ಹೌದು sir.
ಯಾವ್ದದು ಪೇಜ್ ತೋರಿಸಿ.
May I request my lord page 34 my lord, first rule what was earlier was there.
34
ಹೌದು.
was the original
A1.
legal position.
ಹೌದು sir.
It provided for a promotion
ಹೌದು promotion.
from the feeder cadre ಏನದು?
Feeder cadre must have put in services not less than third row my lord, third row.
Which
Not less.
post? Which post?
My lord, this was the joint commissioner of excise my lord.
Feeder cadre.
Driver,
Driver.
stenographer.
Not extracted
And,
in the tribunal
FDM.
order at page 84.
Promotion from the cadre of sub-inspector of excise, first division ಅದ?
Driver, senior driver post in the
ಅದೆಲ್ಲಿದೆ?
sub-inspector excise.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
Uh,
34 ನಲ್ಲಿ. Brother, you asked us to read 34.
May- I
What is
beg your-
there in 34?
Lord, I beg your pardon,
not
my
there.
lord, it was, this was says that it is for the additional commissioner excise 11 enforcement inspection, my lord.
Page.
But sorry, page number 42.
No, you said
that is
us,
not-
you
that
told
is-
us to see.
Lord, beg your
Turn
pardon.
pages, na?
That is not relevant to
Ah.
this, my lord. Beg your
Which is that page?
pardon. Lord, ಅದರಲ್ಲಿ note ಅಂತ ಇದೆ 43 ಅಲ್ಲಿ ಸ್ವಾಮಿ.
43.
43 page note that is below that, my lord.
Notice, note below rule.
That note only, my lord, I may read, my lord. A person in the cadre of first division assistant or stenographer shall exercise an irrevocable option to time of consideration.
ಇವ್ರಿಗೆ ಹೆಂಗ್
promotion
ಅಪ್ಲೈ
to the
ಆಗ್ತದೆ?
cadre of-
ಡ್ರೈವರ್ಸ್ ಅಂತ ಹೇಳಿ. They are drivers. How note is applicable to them? ನೋಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಹಿಂಗ್ ಮಾಡಿರೋ. Which gives right of consideration for promotion?
Not annex A2,
A2, page number?
page number.
ತಮ್ಗೆ 43 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ಮೇ ರೀಡ್, ಮೈ ಲಾರ್ಡ್.
Last line.
ಹೌದು ಸ್ವಾಮಿ. ಅಂಡ್ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ 2% ಬೈ ಪ್ರಮೋಷನ್ ಫ್ರಮ್ ದಿ ಕೇಡರ್ ಆಫ್ ಸೀನಿಯರ್ ಡ್ರೈವರ್ ಅಂಡ್ ಇಫ್ ನೋ ಸೂಟೇಬಲ್ ಸೀನಿಯರ್ ಡ್ರೈವರ್ ಈಸ್ ಅವೈಲೇಬಲ್ ದೆನ್ ಫ್ರಮ್ ದಿ ಕೇಡರ್ ಆಫ್ ಡ್ರೈವರ್ಸ್. 44 ಗೆ ಬಂದು
ಪ್ಯಾರಾ ಏನದು?
ಸ್ವಾಮಿ ಇದು ಇಂಟರ್ನಲ್ ಪೇಜ್ 343 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಆದ್ಮೇಲೆ ಹೆಡ್ ಗಾರ್ಡ್ ಅಂತ ಬರ್ತದೆ.
Internal page 43 ನಾ?
44 ತಾವು ಬಂದ್ರೆ ಕಂಟಿನ್ಯೂವೇಷನ್ ಅದದ್ದು.
Head guards and.
44 ಗೆ top two lines.
Then from the cadre of guards ಆಯ್ತು. Drivers ಅದಲ್ಲಿ ಬರ್ತಾ ಇದೆ.
Top
Senior
two
drivers. And if no suitable senior driver is available, then from the cadre of drivers. This was a law as on which date?
Lord, this was law.
March 2002.
ಹೌದು ಸರ್. May I read para 7 of the tribunal order, my lord, that was extracted and it is.
One second. What the change of law?
My lord,
Sure,
5-3.
change of law. Where is the change of law?
Lord, this is the change one, this was deleted. Earlier one, I want to show that. Sorry, my lord, I beg your pardon. 39, page 39, column C, my lord. Page 39, column C.
39, column 3.
C, my lord, ಇದು A, B, C ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
A, B, C, you are right.
C, may I read, my lord?
Ah.
For promotion from the cadre of senior driver and driver must have put a service not less than 5 years in the cadre of senior driver or 10-year service in the cadre of driver and must have passed SSLC or equivalent examination and must satisfy physical standards specified or for direct recruitment. Correct.
ಈ ಲಾದಲ್ಲಿ ಏನಾರ ಬದಲಾವಣೆ ಆಗಿದೆಯಾ?
Lord, that was removed, my lord, by subsequent amendment.
ಯಾವ amendment?
ನಾನು ಹೀಗೆ ಓದ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. 44 ಪೇಜ್ ಅಲ್ಲಿ that was removed.
ಅಲ್ಲಿ ಇದೆಯಲ್ಲ.
ಹೌದು.
44. 44 ನಲ್ಲಿ ಇದೆಯಲ್ಲ ಬ್ರದರ್. From the Karnataka excise officers. 53% by recruitment, 5%, 40%. So guards, if no suitable guard is available, then from the cadre of guards and 2% by promotion from the cadre of drivers. 2% from the drivers ಕೊಡಬೇಕು ಅಂತ ರೂಲ್ ಇದೆಯಲ್ಲ.
ಹೌದು.
ಮತ್ತೆ ಯಾಕೆ ಕೊಡಲ್ಲ? ಅವ್ರು ನಿಮಗೆ 2% ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಏನು? rule says 2% should be from the cadre of drivers. And there are two recommendations we can give one. And he says, consider this. Tribunal says no. You know what is happening?
Lord, I will take notice and make a submission.
ಈ ಮತ್ತೇನು submission, brother? ಹಾಗೆ ಹೋಯ್ತು.
Lord,
ಬೇರೆ ಏನಾರ
request.
ಇದೆಯಾ?
Lord,
10 ತಿಂಗಳು
Lord,
ಅವತ್ತು ನಾಳೆ ನಾಡ್ದು ಇಟ್ಕೋತೀವಿ.
Oblige.
ಎಂತ ಕೇಶವಾನಂದ ಇಲ್ಲ ಏನು ಚಿಕ್ಕದು. Ladne DG is requested to accept notice for official, for respondents. All respondents.
All response.
Call this matter day after tomorrow.
Oblige.
ಏನಿಲ್ಲ ಅಷ್ಟೇ.
Great.
ಇನ್ನು ಇಂಥ ಪ್ರೇಯರು ಕೊಡಲ್ವಾ ಟ್ರೈಬ್ನಲ್?
Petitioner.
Yes, Umesh.
My lord, the petitioner is before tribunal only sought for mandamus to consider representation of another A3, my lord. Just I read my representation, my lord, kindly another A3, my lord, 31/3/2023, page number 30, my lord. My lord, I
What
read
is
just I read just 2 lines. B. Manjunath, executive engineer, retired of superannuation 30/5/2015. My last working place, office so-and-so, highway department project. With reference to the above, the letter cited under reference number 1, I have been sanctioned 6th stagnation increment till 1/7/2012. Further, my 7th and 8th increment have not been sanctioned. I am here to enclosing your details of so-and-so. Well, the petition is only sought for mandamus before tribunal. The tribunal is dismissed the application, madam, on the ground that limitation. Well, in this regard, this correspondence letter recent order page number 66 another F. ಇದರಲ್ಲಿ ಇನ್ನು ಸೆಕೆಂಡ್ ಎಫ್ ಪಾರ್ಟಿ ಅವ್ರಿಗೆ AG ಅವರಿಗೆ ಲೆಟರ್ ಬರೀತಾರೆ ಸರ್. 7th ಅಂತ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಇದನ್ನ ಇದ್ರ ಬಗ್ಗೆ ಡೀಟೇಲ್ ಕಳಿಸಿ ಅಂತ ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ. ಅನೇದರ್ F, my lord, page number 66, my lord, page number 60.
All right, all right. Please wait. ಏನು ಎಷ್ಟೊಂದು ಅವಸರದಲ್ಲಿ. Brother, Lord, can tribunal say, ನೀವು 3-4 ರಿಲೀಫ್ ಕೇಳಿದಿರಿ ಹಂಗಾಗಿ ಕೊಡಕ್ ಬರಲ್ಲ?
Lord, that is
representation. Consider representation.
Lord, may I request, my lord, for consideration of representation, that is a writ of mandamus, there should be a statutory remedy.
That's all we have been taught.
We should claim for that.
That's right.
And it
he
should
is
be
giving a representation. ಏನಂತ ಇದ್ದಾರೆ?
Oblige.
ನನಗೆ ಫಿಟ್ಮೆಂಟ್ ಕೊಡಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಕೊಡ್ತೇವಿ, ಕೊಡಲ್ಲ. ಇದಕ್ಕೂ ಇಂಥದನ್ನು ಡಿನೈ ಮಾಡ್ತದ ರಿಲೀಫ್ ಟ್ರೈಬ್ನಲ್?
Lord, one I request, my lord, in a tribunal that the representation should for consideration, he should file within a 6 month. If you want to challenge any order, then it is a 1 year.
1 year.
1 year.
1 year. Plus
For
6
challenging
months.
the order, my lord.
Correct.
For representation, it is a 6 month. Consideration for, if you want, then he would have given one more representation in reference to that, and it may be.
That he can do. But when you have not considered first representations, what hope we will have, citizen will have, that we will consider subsequent representations? We are a welfare state. Therefore, we keep on telling, we are not East India Company. We are a welfare state. ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡಿ ನೋಡಪ್ಪ ಇಂಥ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿಯಾ, ಇದರಲ್ಲಿ ನೀನು ಫುಲ್ ಡೌನ್ ಪೋರ್ಷನ್ ಆಫ್ ವಿಧಾನಸೌಧ ಅಂತ ಕೇಳಿ ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರಲ್ಲ, ರಿಜೆಕ್ಟೆಡ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಅದಕ್ಕೊಂದು ಅಪ್ಲಿಕೇಶನ್, ಹಿಂಗಾಗಿ ಎಲ್ಲ ನಂಬರ್ ಜಾಸ್ತಿ ಆಗ್ತದೆ. ಅದಾದ್ಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್. ಕನ್ಸಿಡರ್ ದೋಸ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ಬರ್ಕೊಳ್ಳಿ.
That may be in accordance with law.
According to law. ಬರ್ಕೊಳ್ಳಿ. A pensioner is knocking at the doors of writ court, grieving against State Administrative Tribunal's order dated 15/3/2024, whereby his application number 895 of 2024 has been negatived, principally on the ground that he had sought for plural remedies. Full stop. Learned counsel appearing for the petitioner submits, and we agree that whenever a representation is given airing the grievance, the same needs to be considered by the answering respondents in terms of mandate enacted in Article 350 of our Constitution. First stop. In a curtain of decisions, we have held that way. Full stop. This aspect of the matter having not been considered by the tribunal, counsel for the petitioner argues, there is legal infirmity in its order, which is liable to be voided. First, next part. Learned AGA on request appearing for the official respondents vehemently opposes the petition, contending that right to consideration has to be demonstrated before a direction is given for consideration. First, this submission is very attractive and it is elementary too. First off, but that could have been told to the citizen who made the representation by the authority to whom it was made. First off, this aspect having not been looked into by the tribunal, we cannot turn our blind eye to the grievance aired in the representations, more particularly when it is from a pensioner. First off, next one, in the above circumstances, this petition is disposed of, directing the respondents. Yav respondent?
Second respondent.
Second respondent.
Second.
To consider or cause to be considered the subject representations dated
Lord 31/3/21 and 31/3/21.
Void another A3 of
AC1.
another B.
Both dated 31/3/21. Both dated 31/3/2021, wherein some service grievance is aired. First off, time for compliance is 8 weeks. 8 weeks. First off, all contentions are kept open. Next paragraph. It is open to the answering respondent to solicit any information or documents from the side of petitioner as are required for due consideration of the subject representations. However, in that guise, delay shall not be brooked.
Request that the representation shall be considered in accordance with law.
Shall be considered
positive
in accordance with law. Okay. All contentions kept open. Within a period of it, and inform result of consideration to the petitioner within 8 weeks.
For another A question, Kate. Yes, Kate had to set aside another A question.
We have said that this consider. No?
Pay for the petitioner.
One sentence, he may be right. This petition is allowed in order of the impugned order of the tribunal is set at naught. A writ of mandamus issues to the second respondent to consider petitioner's representations dated so and so. And inform result of consideration to him within 8 weeks. In accordance with law.
Office objection is that I have to furnish a translated copy. That may not be necessary.
Translation dispensed. Requirement of translation. Yes.
Fact, petitioner is a village accountant, your lordship. A complaint is given against him to change the kata. He is not a person to change the kata, it is a tahsildar. That apart, a trap is alleged to have been laid against him and a criminal case was filed in CC number 12 of 2009. And the Sessions Court honorably acquits him.
Where is that?
Yes, sir.
Show the honorable acquitter.
85, your lordship.
80?
85 page.
Which paragraph? Which line? 95, 85.
118. Last para, your lordship. May I read, your lordship? The complaint had come to lodge a complaint against the accused. It is strange that he would not reveal the name of the accused to the investigating officer as the person who is demanding bribe further. As pointed out by me, there is a major discrepancy regarding the playing of the cassette in the presence of Panchayat Dars. It is doubtful whether tape recorder was played or not in the presence of Panchayat Dars. Admittedly, PWs 1 to 3 had not either met the accused or the complainant prior to the date of tape. It is not the case of prosecution that PW 1 to 3 were acquitted with the voice of accused and they were capable of identifying the same. The prosecution examination of PW 7 KL Rajappa, the revenue inspector who was working with the accused to prove that the voice in the cassette MO8 is the voice of the accused. PW 7, though state that a cassette of tape recorder was played and he was asked whether the voice in the said tape recorder is that of the accused, he stated that there was a lot of disturbance in the cassette and he told the local Ayukt of police that he cannot definitely say that the voice in the tape recorder is that of the accused. Not only that, he
But it's the
stated.
case of beyond all reasonable doubt, not honorable acquittal.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Correct, merit ಮೇಲೆ ಆಗ್ಬಿಟ್ರೆ ಆಗಲ್ಲ ಅದು. If it is a case, that's what we said in Rudrappa.
Yes, your lordship.
ಎಂತ ರುದ್ರಪ್ಪ ಅದು?
I got that, your lordship.
PV Rudrappa. PV Rudrappa versus state ನಲ್ಲಿ, we have laid down 5 or 6 postulates.
Yes, your lordship.
Only then it fits into honorable acquittal. Read para 5.
My submission to your lordship, I have got this decision of your lordship. My case comes within the parameters laid down by your lordship.
No,
That
it
is-
does- it
that
does
is
not.
for this reason, your lordship.
Read that decision, read the postulates. But I have written that judgment. I remember. Para 5 or 6 ಇದೆ ಅದು.
Para 7, your lordship.
Para 7, all right, read. ಕೊಡಿ, ನಮ್ಗೊಂದು ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ.
Page 7.
ರುದ್ರಪ್ಪ ಇದೆಯೇನು?
Yes, I got a copy, sir.
Honorable acquittal ಆಗಲ್ಲ. To say honorable, we have followed English judgment, Lord Atkins judgment perhaps.
Your lordship has referred, your lordship will kindly say.
Yes.
In fact, in my case, your lordship, where the incident has happened, there is no unanimity as far as the witnesses are concerned. Because 3 witnesses give a three different versions, your lordship.
Kindly come to page 13 of the ruling.
Yes, my lord.
Yes. These are the 5 postulates which we have given.
The accused is falsely prosecuted to seek a vengeance or some ulterior motive. That there is absolutely no evidence to implicate the accused in the proceeding.
That does not fit into, the benefit of doubt does not fit into that.
No. Your lordship will kindly say, why I submit that your lordship has laid on this test, my case fit into this is thus. Your lordship will kindly say, trap the 3 witnesses of the prosecution say it has taken in 3 different places. No, therefore, nobody has seen what has happened that your lordship.
Your
Therefore,
first statement, you said Tahsildar has to change. Read section 128 of the Land Revenue Act. Kodi.
Yes, sir.
Karnataka Land Revenue Act. Read that judgment. Kodi. Karnataka Land Revenue Act. Kodi. One 128 to 135.
Well, yes, sir.
136 is
Yes, sir.
appeal.
That
revision.
chapter deals only with the change.
That one only.
Yes, sir.
Read that.
Acquisition of rights to be reported.
Yes.
Any person.
How acquisition of right happened in this
Mother
case?
has died, according to him, his mother has died, therefore the kata is.
Inheritance kata.
Yes.
It is inheritance
Yes.
kata, IHL.
Yes.
All inheritance kata, he has to build up the file, na? Tahsildar, Talati has to build up the file. This is what Justice Swami has said in 1988, ILR 88 Karnataka. Just read and come. That's how it has been held by Honorable Justice K.A. Swami. Said, the Tahsildar will ordinarily do, but the file has to be built by the village accountant himself.
Then it will go to the revenue inspector.
Then it goes to revenue. He has given the whole scheme itself. Just read that judgment and come back. It goes to land revenue law. Call week after next. Yenilla. And Talati is a section of village accountants.
Yes.
They play havoc with the lives of farmers.
I do agree, but that
There
may
is such a
not,
judgment. There is such a judgment by Sabha.
that I also agree,
Senior
but
Sabha.
it may not be in this case, your lordship. That is because he says I have never demanded, because the most important is where the traps take place. The three places are served by 3 witnesses. Therefore, your lordship.
Disciplinary inquiry has taken place. Disciplinary inquiry has taken place. Yes.
Disciplinary inquiry is held, and in this case, your lordship will kindly say what has happened in this case.
Not your money. Judgment not your money.
Very well.
Because in your first statement appears to be wrong to me. It appears to be wrong to me because of the set, Mr. M.R. Achar's book and Mr. A.G. Shivanna's books, both they have dealt with this. Both the authors have dealt with. Both are dealt, we can quote the
Village
points.
accountant has to send a report, that I agree, Your Lordship.
That's all. Both are dead.
Yes, sir.
Therefore, their write-up can be quoted as an authority of law in
Yes,
English
I
law.
agree, ma'am.
Unless
But
the
even-
author is dead, you cannot quote.
Allah, he does not say, the complaint do not say that I have not sent anything.
Read and come.
He said, I have not made the kata.
First proposition, you have not convinced us. And we are quoting two books in support of our version. Yes. And both are dead. Therefore, their works have become authoritative work now.
Yes.
Yes. We have objection? Don't have. Because petitioner has moved a memo dated so and so seeking leave of the court to withdraw the petition. First off, memo reads as under. Next one. There is no objection from the other side. Nimgu service agidena?
Appearing for the petitioner in this, my lords.
All right. In the above circumstances, petition is disposed of as having been withdrawn in terms of memo. Next.
Request for a passover.
For the response.
Passover.
Senior is on his legs in the other court.
All right. Passover.
Please.
That given, directed us to call the
Correct.
officer and then.
Did you do that exercise?
We did that exercise, my lord. She had given indications that she will consider going to the place which is transferred, but anything else, I don't know whether.
Mr.
Please,
Vivek,
my lord,
comment, say something.
2:30
na?
minutes.
2:30.
2:30, please.
Comment 2:30. Yes, next. Yes.
Petitioner by me.
Dispensed with. Yes.
My lord, the objections for office objection is that.
Dispensed with. What is the matter?
Your Lordship will kindly see, the matter is very peculiar in this case, Your Lordship. The KADB, Your Lordship, notified for acquisition for several hundreds of 492 acres of land in Herohalli for the Herohalli third place on 25/10/2006. Preliminary notification.
2006.
Yes, Your Lord.
This is under KIDB Act.
Yes, Your Lord.
Section 28 notification.
28(1) notification. Then, Your Lordship, 28(3) was issued on 29/10/2010.
Final notification.
Yes, 28(3) notification.
Date.
Then the Your Lordship will kindly.
Date.
Date 29/10/2010, Your Lord.
Date. 3 no 4 other.
29/10/2010, Your Lord.
That's all right. Under which section?
28(3), Your Lordship.
Not 28(4).
28(4), I'm sorry, 28(3) is the inquiry.
That's what. 28(4) it is.
Price advising committee fixed the price of rupees 38 lakhs per acre.
$38 lakh.
Yes, sir. On that basis, Your Lordship, all the award was passed and the owners have to be issued a check. I go to the KADB on 22/12/2012, Your Lordship.
This advisory committee recommendation is dated
10/8/2012, Your Lordship.
Yes.
I go as a special and exception officer to the KADB on 22/12/2012.
22/12.
Yes, Your Lordship.
More than 4 months.
Yes. By that time, Your Lordship, everything was ready. I issued a check to the owners, Your Lordship.
When you issued?
The records are not available even KADB about that, Your Lordship.
All right. What is the date of the check?
Even that is not available. Why I am making this submission, Your Lordship? Background I am giving is this, Your Lordship. After everything happened, some persons gives a complaint that the owners of this particular land, that survey numbers 198/5, 199, 210/3, 210/7, 210/11.
XYZ lands.
That they have taken the award twice, your lordship. Then, your lordship, I scrutinize and open all the records. Then I have come to know that these lands have been notified and acquired by Water Resources Committee on 11/12/1980.
They were already acquired.
Already. Immediately, your
How
lordship,
you came to know of that?
after filing a complaint against them, when
When the
the
complaint was filed?
the landlords admit that I have given a
We
complaint.
want to know when the complaint was filed.
I'm sorry, my lord, date of complaint, the owners accept that because somebody gives a complaint, all these proceedings have been initiated against us. Then immediately after, my lord, I file a original suit, and original suit is decreed, and they have come with an RFA before this court, and here this court has directed them to deposit 50% of the money, and all that I have done. And your lordship will
When you
find,
filed, when action was sought to be taken, date, when you filed the OS, date.
immediately, your lordship.
No, that immediately is a very elastic word in English
Yes, yes,
dictionary.
true, your lord. Annexed A6, your lordship. Page 122.
Complaint date you have not given, check date you have not given.
27/6/2014
Is?
date of filing the original suit, your lord.
No, that, you are not answering our point.
I got
Go
it,
against you. One is you are not giving the complaint date. You are not giving the check date. Anyway, all right.
After obtaining a permission from the board, I filed the suit, and the suit is decreed against the defendants, your lord. And
How that comes to your aid? What is the charge against you?
the ನನ್ನ ಮೇಲೆ ಚಾರ್ಜ್ 2 ಸತಿ ದುಡ್ಡು ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ. I was not there at all. Your lordship.
No, you should have, you are the person who will make the disperse the money.
Yes.
You should have verified
Yes,
whether this land is already acquired or how you came to know of all these things. That exercise you should have done
No,
before
my lord.
giving public fund to a private person.
My lord, by the time I had taken a charge, all these things has opened.
Payment, who made the payment?
The payment, except giving a check, all the previous things have been done by the time I took charge as a special land acquisition officer by the previous officers. Your
Up to what all the previous officer had done?
The
What all the previous officer had?
award has been passed by the time I came. Award is not passed by me. Award has been passed, and award amount has to be paid.
No, when one has to ascertain whether land is private land, government land,
Yes, your lord.
or it's already acquired,
Yes.
when, at what stage it should be
My lord,
verified?
it is to be verified under 2 stages. When the final notification is issued, final notification will be issued by looking into the RTC. If the RTC is something else is there that is already acquired, then the acquiring authority cannot issue that preliminary notification. Your 28(1) cannot be issued. Then your lordship.
28 is a preliminary notification. At that stage, that verification. At what stage verification happens, brother? What VG Ramachandran says in law of land acquisition and compensation? At what stage verification of documents has to happen? What is the protocol in KIDB? How things are accomplished? You have to say. How things are accomplished,
My lord,
at what stage?
Your lordship will kindly say, as far as my knowledge goes, your lordship, notification will be issued, preliminary notification by the land acquisition officer by getting the RTC. One RTC name and everything is there, survey number will be there, preliminary notification will be issued, your lordship.
Correct.
Then objections are called for, and final notification is issued. After issuing a final notification, award will be passed, your lord. At the time of passing of the award, if somebody else comes files an objection, then the reference will be made to under section 30 and 31 to the civil court, your lord.
Now, how you came to know? This land was already acquired by the state. BWSSB.
They admit themselves when the original suit was filed against them.
No, you took a decision to file the suit.
Yes, Your Lordship.
When?
Your Lordship will kindly, because somebody comes and gives a complaint to the KADB office that the landowners have already taken the money for previous acquisition, then Your Lordship, I filed a FIR, then initiated a original suit. I have taken steps to recover the money and suit is decreed.
You have said that. No, already twice you have said.
Therefore, Your Lordship will kindly see. And
What the inquiry officer says?
and another important thing, Your Lordship.
But regarding check, Your Lordship. the date is-
PW3 inquiry was held on Telvaraju, one of this officer of the KADB. Your Lordship. I just read about 3 sentences from his report, then it may be satisfied, Your Lordship.
Page number?
Page. Annexed page.
Regarding date of check, Your Lordship, 315. 2/3/2013, drawn on Corporation Bank, Rupatunga Road, Bangalore, 56001.
No, what he says is, once award is passed by my predecessor, the rights become concrete. This is how VG Ramachandran says. Rights become concrete once award is accepted by the landowner. Award is an offer from the side of acquiring body. Once it is accepted, I do not have a role to play in our contention. At what stage verification of ownership, etc., has to be done? How that should be done? Other mail protocol, what are the rulings on that? Doubt banbutre, at any stage it has to be done is one thing. That's an extreme example. Ordinarily.
I request.
Yes.
The identification of lands will be done by the SLO law.
Correct.
That time they will know that these are the extent of land which is in their whom name it was there. They will rectify it on the title deed, my lord. On that basis, they will issue the notice.
When they take actual possession of the property.
Notification ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆನೆ they will look into
first
the
level.
the area of extent.
It is the first level. Second level, at the time of passing the award, comparative valuation ಎಲ್ಲ ನೋಡ್ಬೇಕು ತಾನೆ. ಅವಾಗ ಸುತ್ತಮುತ್ತದ ಎಲ್ಲದಕ್ಕೂ ನೀವು ನೋಡ್ಕೋಬೇಕು ತಾನೆ.
I think they will bifurcate into the land and the extent of land which is there, they will make a table, my lord. According to, at that point of time, if whom name it was there, they will release the compensation amount, they will issue notice. That was the procedure, my lord.
ನೀವು ಅವಾರ್ಡ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ we are just thinking, we may lay down that particular law also. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ಪಬ್ಲಿಕ್ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು. ಯಾರಾದ್ರೂ ಅದರ್ವೈಸ್ ಸಿ ದಟ್ಸ್ ಹೌ ಇಟ್ ಕೇಮ್ ಟು ಲೈಟ್. ಒಂದು ಪಬ್ಲಿಕ್ ನೋಟಿಸ್ ಕೊಟ್ಟು ಇಂಥವ್ರಿಗೆ ಅವಾರ್ಡ್ ಆಗಿದೆ, ಈ ರೀತಿ ಅಮೌಂಟ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ, ಇದ್ರ ಬಗ್ಗೆ ನೀವು ಯಾರಾದ್ರೂ ಪಬ್ಲಿಕ್ನವ್ರು ಏನಾರ ಹೇಳೋದಿದ್ರೆ ಹೇಳಿ ಅಂತ. ಅವಾಗ ಒಂದು 10,000 ಜನ ಹಾಕ್ತಾರೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ಕೊಡ್ಬೇಡ್ರಿ ಇವರಿಗೆ ಅಂತ. ಅಲ್ಲಿಂದ ನೀವು ವೆರಿಫೈ ಮಾಡ್ಕೋಬೇಕು. ಈಗ ನೋಡಿ ಈ ರೀತಿ ಬಂದಿದೆ ಈಗ.
Certain cases where my lord the dispute between two parties.
Now we are asking one more question. When BWSSB acquired the land, why that was not reflected in the revenue records? Revenue records nalli avana hesarannu delete ಮಾಡಿ wide acquisition so and so ಅಂತ ಬರೆದು ಹಾಕಿಬಿಟ್ಟಿದ್ರೆ ಇದೆಲ್ಲ ಮಿಸ್ಚೀಫ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ. Why no action is taken against the concerned revenue official? What he says, ನನ್ನ ಟೈಮಿಗೆ ಬರೋ ಅಷ್ಟೊತ್ತಿಗೆ ಇದೆಲ್ಲ ಅಷ್ಟು ಅದಾದ್ಮೇಲೆ ರಿಕವರ್ ಮಾಡಿದೆ.
ಆದ್ಮೇಲೆ ನೀವು ಮತ್ತೆ ಎನ್ಕ್ವೈರಿ ಏನ್ ಮಾಡಬೇಕು?
What inquiry he can do once award is
ಅಲ್ಲ, verification of that amount, the check is issued, your lordship may kindly see. ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಚೆಕ್ ಅದು ಒಂದ್ ವರ್ಷ ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಚೆಕ್ನ. 2/3/2013 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್. ಅದು ಯಾವಾಗ ಆಫ್ಟರ್ ಅವಾರ್ಡ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
So,
how can he withhold money? If you withhold money, we say right to fundamental property is constitutional right. Why you have not given anteve? He has given that. Where inquiry? What is the protocol for the inquiry? Award ಮಾಡಿದವ್ರ ಮೇಲೆ ತೊಗೊಂಡಿರೋ action. He only complied with the award. And what action you have taken against the revenue official who left, who continued the entries? In the name of the erstwhile owner. ಇವ್ರ ಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಏನಾಯ್ತು?
ಅಲ್ಲ, ಬೇರೆಯವ್ರ ಮೇಲೇನು ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
ಆ?
ಇದೆ ಅನುಬಂಧ
ಯಾವ
2 ಅಲ್ಲಿ ಎಲ್ಲರ ಮೇಲೇನು ತಗೊಂಡಿದ್ದಾರೆ.
ಏನ್ ತೊಗೊಂಡಾರ?
ಅಲ್ಲ, ಈ ಕೆಂಪೇಗೌಡ ಕೆಂಪೇಗೌಡ ಹೆಬ್ಬಿ ಹರೋಹಳ್ಳಿ ಗ್ರಾಮ ಕನಕಪುರ ತಾಲೂಕು ಭೂ ಪರಿಹಾರ ಪಾವತಿಯಾದ ನಂತರ ಬನ್ನಿಕುಪ್ಪೆ ಕೆರೆ ನಾಲೆಗೆ ಬೆಳಕಿಗೆ ಬಂದಿದ್ದರಿಂದ ಬೆಂಗಳೂರಿನ ಹಲಸೂರು ಗೇಟ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದೂರು ಸಲ್ಲಿಸರಂತೆ
ಅದು ಬಿಡಿ, ನಾವು we are asking a question
ಮಾಡಿದ್ದಾರೆ.
to you.
ಪ್ಲೀಸ್.
ಇದೆಲ್ಲ ಪ್ರಶ್ನೆ ಹೇಳೋದು ಯಾವಾಗ ಅಂದ್ರೆ, therefore one old judgment of our high court says, ಗೋವಿಂದ್ ಭಟ್ರು ಅಥವಾ ಪೈ ನಾರಾಯಣ್ ಪೈ ಅವ್ರದ್ದಿರ್ಬೇಕದು, lot of mischief is played by the talatis and village officers ಅಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ರಿಪೋರ್ಟೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್. ಅವರು ಎಕ್ವಿಜಿಷನ್ ಆದ್ಮೇಲೆ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ ರಿಫ್ಲೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಈ ರೀತಿ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ವೇರ್ ಇಸ್ ದಿ ಕ್ವಶನ್ ಆಫ್ acquired land? We acquire private land subject to some exceptions, ಕೋರ್ಟ್ ಖರಾಬ್ ಇಂಥದ್ದಲ್ಲಿ ಏನೋ ಎಕ್ಸೆಪ್ಷನ್ಸ್ ಇದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಆಲ್ರೈಟ್, ಬಿ ಖರಾಬ್. ಬಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ acquired land, how can there be second acquisition? All this mischief has happened because entries in the revenue records were not updated pursuant to earlier acquisition. What action you have taken against them now? ಅವನೇನ್ ಮಾಡ್ತಾನೆ, ಅವಾರ್ಡ್ ಇದೆ ಆ ಪ್ರಕಾರ ಹಿಂದಿಯವರೆಲ್ಲ ಮಾಡಿಟ್ಟಾರೆ, ನಮ್ ಚೆಕ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಳಪ್ಪ ಚೆಕ್ ಅಂತ ಅನ್ಕೊಂಡು ಕೊಟ್ಟ ಅವನು. What action you have taken against the revenue official who did not update entries?
ಅದು ವೆರಿಫೈ ಮಾಡಿ.
ಅವ್ರದ್ದು ರಿಟೈರ್ ಆಗಿದ್ರೆ ಅವ್ರದ್ದೆಲ್ಲ ಪೆನ್ಷನ್ ಕಟ್ ಮಾಡ್ಬೇಕು,
ಐ ವಿಲ್ ವೆರಿಫೈ.
ಅವಾಗ ಅವೇರ್ನೆಸ್ ಬರ್ತದೆ. ಇಶ್ಯೂ ನೋಟಿಸ್, AG is requested to accept notice for the respondents. ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಹೇಳ್ಬೇಕು ನಾವು,
Please,
ಕೈಯಲ್ಲೇ
please,
ಡಿಸೈಡ್
ಪ್ಲೀಸ್
ಆಗ್ಬೇಕು,
ಲಾರ್ಡ್.
ಅದರ್ವೈಸ್ ಇಲ್ಲಿ ಇಟ್ ಎಸ್ಕೇಪ್. ಅದನ್ನ ಹೇಳ್ಬೇಕು ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ.
ಪ್ಲೀಸ್ ಲಾರ್ಡ್.
The AGA is directed to make a statement on the next date of hearing as to why the entries in respect of PWSSB acquisition were not made in the revenue records, which eventually resulted into duplication of acquisition of acquired land. Okay, next date, a copy of this order to be shared, the learned AGA. Yes. And he has done suit ಹಾಕೊಂಡಾನೆ, ಆರ್ಡರ್ ಮಾಡ್ಕೊಂಡು ಡಿಗ್ರಿ ಆಗಿದೆ, ಅಪೀಲರ್ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ. What efforts he has generally appears to be something has been done actually. But let us see, it's first time. All right.
Lordship directed
Yes.
to comply the order dated 9/8/2024. But they complied it on 27/11/2024.
File along with memo, your lordship, but it is passed.
Filed it. They have complained.
Date of eligibility. My lord, now they issued an order promoting me to the post of Assistant Executive Engineer. Earlier I was working. Earlier, my lord, I have been promoted on 3/1/2024 with effect from 17/6/2021. That date is not given. The reason is this court has passed an order not only to the post of AEA, but to the post of Executive Engineer. Now they will have to consider, my lord, to the post of Executive Engineer. Now the 3 years experience will come in the way if 27/11/2024 is to be taken into consideration. I was eligible on 17/6/2000, that date has to be corrected. Then they will have to comply the order dated 9/8/2020. In fact, I filed an application to correct the date. Page 11, my lord, they say, this court,
ಯಾವ ಡೇಟ್ ನಿಂದ?
let them verify, my lord.
ಮತ್ತೆ ಅದು ಕೊಡ್ಬೇಕು. ಅದ್ರ ಇಂಥ ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ತಾರೆ ಮತ್ತೆ.
Application for modification is not application for modification of order dated 9/8.
ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು.
This order is passed by the coordinate bench, my lords, and the application sought is to modify the order dated 27.
No. That is a different issue. That date can be corrected in view of this order.
In fact, my order is passed by the court on number 3, my lord. They have produced it along with the IA only, my lord, page number 9.
ಹೋಟೆಲ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಹಿಯರಿಂಗ್ ಎಷ್ಟೊತ್ತಂಗೆ ಬಾಳತ್ತಾಗಿತ್ತಾ?
ಆಗಿತ್ತು. ಆದ್ಮೇಲೆ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್.
ಅಲ್ಲಿಗೆ ಕಳಿಸ್ಬಿಟ್ರೆ ಆಯ್ತು. ಹಂಗಾರೆ
ಇಲ್ಲ ಬೇಡ, one submission. My promotion, my lord, on 3/1/2024. With effect from 17/6/2021.
Finally,
Now,
ಅಲ್ಲ ಫೈನಲಿ ಡಿಸೈಡ್ ಮಾಡೋಣ.
ಇಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್ ಇಲ್ಲೇ ಮಾಡ್ತಾರೆ.
Application is not served.
ಅವ್ರಿಗೆ ಒಂದು ಯಾವ್ದೋ ಅಪ್ಲಿಕೇಶನ್
ಸರ್ವ್ ಮಾಡಿದೀವಿ ನೆನ್ನೆ.
ಅವ್ರಿಗೆ ಒಂದು ಕೊಡಿ, ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ, ಅದೇನೋ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಮಾಡ್ಕೊಬಂದ್ರೆ ಮುಗಿದು ಹೋಯ್ತಲ್ಲ. ಆ ಅಪ್ಲಿಕೇಶನ್ ಪ್ರಕಾರ ಒಂದೇನೋ ಒಂದು ಡಿಸಿಷನ್ ತೊಗೊಳ್ರಿ.
Malad, the short question, malad, is only this.
ಅಲ್ಲ ಅವ್ರು ಮಾಡ್ತೀವಿ,
ಇಲ್ಲ ಓನ್ಲಿ
ಒನ್ಸ್ ಅಡ್ರೆಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಅವರು.
ಇಲ್ಲ ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಹೇಳ್ತೀನಿ. Seniority is different from suitability. Now, as per the seniority, they say I have given an option belatedly, not within the time. Therefore, I will go to the bottom of the list. That is one aspect. If I go to the bottom of the list, there are only 33 executive engineers and there are only 29. Even if I go to bottom, I
will get the post.
29. There are number of years. Now, what the apex court has said, if I am eligible, if I have got an experience, the suitability cannot be denied on the ground of belated option. There is a direct, therefore, this court directed not only to the post of AEE, but also to the post of executive. It doesn't take even 5-10 minutes.
ಇದೇನು ಬೇರೆ ಇಂಟ್ರಿ ಮಾಡರ್ ಇದನ್ನ ಇದೇ ರಿಲೀಫ್?
It's the interim order only.
ಇಂಟ್ರಿ ಮಾಡರ್ ಅಷ್ಟೇ.
Yes, kindly, the application which my lord senior friend.
Your lordship, my learned friend government advocate will serve a copy. Will ask me have it on Monday. This is the only short point.
ನೋಡೋಣ, ಏನೋ ಒಂದು ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes.
ಸ್ವಲ್ಪ ಇಟ್ ಟೇಕ್ಸ್ ಟೈಮ್. ಒಂದು ನೋಡ್ರಿ, ಒಂದು 2 weeks ನಲ್ಲಿ ಅದ್ರ ಮೇಲೆ ಡಿಸಿಷನ್ ತಗೋಬೇಕು. ಆ ಡೇಟ್ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಮಸ್ಯೆ ಆಗಿದೆ ಅನ್ನೋದು ಅವ್ರ ಕಂಟೆನ್ಷನ್.
AAE seniority list is just to be finalized. It is not yet finalized.
Not
Until
yet
and
It is
unless
a different matter.
Until and unless
ಈ
not-
date
It is not finalized. How can
Seniority is
be a
finalized.
reversion?
ಅಲ್ಲ ಬ್ರದರ್, ಈ ಡೇಟ್ ಅನ್ನು ಕರೆಕ್ಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಆ ಪ್ರಕಾರ ಎಲ್ಲ ಫೈನಲೈಸ್ ಆಗ್ತದೆ.
Correct,
ಇಲ್ಲ
correct.
ಹಂಗೆ ಉಳಿಯುತ್ತದು ಅನ್ನೋದು ಅವರ ಅಪ್ರೇಕ್ಷೆ.
ಹೌದು.
ಆ ಡೇಟ್ ಕೊಡಿ ನೀವು. ವಿತ್ ಇಫೆಕ್ಟ್ ಫ್ರಮ್ ವಿಚ್ ಡೇಟ್ ಯು ಹ್ಯಾವ್ ಪ್ರಮೋಟೆಡ್ ಇನ್. Learned senior advocate appearing for the petitioner submits, and government advocate also agrees that in terms of our order dated 4/11/2024, reflected in the subsequent order dated 27/11/2024, comma, promotion has been accorded to the petitioner to the post of executive
Assistant
executive engineer.
engineer.
Why the order dated? Why the
27.
government order dated? Huh?
27/11/2024.
24. Similar. Mr. Lakshmi Narayana points out that the said promotion order does not reflect the date with effect from promotion is accorded, and unless that is done, to have right ranking in the seniority list will be difficult, and therefore an application is moved seeking a direction in that regard. First up, learned government advocate in all having opposed the application now agrees to instruct his clients to look into the application and come out with result on the next date of.
My lord, the date of eligibility has been assigned to me by virtue of government order.
That's what, they will
Only
take a
one.
decision. Which date you will take a decision on that application? All right, call this matter one date ಕೊಡಿ after 2 weeks.
ಇಲ್ಲ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ನವೆಂಬರ್ ಅಲ್ಲಿ ಅದು ತಾವ್ ಹೇಳಿದ ಮೇಲೆ ಮಾಡುದು. ಇವತ್ತಿಂದ ಅಂದ್ಕೊಟ್ರೆ ನಾನು ಎಲಿಜಿಬಿಲಿಟಿ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಅರ್ಲಿಯರ್
ಕೊಟ್ಬಿಟ್ಟು
ಗವರ್ಮೆಂಟ್
ಹೇಳಿ.
ಅಸೈನ್ ಮೀ ಫ್ರಮ್ 2000.
ಸಿಂಪಲ್ ಇದಾವೆ, ಇದಕ್ಕೆಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಟೈಮ್.
ಅದೊಂದು ಕೊಟ್ಬಿಟ್ರೆ
ಅವರು ಕಲಿಬಾರ್ದು, ನೀವು ಕಲಿಬಾರ್ದು.
ರಿಟ್ ವಿಲ್ ನಾಟ್ ಸರ್ವೈವ್. ಅದೊಂದು ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ರೆ
ಹಾ, ಅದ್ರ ಮೇಲೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್, ಅದ್ರ ಮೇಲೆ ಒಂದು ಅರ್ಧ ದಿವಸ ಆರ್ಗ್ಯುಮೆಂಟು ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಮುಂದೆ ಉಳಿದವರಿಗೆ ವಿ ಹ್ಯಾವ್ ಟು ರೇಷನ್ ಜಸ್ಟಿಸ್. ಇದು ಒಂದೇ ಕೇಸಾ?
Lord, if that earlier data was eligibility is
Next.
given, writ will not survive.
The
That's
order of the earlier bench, my lord, is, my lord, not to disturb the respondent without disturbing the respondent.
Yes, yes. Even now I will stand by.
after 2 weeks, next.
This is a medical officer's transfer matter, my lords, heard, my lords, last week.
Correct.
Lords, I had made a submission, my lords, to the final list. If they have any grievances, let them point out that, my lords, we will work it out. My lords, they have given us a list, my lords, and we are working it out, my lords. In the meantime, my lords, the issue was with regard to the Department of Medical Education, which are autonomous institution, about those things. There is one other order, my lords, we have suffered, where the state has filed a writ appeal in respect of, that was in respect of nursing staff, where they are actually deputation post, but salaries are being paid. So some persons were claiming that we have a right to be absorbed. So that issue we are sorting it out, my lords. So it might take, my lords, another 2 or 3 days time. In the meantime, there is one urgency, my lords, I have informed them. My lords, there are around 47 doctors who are waiting for posting.
47 doctors.
47 medical officers who are waiting for posting.
Okay.
In terms of the act, my lords, I have to do only counseling, my lords, before I can give posting. So that, my lords, they cannot have an objection. I have informed them also. In case, my lords, give us leave, my lords, to, because they are just waiting for posting, my lords, and there are vacant posts also. I may be the state may be permitted, my lords, to complete the counseling only for those persons who are waiting for posting. We will respond to this, my lords.
Those who are waiting for posting, you will conduct counseling.
Conduct counseling, my lords, so that
What the additional advocate general informed me is that these 47 will be adjusted towards the critical vacancies.
Critical
Please,
vacancies.
Yes.
first
Only
critical
critical vacancies.
Please.
Notes, I said that then there is no difficulty. 47 can be accommodated as against the critical vacancies. Notes, since the additional advocate general has assured me, notes, that this list is being worked out, I don't want to go beyond it.
That's what.
Please.
Learned additional advocate general appearing for the official respondent submits, and learned senior advocate appearing for the petitioners does not much object that there are 47 doctors in the waiting for posting, and therefore critical counseling.
No, counseling.
Vacancies, I mean, not
Critical
counseling.
vacancies.
Yes, counseling for the critical vacancies.
And therefore, the counseling for the subject critical vacancies can be undertaken.
Please.
First off, we also agree with
Please.
First off, this to be done within what period?
Lords, we have to do it immediately, lords, within 2 or 3 days.
This should be accomplished on a war footing, since public interest will be disserved if doctors are kept waiting indefinitely. First off,
Please
call this matter when?
Lords, Friday or Monday. Lords.
Next week.
Monday, my lords.
Monday.
If they, my lords, if they work it out, my lords, they lots.
If they work it out, my lords, it's a short matter, my lords.
10th we have posted some matter, na? 17th. All right.
Lords, if we work it out, my lords, it might be a 5-minute matter, my lords.
It is open to the parties to move the court if the task is accomplished.
Grateful.
For
Otherwise,
getting the matter posted for early consideration.
Please, grateful.
Entry management to continue till then, subject to the modification. Subject to your lords' modification, entry management to continue.
Interim order, subject to what is stated above, shall continue.
Lords.
Okay.
Grateful.
It in Aitala. Yes, Jayant.
My lords, kindly, for the petitioner, please, my lords. The instant writ petition, my lords, is questioning the order of the Honorable Single Judge, my lords. Dismissing a writ petition questioning the order of penalty of compulsory retirement, my lords, imposed on the petitioner, please, my lords.
What was the charge?
My lords, charges were, my lords, regarding certain irregularities in sanctioning of certain loans, my lords.
Loans.
Please. There is no.
What was the bank manager, you know?
My lords, the petitioner, my lords, was assistant general manager, please, my lords.
AGM.
AGM, please, my lords.
Okay.
One of the principal contentions raised was the
Who
inquiry
appears for the admission?
notice is yet to be issued, my lords. The 2 witnesses were inquired, were taken as witnesses for the management, please, my lords. The principal evidence was led by one Mr. Anand Rao, who was the investigation officer, my lords. His entire evidence is based on his investigation report.
Iqbal was examined as how?
He was not examined at all.
He was not examined.
He was not examined. Mr. Anand Rao, who was examined, was the investigation officer. His report was not placed on record. His entire evidence is based on his investigation, my lords.
MW1.
Please. The Honorable Single Judge proceeds on the basis that the findings are not based on the investigation report. Therefore, that need not have been given or furnished to the petitioner. The very fact that he was the investigation officer and he could stand on his foot only because of that investigation. He had no other capacity to tender evidence in any other capacity. Therefore, denial of that investigation report, my lords, has prejudiced my entire case, was my principal contention, my lords. The Honorable Single Judge proceeds that no prejudice has been caused by denial of the investigation report.
ಏನ್ prejudice ಆಗಿದೆ?
The very evidence, my lords, of the MW1 was based on his investigation, my lords. He had no personal knowledge of the transactions. So therefore, everything that he came and deposed before the inquiry, my lords, was based on the investigation. So now by denying that investigation report to me, my lords, I have been denied a very important aspect to cross-examine him on that report.
Did you ask for the report?
I have asked, my lords, as at annexure K, please, my lords. Page 145, even before the inquiry commenced. That was denied, saying that it is an internal communication. That also has been recorded by the Honorable Single Judge. That
No,
aspect
the
has been
single judge
noticed.
says
Please.
that you are not put to prejudice by non-supply anta.
My contention is, my lords, there are two kinds of prejudice, my lords. When a matter goes to the very root of the matter, such as violation of principles of natural justice, then the prejudice is apparent and evident, my lords. There is no, I don't have to prove it separately.
No, no.
In
We have moved, earlier we was the very fact that principles of natural justice have been violated.
Please.
Per se is sufficient for grant of relief.
Please.
But now from that we have moved further. There should be violation of principles of natural justice.
Please.
And demonstrability of prejudice thereby.
There, my lords, demonstration of prejudice, my lords, would be apparent in cases where I am denied a fair opportunity of inquiry, please, my lords. In this case, my lords, the very witness who was deposed, my lords are aware, my lords, in the case of Bareilly Electricals, where they said mere furnishing of document is not enough. A competent person has to be brought in to speak of those documents. Similarly here, when Mr. Anandra, who is the MW1, is on as witness, he is deposing based on his investigation. And I don't have the benefit of that report based on which he is deposing. Therefore, my lords, the prejudice is apparent on the face of it.
But what were the questions you had put to Anandram? Only one question you had put perhaps.
No, my lords, I had put
Yes,
several.
because there is a judge, Pandit Saab says that.
No, my
Only
lords,
one question.
there were several questions put, but because I did not have the benefit of the investigation report, my lords, I could not have a fair inquiry, please, my lords. And violation of or non-grant of a fair inquiry goes to the root of the matter, which is an absolute prejudice in the whole aspect of the matter, please.
But the judge says that put only one question. No, 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 ಬೇರೆ question use ಮಾಡ್ಲಿಕ್ಕೂ ನಮ್ಮ report ಇದ್ರೆ ಸಾಕಿತ್ತು. You take notice, let us.
Please, my lords.
Issue emergent notice.
Grateful to my lords.
They have raised all questions that would have been. Yes. Subramanya Prasad. Special.
Your Lordships, I appear for the appellants in this matter, Your Lordships. She came for a short accommodation, Your Lordships.
Short accommodation. Yes. Call in second week of January 2025 at the request of counsel for the petition. Yes.
Wait, please. Lord.
Yes, Mr. Prabhu. ಏನಿದೆ?
The issue is, my lord, Assistant Director, DNA section in Forensic Science Laboratory is the post for which I applied. The requirement was, my lord, Laboratory, Forensic Science Laboratories, my lord, in the Department of Police, FSL. Page 60 is the qualification prescribed.
60.
60. The fifth column on page 16, my lord, prescribes. The second, first one, my lord, is not in dispute that I hold. We must be a degree holder in so and so, so on. So doctorate degree holder in so.
To the post of?
Yes, this is, my lord, the Assistant Director, DNA section in Forensic Science Laboratory.
He should be doctoral degree.
Adide, that is not in dispute. Next one, my lord, must have not less than 3 years of analytical research experience in any forensic science laboratories or any research institution recognized.
With the
Now, my lord,
government.
I do have. Now, what is said is, my lord, You should have a working experience. They substitute, instead of what is prescribed, the Honorable Tribunal, my lord, substitutes its own words to say, page 20, your lordships will get.
Research experience idre saku antana?
Anta ide, lordships will see, my
Or
lord.
any research
In any institution, lordships will see, my lord, if the work experience was prescribed, they should have said in department or any working establishment. Page 20, my lord, is the page 19 onwards is the reasoning assigned for unsuiting me.
that actually amounts to amending rules of recruitment,
ಅವ್ರದ್ದು
appointment by promotion.
page 19, my lord, they reproduce that, my lord, the same.
Notice
ಅಲ್ಲ, ಅದು ಆಗಿದೆ. It was one, and no, the parties are served, objections are also filed. I'm only the single point, my lord, lordships may see the reasoning.
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಕೇಳೋಣ ಮತ್ತೆ. Ready in the matter?
No, we have not filed objection. Just verify and file.
ಅಲ್ಲ, ಇಲ್ಲಿ objections.
This short matter is for the KPSC to decide because there are numerous cases in which they have held, my lord.
The question is not that. How can the tribunal introduce a word, a concept which is not there in the rule?
Page 57, your lordship, notification ಅಲ್ಲಿ ಇದೆ.
ಏನಂತ?
Continuity ಇದೆ.
No, rules will be.
Analytical experience format ಅಂತ ಇದೆ.
Rules will
Format
be.
ಕೊಟ್ಟಿದ್ದಾರೆ.
Rules, you can't have, your notification cannot transcend
ಅಲ್ಲ,
the rule.
ಅಲ್ಲ, ಅದಕ್ಕೆ lordship may kindly see page 20, the application has been by authority based on the recruitment notification as well as C&R rules in accordance with law, and there is no information on the in the eye of law ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Page 57, my lord.
20 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
57. Research experience format ನಲ್ಲಿ they have given.
Research experience. ಅದ್ರಲ್ಲಿ work experience and format ಇಲ್ಲ.
ನೀವು ಅದರಲ್ಲಿ ಆ that very format says what should be there.
ಹೌದು.
How can you expect more than what the format? Even if he has one, how he will be able to furnish it when you prescribe the format? Even if he has experience in Scotland Yard police, he cannot write that because your format does not admit anything to be added to that.
ಅಲ್ಲ, ಇದರಲ್ಲಿ first I will read one. Contents is specifically the format, research experience format, but on reading the content, it is specifically noted that applicant shall working as a research scholar, designation of candidate as narrated in the format. Both the formats noted supra are clearly speaks the applicant is having research experience, not the work experience.
Correct.
The applicant, without reading the entire contents of the format, filed this application based on
Let
head
us
note.
read the formats now. Read. Where does it require working experience? Twice I have read now when we were arguing.
Experience as research scholar as on so and so months
That's
and
what.
days.
That's what.
ಅಂತ ಇದೆ sir.
How why tribunal says everything has to be looked into is true. But where is that?
And it is certified that this institute is recognized by central and state government ಅಂತ ಇದೆ. ಆಮೇಲೆ next from analytical experience format ಇದೆ.
Huh?
Analytical experience format ಇದೆ.
That applies to the first part.
ಹೌದು. ಎರಡು ಇದೆ.
ಅದು ಎರಡು. So he has to comply with that.
ಅಲ್ಲ,
How the tribunal can say all these tamasha
ಅಲ್ಲ,
we do not
C&R
understand.
rules ಪ್ರಕಾರ ಮಾಡಿದ್ದಾರೆ ಅಂತ verify.
ಎಲ್ಲಿದೆ?
The tribunal extracts the very same formats and says his experience is not in conformity with this.
That is
format.
wrong, Anta. Therefore he is here.
No. The work experience, the research experience in those institutes are deemed to be work experiences.
Correct.
The distinction is only this. There are certain institutes where research is conducted where they are not workers. I mean,
Now, where is the working experience?
no, that is why they have extracted the format.
Huh?
It is the format.
Show that. Read the format.
My lord, the
This
tribunal.
is to page 57. You know.
Huh?
57.
That's
format.
what.
Seven,
Both the
also the
formats
tribunal
are-
extracts it
Same
at page
extracted.
18.
Read.
Tribunal extracts it at page 18.
Don't worry about the tribunal. Tribunal is being
57.
attacked before the court now. Therefore, say from your document which the tribunal has acted upon. Come to 57. Read slowly.
The format, research experience format. This is to certify that so and so is working as research scholar, designation of candidate, example JRF, SRF,
Stroke. See that.
research scholar stroke.
Working as research scholar, stroke,
Stroke, SRF.
designation of candidate that is so and so under the supervision of so and so. She was admitted to our institution on so and so from so and so. This her experience as research scholar, not working experience. Where is that word working? Where is that adjective? Adjectives do not fall from the heaven. Unless the rules require, you can't put the adjectives, adverbs, etc.
Please, my lord, if it is in this format, in the format in which it is given, and it is come from a valid institute as required under law,
How can
which is there under UGC guidelines, it is accepted.
Maybe many guidelines may be there, but where is that? Supreme Court say, working, you will exclude many people who do not have working experience.
The first line, my lord, this is to certify that Mr., Mrs. So-and-so.
He was working
Was
as research
working.
scholar.
Was working.
Stroke. Go to the stroke.
Is working as research
Designation.
scholar with designation / designation.
/ Supreme Court say is an alternative.
ಇದ್ರಲ್ಲಿ KPSC ಹೇಳ್ಬೇಕು ಸುಮ್ನೆ, ಅವರು ಇಲ್ಲ, ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ ಕಾಣುತ್ತೆ
KPSC.
KPSC ಗೆ.
Who appears for KPSC?
Already there.
Sri, so and so is requested to accept notice for, ಯಾರು?
ಪ್ರಕಾಶ್.
KPSC ಗೆ ಪ್ರಕಾಶ್.
ಪ್ರಕಾಶ್.
Prakash, K. Prakash, learned panel counsel is requested to accept notice for respondent KPSC. First, a petitioner to serve copy of
I
the
have
petition
served,
on-
my lord, already. Served, my lord. Served. His name is not reflected
Name
perhaps
to be
therefore.
printed, registry to print name of Mr. Prakash.
Page
Call
97.
after
I'm
2
sorry.
weeks.
Not date, my lord, I'm without job.
Will come next. Will come. Yes.
Appearing for the petition. A matter that is arising out of the consumer dispute lots. The petitioner is opposite party number 1. A complaint was filed initially before the state commission, which came to be allowed by the complainant.
Appeal ilva idra mele?
Lots under 58(3), since it's not a first appeal, a revision
Second
lies.
appeal is not
It's
there.
it's
Revision
that-
is there.
Revision, as per the Honorable Supreme Court judgment.
But revision is wider. The text of that revisional provision
Please,
corresponds with the section 18 of the Small Cause Courts Act.
please. But if-
Therefore, it's wider, though it's not as good as appeal.
but in this case, it comes under 58 subclause 3 of the Consumer Protection Act. Lots.
Read. How courts have construed it, the scope of revision. Which paragraph?
Lodge will find. Para,
No, this is no appeal.
there's no appeal. Lodge.
No.
Please, there's no
Revision
appeal.
is there.
Revision has been filed before the National Commission, right? Because that's a first complaint before the State Commission. Then an first appeal is before the before the District Forum. Then an appeal before the State Commission. Then a revision is filed under Regulation 14 under the before the National
You
Commission.
file that one.
Please. Then again, there's no appeal before the
Revision is over now.
revision is over. Lots.
That's also over.
That's also the impugned order is the revision, lots.
Revisional
Where
order.
the delay application came to be dismissed primarily without looking into the condonation cause. Therefore, on that application being summarily rejected on that,
ಎಷ್ಟು ದಿವಸ ಇತ್ತು delay?
288 days, lots.
288 days.
Please, lots.
Long delay ಆಗಲಲ್ವಾ? What is the explanation offered?
Lots, in this, when appeal was sent to the council, the said council.
Where is that?
Please, lots, ink page 41. Ink page 40 and 41 is the
41.
grounds and reasons given.
What is that you have stated? You have kept blanks in the application also.
That's the application as filed, so I've filed as it is. I didn't want to. It's 288 days, lots.
No, that's all right. But unless you tell how many days of delay,
288 days, lots.
you are saying it orally.
It's also forthcoming from the order, lots. In page 36, para 12.
No, that order comes up thereafter.
Please,
Your version 41, page 41.
please, lots.
Come to para 12.
Please. In that application, what they have filed as it is, lots, maybe the copy that has been filed before the National Commission, the number is mentioned. This is the office copy, what has been sent to us, lots.
In that you had mentioned.
Please, lots. Your lordship will find
Even
para
in
12.
see your affidavit.
Please,
Come to 44.
please, lots.
Even there it is blank.
There it's with respect to verification, lots.
That's blank.
That's blank. Verification is on the
All right.
date.
Where have you stated in your affidavit, how many days of delay? You know, 100 days, either we'd have understood, 288 days. Where is the reasoning of the National Commission?
Lords will find at page 36,
36.
in page 36, para 12, 13. The issue was this, Lords, the counsel for whom the said copy was sent, he had misplaced the records due to renovation of the office. Therefore, he could not file the said appeal in time. Therefore, they had to send the seek instructions again and get the copies again, and they had to refile it, Lords. That is the issue. That is definitely requires an indulgence on this court.
How many days revision against this?
90 days, Lords. as per
90 days plus 288 days.
Please.
Plus the days taken for furnishing of the copy, it will be 2 years. That object is that they should get speedy justice,
Please, but in
chief
this,
justice.
in this matter, what has happened, Lords, if I take your Lordships to this point of merits of the case is filed on this point. The petitioner is the stockbroker, respondent, the complainant respondent is the customer client. It's firstly, a dispute does not come within the scope of the
Commercial.
it's a commercial matter. Second point, Lords, there is an associate person who's dealing with the consumer, and they've entered into an agreement for settlement of certain amount, and in that they've received 1 lakh and balance 4 lakhs was not paid. Therefore, the refund of that 4 lakhs they filed for the said complaint. Lords, there was actually
Amount deposit madil.
50% I will deposit. Lords.
Why 50%?
Please.
You are not a
Please,
farmer,
please.
laborer.
Great.
You are not some
Please,
Kallegowda, Mallegowda.
the matter is
We
on.
could have
I.
Number kali.
Please.
Agent anta.
But he is your agent.
Respondent number 2 is the associate person. Lords.
So that means what?
He's an agent. He's an agent.
Then principal and agent.
They've entered into
What he
a
does by
settlement. Please, Lords. I'll deposit the amount.
Commercial element ಇದೆ. ಹಂಗಾಗಿ dispute ಆಗಲ್ಲ, service dispute ಆಗಲ್ಲ, consumer dispute ಆಗಲ್ಲ. Issue emergent notice. Stay of impugned orders. Subject to petitioner depositing the entire amount in question. Interest ಇದೆ ಅನ್ನೋದಕ್ಕೆ 4,29,735.
Please, that amount of
Nodama.
deposit.
4,29,735 in the registry within 3 days, filling which interim order stands in dead on its own, and the petition runs the risk of
Please,
dismissal.
we will mail. Lordship, may I request your Lordships to provide early delivery because the client is in Chennai. I may have to send them instructions.
1 week.
1 week will be, please, please.
Within 1 week.
Lords, in the order, since the execution is already filed and the matter is coming up on 7th.
We have stayed now.
Please, great.
We have stayed now.
Great.
No, all further proceedings pursuant to impugned orders are stayed,
Great.
subject to signs.
1 week. Great.
Mohan. Yes. Your friends can go for a round, na? It will take some time.
Yes, we'll take
Yes, sir.
Please.
Ready? Both are ready?
Yes, yes.
So no option to the judges now. Yes. brother.
But the petition.
What is the issue, brother? How, whether that full bench matter was taken to the apex court?
No, Lord.
Not
We have
taken?
checked online.
It has
not
attained
taken.
finality?
It has attained finality.
Okay. But just say the foundational facts.
Please. But can I just
Yes.
pass on, Lord, the memo
Buddy.
documents, what was there before the learned single judge?
Okay. Original second appeal ಇದು?
Lord, this is original second appeal.
ಏನದು under which provision?
From the testamentary OS, Lord, it becomes
Original. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಒಂದು TS ಎಂತದೋ ಒಂದು ಬರ್ತದೆ?
the TOS and the
TOS.
testamentary original suit.
Testamentary original suit.
Second appeal ಎಂತ ಅದು?
Original second appeal.
Second appeal ಅಲ್ಲ, first appeal, OSS.
ಅಪೀಲ್ ಬರ್ಬೇಕು.
OSS.
Termed as OSA.
ಎಸ್ ಎ ಅಂದ್ರೇನು? ಎ ಅಂದ್ರೆ ಅಪೀಲು, ಎಸ್ ಅಂದ್ರೇನು?
Original. Side appeal.
Side
Side
appeal.
appeal.
Side appeals.
Side
Side. He says that. Yes.
But the bill Milord is of the year 3/8/1989, which Milord should get it at Milord page.
What is the order your, give just a small, make a small statement.
Yes, Milord.
Brandy statement of US Supreme Court.
But briefly, Milord, the issue is only this. Milord, a petition is filed for probate, not of a will. Milord, in that, Milord, application for impleadment is filed not by the contesting respondents. Their impleading is allowed. And Milord, after which they file an application for rejection of the petition on the
So
ground.
it was a contested matter.
Yes, Milord. And it-
What takes the character of a suit?
yes. Now, Milord, the application is filed under Order 7 Rule 11A, saying that not suit the petition is not barred by limitation. 7D, 711D, saying it is barred by limitation.
711D.
Now, the learned single judge allows the application and says that the petition is barred by limitation. That is challenged before Milords. But the only Milord, the crux of the matter would be Milord, one, grant or Milord application for probate, but is not Milord a legal Milord
No
requirement.
limitation,
But limitation is provided under Article 137. That's what the Supreme Court has said.
3 years.
Yes,
That
Lord.
is a residuary article.
Yes. However, Lord, it is a continuous right, is what Supreme Court has said. So long as Lord, the duty is not discharged, Lord, the right continues what the apex court has said. But Lord, unfortunately, learned single judge says, once the will is denied, that
Cause of
means
action arises.
the cause of action arises. Therefore, within that period, you have to file it.
I think there is one more angle,
Please, Lord.
that your will was rejected in a 22 Rule 5.
True.
proceeding.
True, Lord. Yes, Lord.
And thereafter
True, Lord.
probate was filed.
Yes. Lord, what happened was,
The probate, it was held that there it was rejected and therefore the limitation starts from that day.
yes, Lord. What Lord learned single judge says is, Lord, earlier an application, a suit was filed, Lord, by the earliest Swamiji. Lord, there during the pendency of the suit, Lord, he died.
Is it a case of continuing cause of action or it is a case of recurring causes of action?
Lord, it is a continuing cause of action, so long as, Lord, the
Obligation
duty,
is not
obligation is not discharged. Lord, I straightaway take notes of judgment of the apex court, Lord, which answers this, which, Lord, I had placed on record before the learned single judge. I had placed on record on the last date.
You have given that. You're right. Rulings ಅನ್ನ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ? Clear. Whether Indian law differentiates
Please, Lord.
between continuing cause of action and recurring causes of action.
No, Lord. In fact,
Does not differentiate.
I'm doing a little more homework on that, Lord, because there are no direct, Lord, I have found judgments, Lord, which say in suit for partition, it is a continuous action, continuous cause of action that
No,
continues.
recurring causes of action.
A recurring cause of action, Lord, it is something similar to that because, Lord, there is nothing, Lord, defining what is a continuous cause of action. Lord, but the apex court, Lord, if my Lord should please turn to, Lord, the judgment of the Supreme Court in page 43 of that compilation.
Samir
Oh, Samir
Kapoor.
Kapoor. Lord, can I request, Lord, please turn to para 9, Lord, which may also get it at page
Page
50. 50, Lord.
paragraph.
Para 9, Lord. Lord, kindly permit me to read, Lord, the two issues that were raised before the court.
That 9.1 is 137.
How?
Residuary
It
article.
applies is what?
Go to the next point.
9.2, Lord. Whether application under 228 of the Succession Act shall be barred by a period of limitation prescribed under 137 of the Limitation Act, and whether the period of limitation for application under 228 would start to run from the date of grant of probate by a court of competent jurisdiction situated beyond the limits of the state, whether within or beyond the limits of India.
What is that?
But there, Lord, what happened was there was an endorsement that was issued saying that you'll have to apply and obtain probate. He filed for a probate after lapse of 4 years.
Whether it was time board was
At
the
this
issue.
time, but was the issue. Lord, that Lord was considered. Lord, kindly then turn to, please permit me to take the
No,
court.
two questions are framed there
Please, Lord.
separately
True.
with the conjunction.
Yes, Lord.
The first question is, shall be barred. 228 probate.
How?
228 of the Succession Act shall be barred by the period of limitation prescribed in 137.
Second
of
portion from
limitation
when
Act.
it would start to run. Not that is what is
the
relevant for
correct-
us.
Two questions. One
Yes.
is, once reckoning point is fixed, then we understand what is the period run. Whether that period is prescribed, is it within the period prescribed in any of the articles in Schedule 2 Act? That is the question.
But can I request, must please turn to para 12, Lord? However, the next question which is posed for consideration before this court is when the right to apply can be said to have accrued. As per Article 130 of the Limitation Act, the period of limitation prescribed is 3 years and 3 years begin to run when the right to apply accrues. The crucial expression under Article 137 Limitation Act is right to apply. It is the case of the appellant that in the present case, the right to apply for letters of administration accrued in the year 1997. More particularly on so and so, when the High Court of Justice so and so, Birmingham, passed an order for grant of probate of will dated so and so in favor of respondent number 2. It is a case on behalf of the appellants that therefore right to apply under section 228 of the Act had accrued in favor of the respondent number 2. on
Whether 137 also speaks of right to apply?
Yes, Lord. Does not, it says not.
Wherever limitation is not prescribed, will be 3 years.
Yes, how?
Right to apply as such is not spoken of.
It says, Lord.
Right to apply is under 228.
True. It says when the right to accrues is what it says.
Right accrues.
Right to apply accrues.
Right to apply accrues. That is 227 language.
How?
137?
The 137 itself says, Lord, any application for which no period of limitation provided elsewhere in this division.
Read one provision where application for a specific period is prescribed other than residuary.
For the purpose of not any.
Right to apply accrues to understand.
True, Lord. Section 9.
Says right to apply. Right to apply accrues.
113 says.
228. 137 says right to apply wherever no period is prescribed. It will be 3 years. That's a residuary. Therefore, we want to know one particular article where right to apply accrues within period. For that, how it treats.
But 113 Lord says.
113.
How? 113 says any suit for which no period of limitation elsewhere is provided in the schedule, 3 years when the right to sue accrues.
Again, that is the
language.
Where particular period is prescribed, how that is texted. All right, we'll look into. Go to the next point. May articulate your point.
Please, no. Not if can I just.
According to you, right to apply for probate arises accrues to you, to use the language of statute 63 statute. When it accrues.
Not it accrued in my favor. What happened was not after not the order was passed not by the trial court, but in the earlier 1999 proceedings. There not I had approached the Honorable Court in a CRP.
What was that suit?
Suit not was filed for declaration of certain rights not against not the father of not one of the respondents herein. There, Lord, CRP was filed and CRP was disposed of, saying the observations made not by the trial court will not affect you, but you are entitled to take action in accordance with law to establish your rights. Immediately thereafter,
Had pressed into service the testament.
Yes. The will was the subject matter, but then I was a minor. I was represented by a guardian.
You were a party there.
But I was a minor represented by my guardian on the basis of this will itself. There's no dispute on that. After which, Lord, the other Lord interested.
When you attain majority.
But I will inform the court.
That also figures now.
No, Lord, the issue was another not important issue was not another suit was filed by the respondents herein through their predecessors or whoever not. Wherein, Lord, the very issue with regard to the will was subject matter. That is OS number 1 of 1996. And a specific issue was framed with regard to this very will, where, Lord, I was also, Lord, pursuing the matter, trying to prove the will. But ultimately what happened was the plaint was rejected, saying that the suit is not maintainable because section 92 proceedings were initiated. The court said we cannot proceed because there is no such trust as such.
Public trust.
But that is what they claimed. On that basis, the suit was filed.
Whether any finding was given in respect of the will?
No, my lord. That is precisely the reason. Immediately thereafter, I filed this probate petition.
It was filed under 92,
How?
right?
Please, my lord.
But in that suit,
Please.
an application was filed under order 22.
No, my lord. That's a different suit. My lord,
It's
can I
clear.
request, my lord, to please turn to the memo with documents?
One suit is under section 92. 92 suit is subsequent.
Subsequent. It is of 1996.
They pleaded that it is a public and charitable trust. Court came to the conclusion to the contra and said no jurisdiction.
Yes.
Therefore, did not treat the plea of validity of the will
Yes.
at all.
Therefore, my lord,
Sorry,
after
sorry,
which.
one submission, my lord. In earlier suit, my lord, there is a finding that will is invalid. Earlier suit.
That was not subject matter of CR. I'll take notes of document itself. This honorable court said that finding will not be of no consequence. I am entitled to prove or discharge my rights in so in a proper instituted proceedings. Now, my lord, that suit was one of 1996 which they had filed, where an issue was framed with regard to this particular will itself. Please.
There are judges which say that a finding pursuant to an inquiry under order 22 will bind only those parties who are before that.
But that finding also, my lord.
Finding is not in rem.
True.
At least to others, we can say.
At least to others. Not, in fact, not this honorable court clarified. Not, can I just persuade, not, so please turn to page 36 for a moment of the memo, not with documents. But this not will be clarified because this honorable, I'm sorry.
Probate proceeding nagada. What in that suit? Probate
1996.
Probate jurisdiction is rem. Whether contested or not, it continues to be rem only.
Yes.
Even when it is contested, it will be tried as far as possible
As a
suit as stayed.
yeah, how.
Therefore, its a rem character continues.
Yes, ma'am.
Even when there is contest.
Yes, that is not my limited understanding.
ಇವನಿಗೆ ಬಿಲ್ಡಿಂಗ್ ಇದೆ point. Where is that 2017 judgment of Punjab Haryana High Court, which is said about what is the effect of order 22(3)? Anybody remembers that judgment? 2017 AR 2017 2017 Punjab said, once finding is given, it rejudicates contra finding in other proceeding. 2017 effective that 22(3) effective. 22(3) another.
How?
22(3). 22(5) is N5. It operates as a res judicata rules we with Punjab. Get that 2017 judgment? Get that 2017 under of Punjab Haryana High Court.
In fact, not in this, in the CRP, this honorable court clarifies because I had challenged the order of the trial court of the order of 1995. There, not this honorable clarifies it does not operate as res judicata.
There.
Now, please turn to page 36. The order starts at page 34 of that memo, which I just passed on with the orders or pleading before the single judge. Page 34 is the order, not 20th of September 1996. Order passed in CRP. Please turn to page 36, no?
36?
Oh, 36. Not about 6 lines from the bottom. But it starts with present case at all. My lords have it, no?
36?
Page 36, Ali.
Para 10 is there. 36 of your paper book?
No, my lord. I've just passed on a memo. I have passed on a memo with not the
memo.
Not citations, my lord. This is the documents which are placed before the learned single judge.
Okay.
My apologies, my lords have it. Page 34, it starts.
You're right.
Lords have it, my lord?
Yes.
But this is the order in CRP, my lord, which is filed by me. So please turn to page 36.
6. Para
Not
B.
bottom in the about sixth
referring
line.
to.
No, it starts with the Supreme Court was concerned with. ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಕೆಳಗಡೆ ತಾವು ಬಂದ್ರೆ it goes on to say present case at all.
Internal page ಏನದು?
Internal page 3 of that order. Page 36, internal page 3 of the CRP order.
ತಪ್ಪಾಗಿದೆಯಾ? 6 36(3). Yes.
Not from bottom, if not turn to about not.
The question that when the plaintiff had died, the legal representative could be put on record and whether the proceeding would abate. The court took the view that upon the death of the plaintiff before judge, that time would abate, but when final judgment had been obtained before the death of the plaintiff, the benefit would go to the legal representative. That is not the position. Therefore, the principles laid down in the same. And whatever view expressed by the trial court is neither conclusive nor would it bar any further proceeding on principles of res judicata, and such decision is only for the purpose of continuing the suit. Karnataka law, short notes, so it is certainly open to the petitioner to initiate appropriate proceeding to get his rights settled. So res judicata argument will not
come.
Rightly or wrongly. It's a
That
finding
is the order.
which you are suffer.
This is at in finality.
But this view appears to be little, anyway, because you have suffered and finding as attained finality, Patil versus Patil will apply, 63 Supreme Court, and it will be res judicata.
Please no. Lord,
Could you get to locate that judgment? 2017, 2013 judgment is reflected, reiterated in 2017. Go to 2013, Punjab, Haryana, on order 22, rule 3, rule 5 of CPC.
This para, my lord, my sorry, my lord.
Eh?
This para, next para.
Para?
It helps me, my lord, that cause of action starts at least from that point.
page 37.
Para
method
6 kindly be
referring.
seen forever, at this
Next
stage.
paragraph.
Yes.
You have noticed that the suit was abated. In the second question, whether the proceeding is abated need not necessarily be recorded in the court proceeding. The legal position between. I do not think that part of the order will affect the rights of the parties in it. I do not think
Yes.
no part will affect them.
Yes, ma'am. Therefore, at least from that stage, cause of action comes to him. He should have raised this probate issue and all thing within 3 years. He filed a suit in the year 2017.
No, but what he says is, it's a continuing cause of
Yes,
action. not our
yes, that,
contention.
yes,
If that is so,
yes.
then
Yes,
reckoning, all that will fall to the ground.
But then, Lord,
Which decision held the point that the right to apply for probate is on the premise of continuing cause of action?
Yes,
The other
ma'am.
judgment idea?
how did the one Samir Kapoor itself says so? But I'll just take notes. Just
Well,
1 minute, Lord.
Paruk, P-U-R-U-K, Paruk on law of succession. Get that book. Which judgment you said, brother?
Lord, Samir Kapoor, which my lords were just seeing while ago, my lord.
Samir Kapoor itself says
How? Lord,
that
page,
it's a proceeding of continuing cause of action.
it refers to another judgment of the epic. Page 51, if my lords will please turn to.
Page number?
51, my lord.
51.
Continuation of para 12. But after placitum beam, Lord. It was also the case on behalf of the appellant that so long as the will is not probated, the period of limitation would not start running. However, once the will is probated, in that case, the period of limitation as per in Article 137 Limitation Act would begin to run from the date on which the will is probated. But then, Lord, please permit.
No, question is not that. Question is when to apply for probate.
True, Lord. That is also.
Because further.
How? Please turn to Lord para 16.
1-6.
How?
Directly answered in para 10, my lord, in same judgment, para 10.
Para 10.
Yes, my lord. That is the issue answered in.
So far, the first question is concerned.
Shall I apply to probate?
No, not present.
ಹೌದು.
View of the direct decision of this court in both the proceedings, the court has specifically observed that had that shall be applicable.
Then only says 137 applies.
Grant of probate or letters of administration also. Therefore, question 1 is answered in the affirmation. The 137 limitation act shall be applicable to the applications for grant of probate or letters of administration. In answer again. Yes. 137 will be applicable.
137 is applicable, but there is no dispute about it. But please turn to note para 16, note. Para 15 says the question.
Para 16.
Para 15, note, is a question. Now
Next
the next
question
question which may arise for consideration would be, with an application
application
probate or letters administration with will, the period of limitation begin to run from which date?
from which, correct.
Yes.
This is the question.
This is the question.
Yes. How it
While
is answered.
considering the issue involved, the decision of this court in Kunwarjit Singh versus so and so, it is required to be referred to and considered. In the said decision, this court considered the decision of the Bombay High Court in so and so, as well as the decision of Madras High Court in so and so. In the said decision, this court referred to and considered para 24 of decision of Madras High Court, which reads as under. In the proceedings or in other words, in an application filed for grant of probate or letters of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. Probate or letters of administration issued by a competent court is conclusive proof of the legal character throughout the world. An assessment of the relevant provisions of Succession Act 1925 does not convey a meaning that by the proceedings filed for grant of probate or letters of administration, no rights of the applicants are settled or secured in the legal sense. The author of the testament has cast the duty with regard to administration with the state, and the applicant for probate or letters of administration only seeks the permission of the court to perform that duty. There is only a seeking of recognition from the court to perform the duty. That duty is only moral and it is not legal. Lords may kindly not mark this. There is no law which compels the applicant to file the proceedings for probate or letters of administration. With the view to discharge the moral duty, the applicant seeks recognition from the court to perform the duty. It will be legitimate to conclude that proceedings filed for grant of probate or letters of administration is not an action in law. Hence, it is very difficult to, and it will not be in order to construe the proceedings for grant of probate or letters of administration, applications come within the meaning of an application under Article 137 of the Limitation Act. But the last portion was not accepted by the Supreme Court. That 137 will not come. Only that was rejected. No, please then come to para 16.1.
No, where this is Bombay view.
Yes, no.
Madras view.
That was not taken before the Supreme Court. The next paragraph itself.
What the apex court said about this view?
Yes, no. 16.2. 16.1, the court says, however, court did not, can you just continue 16.1, Lord? This court approved the observations made in para 24 of the Madras High Court.
Yes.
Insofar as the nature of the petition for grant of probate or letters of admission is concerned. However, this court did not agree with the finding that the application for grant of probate or letters of administration is not covered by 137 of the Limitation Act. In the aforesaid decision, this court also considered and referred to para 16 of the Bombay High Court in so and so in para 15, which reads as follows. Rejecting Mr. Dalpat Rai's contention, I summarize my conclusions thus. Under Limitation Act, no period is advisably prescribed within which an application for probate, letters of administration, or succession certificate must be made.
This is a Bombay High Court said.
No, this is approved by the Supreme Court except Lord B. That is, assumption that Article 137 of Limitation right to apply necessarily accrues on the date of death of the deceased is unwarranted. Then, Lord, the next one, such an application.
What is meant by unwarranted? Was not required for
Was not
deciding
required.
that case on our
But the court has said 137 will apply. Then, Lord, C becomes important, Lord. Such an application is for the court's permission to perform a legal duty created by a will or for recognition of a testamentary trustee, and is a continuous right which can be exercised any time after the death of the deceased, so as long as the right to do so survives and the object of the trust exists, or any part of the trust, if created, remains to be executed. Then, Lords, please permit me to take my Lords to Placitum G. This court did not agree with bar approved conclusion B. However, approved conclusion C reproduced herein above.
Conclusion C is
that it is a continuous right, can be exercised any time after the death of the deceased, so as long as the right to do so survives. It is not their case, not that right does not survive. Their case is that it is barred by limitation. Therefore, my lord, my submission is the right not to seeking for probate, even today it survives. I am entitled, my lord, to obtain for probate, and ultimately, my lord, I am not seeking for declaration of right with regard to property here, because their entire case is, they say the property in question was given to the temple or to the much earlier point in time, and they have a right in the property. They have to approach the civil court, seek for declaration of right. Ultimately, there is no title that is declared in a probate proceedings, as my lords are aware.
what was the suit 92 they had invoked, na?
Please note.
What was that suit about?
That was a scheme suit, not for administration of Sri Guru Gundeshwara Brahmeshwara Swami deity. But what they say is, there is Guru Gundeshwara Brahmeshwara Swami Mat. Other one is, they say there is a deity. We say there is no deity, there is only a mat. So they wanted to say there is a
What
deity
difference?
involved.
Mat also can maintain a suit under 92.
Can be.
There need not be a deity at all.
Both. But in that context, Lord, also can you just continue, my lord, reading that judgment? Para.
This we wanted to understand.
Please note.
But once you say that the residuary clause is applicable,
please,
there is a limitation.
True. But if it is not continuous or in the nature of recurring, then not that right continues. So long as not the obligation is not discharged. Not there's a distinction not here, because not it is not a legal right that not this sort. It's a moral duty that I have to obtain it. And Lord, therefore, it is not as though, Lord, I have to obtain it that point in time itself. Because a continuous right I can seek, Lord, at any point in time. Here, Lord, my submission is, Lord, kindly permit me to show the order that was passed, Lord, in OS number 1 of 96.
There is one other aspect. For Hindus, there is no legal requirement of probating the will.
Absolutely not. I bowed on.
At all.
How?
Except in presidency towns where property is situated.
But sir, absolutely right. Therefore, Lord, there is no legal obligation. Please note.
Because dispute.
In fact, probate through, Lord, the property will come to me by virtue, or Lord, whatever rights are provided, and they will come to me.
To me, that has been negated there.
No, Lord. There, these proceedings stood abated. And then, Lord, the dishonorable court said, you can, Lord, get your declaration.
So in keeping open, we can fight this. Is are you decided? Continuous right to because they permitted it excluded invocation of res judicata. Therefore, I here I will content. It may be wrong order, but it binds as between the parties. It is binding on our contention. I am unable to understand this. 2017 Punjab Haryana judgment is there. He is not able to place hands on that. There is such a judgment.
But that I think
there is such a judgment. 2017, which was Justice Ram Prasad also referred to that judgment.
But was it not Justice Rajmohan Singh's judgment, Lord?
Correct. That is the judgment.
I'll get a copy.
Ask him to get that judgment.
Please.
Get it from that judgment. Rajmohan Singh versus.
Lord, that is not Sheila Vanti versus Kishan Lal.
Justice Rajmohan Singh.
Rajmohan Singh. Her party name is Lord
Sheila
Vanti.
Sheila Vanti
versus Krishnan Lal.
Correct. Kishan Lal.
This is the one, order 22.
They have considered the impact of an order under 22(3) read with 5.
Please.
Good reasoning they have given. Our court, Justice Shyam Prasad, Honorable Justice, Brother Justice Shyam Prasad has considered this judgment in one matter.
Can I continue reading Lord Samir Kapoor further?
Yes.
Because Lord para
No,
17.
we were
Please,
bit confused with the reasoning of the court. Once you say
please,
137 is invocable,
please.
that is on the ground that there is a limitation. 137 applies where there is a limitation. Where there is no specified period of limitation, then the sweep of 137 is wider. It says 3 years. Wherever no limitation is prescribed, 137 will apply. That is the idea. If that is accepted, then if the court says there is no limitation at all for subsequently, there appears to be mongoose and cobra put together. How we should organize, the symphony with between them with them.
What the court clarifies not further in that judgment is,
Court only says there is no legal obligation to apply for probate at all.
True.
That's how it is.
how,
And if at all there is any obligation, it is only a moral obligation. Anta ಹೇಳ್ತಾರೆ.
And not third and most important facet, according to me, Lord, which is again explained in para 17 thereafter, is that not so long as not the right to do so survives,
You can go on applying
You
at
can go
any
on.
time, no limitation
no
at all.
limitation will come. But please permit me to take notes to para 17.
No right is asserted claimed by the applicant. The applicant only seeks recognition of the court to perform a duty.
True.
Probate letter issued by competent court is conclusive proof of the legal character throughout the world. That the proceedings filed for grant of probate is not an action in law, but it is an action in
rem.
rem. Action in law may not be correct. It is an action in law only,
It's an action.
but it is an action in personam.
Correct.
Athwa not in personam, because probate is a probate jurisdiction. So in rem.
Then not again they extract not that 16C, that is continuing cause of action. Then the placitum C, Millers may kindly see.
Continuous right, which can be exercised any time after the death of the deceased, as long as the right to do survives and the object of the trust exists, or any part of the trust if created remains to be executed.
Then not the next paragraph, not there, not there was the application was filed after a lapse of 4 years. The para 18 notes may please see. Applying the law laid down by this.
No,
court-
therefore, last one. Therefore, even if
Please,
that placitum C,
Therefore, even if the will is probated by any court mentioned in section
section
228
228 of the
the
Act,
right to get the letters of administration, the continuous right.
that is another the letters of administration is going better.
And can be exercised at any time so long as the right to sue survives and the object of the trust exists or any part of the trust, if created, remains to be executed. Applying the law laid down by this court in the aforesaid decision and observations made herein above, the submission before.
No, they had sought for letters of administration.
True.
That's not the case here.
True, this is not the case here. In fact, not when the application, I'm sorry.
Hmm? Then how that full bench of our full bench judgment, how that becomes invocable?
Lord, it becomes invoked for this reason. Lord, one, Lord, is whether, Lord, a rejection of plaint can be entertained, Lord, in a proceedings of this nature. Because, Lord, it is as far as possible, it shall be tried as a suit.
Yes.
But it is not a suit as such, the strict
Correct.
sense of the term.
It is not
No.
a suit as such is true.
True, Lord.
But Order 7, Rule 11 D in particular would be invocable. If it is to be tried, because it is tried that way, because it is a contest. Once there is a contest, otherwise probates are granted ex parte.
True.
one side, one citation and ex parte judgment will be given. Even that operates as the rem,
In rem.
order
yes,
in rem.
Yes, yes.
But where it is contested, that has to be tried as a suit. ಅಂತ ಹೇಳಿದ್ರು. You mean to say 711 is not applicable, invocable
It
at
will
all?
not be applicable. for
Any judgment of
Two
that
reasons, Lord. No, I'm relying upon Lord. In fact, Lord, the Samir Kapoor and other cases also, it was Order 7 Rule 11 itself that was filed. Lord,
They
but
did not say such application is not.
no,
made
they have
available.
not. They have not gone into that issue. But
They
Lord,
treated it on merits.
yes, Lord. There's one Lord distinction. If Lord may kindly see, Lord, the rules with regard to probate. High Court ಅಲ್ಲಿ, there is not the format. Lord does not provide for the cause of action as to when it arose.
No, that is uncontested in that.
No. Even
Anytime you can file it.
anytime you can file because
Format does not. Format will not govern the
very well.
substantive
Lord,
law.
Very well. If my lords may then permit me to take notes to section 276 for a moment.
Padi, Indian Succession Act.
How?
ಇಷ್ಟು ಕಾಂಪ್ಲಿಕೇಶನ್ ಇರೋ ಕೇಸ್ ತರಬಾರ್ದು ನೀವು. 276.
In fact, Lord, it is not, court should, in fact, earlier, Lord, when the application for reject, the impleading was filed.
Rule 11 is not applicable because there is no such limitation.
The one is, Lord,
No,
it is a continuous right is one issue. Second thing is, it is not a suit.
137 will be limitation.
It is not a suit in the strict sense of the term.
That's right. It will be tried as such.
Tried as a suit.
How it should be. The section is the process oriented.
True.
Process specific, not designation specific.
True.
That's how I have reasoned that.
Yes,
that
Lord,
full
no,
bench judgment.
But section 276, petition for probate. CPC next.
276.
Order 6.
Application for probate or for letters of administration with the will annexed shall be made by a petition distinctly written in English or in the language in proceedings before the court in which the application is made with the will.
What has to be set out, Lord, is time of the testator's death, the will annexed, his last will and testament, duly executed, amount of assets which are likely to come to the petitioner's hand, and when the application is for probate, the petitioner is the executor in name of the will. In addition to this, the petitioner may further state, the application is to district judge, the disease at the time of his death, etc. Now, my Lord, please permit to take my lords to order 7.
No, what you want to say by
But
this?
from this, not what I'm trying to say, my Lord, comparing this, not with order 7 rule 1, as to what has to be set out in a plaint. Lord, specifically, Lord, the cause of action has to be set out. Now here, Lord, what is required to be mentioned is date of death of the deceased. Not, Lord, as to when the cause of action has arisen for me. Strictly speaking, therefore, Lord, it is a continuing in nature. That is a distinction. In a suit, Lord, you have to mention when did the cause of action arise for you. Because the time limitation will start running and then you can not count the limitation. Here in my petition, Lord, I don't say the limitation starts from running from that date. Because I have pointed out that another suit was filed.
Do you dispute that Supreme Court said that 137 is
No,
applicable?
Lord, I cannot dispute.
You can't dispute.
I cannot dispute.
You're fair. You're very fair. 137. So there is limitation.
Lord, there are two ways of looking at it, Lord. One is, no doubt, Lord, 137 would apply insofar as, Lord, probate is concerned, what the apex court says. But there's slightly difference, Lord, on factual circumstance here. There, Lord, as my lords rightly pointed out, there, Lord, letters of administration were sought, and, Lord, the court considered a date when the probate was granted. Here, Lord, I am seeking for, Lord, probate itself. Two, Lord, kindly permit me to also point out in this case, Lord, OS number 1 of 1996 that was filed by, Lord, the other side, their father or whoever it was.
That was 92.
No, Lord,
Earlier one.
1996. CRP admele, other or simultaneously they filed one more suit under section 92, invoking section 92 of CPC. But there, Lord, that proceedings, Lord, got disposed of on 20th July 2016. Immediately there, over 7 months thereafter, I have filed the probate petition.
No, first we'll understand the legal position.
Very well, very well.
Both you agree that there is a limitation.
Lord, Supreme Court not judgment, Lord, I cannot say much.
So you agree that there is limitation
But yes, it says Article 137 will apply,
applicable.
but I would of course.
137 applies only when there is a limitation, but not specified by any article.
Out.
If you see Rustumji, D.A. Desai on law of limitation, they say that way. 137
Please.
applies as a residuary clause.
True.
It applies because there is limitation. Unspecified limitation in any of the provisions, any of the articles in schedule. Then you travel to 137.
Leading judgment on that point, Kuni case, my lord.
What apply? Limitation to apply accrues from that day. Will does not become invalid by lapse of time. Is it not? Though it is ambulatory, the will does not commit legal suicide, like your right to sue for money, etc., etc. A will is continuous. At least William on Will says this. The famous book, English author, William on Wills, very famous book. The German on Wills, the two books which Apex Court has considered in at least 1 dozen judgments. A will not die, but it stands revoked if the testator gets married. That is the only circumstance where by operation of law, if something happens, the will stands rescinded, revoked. Otherwise, will is valid. Number one. Will is valid is one thing. Will should be probated is another. A will needs to be probated. These are the XYZ circumstances. A Hindu will need not be probated at all. That's the law.
Yes.
But circumstances may arise where a Hindu will rush to the court seeking probate of the will.
Yes.
Third component. When he applies for probate, whether there is law of limitation or not, both you are agree, we also agree. We have no discretion to disagree with what the Apex Court has said, that there is a limitation. This is fourth component.
Begins when
Ah.
the will is operated.
Fifth component is if there is limitation, which is the reckoning point.
Yes.
The whole dispute is not about the will, etc.
No.
Absolutely.
The dispute is the reckoning point of the limitation.
My lord has got.
We feel like that.
Yes,
Lord, sir, absolutely right.
Having heard you,
yes,
we felt like that. Yes.
Lord, sir, absolutely right. Lord, that is the only issue. Now, my lord, if it is a continuous right or a continuous cause of action that is available to me, then, my lord, I am entitled to, my lord, file the petition at any
No,
point.
that amounts to saying,
Please.
your argument falls foul of 137.
No, my lord, it will not, because the Apex Court itself says,
Let
so
me
long
say-
as, yes, my lord, I'll just not repeat reading that paragraph. Court says it is a continuous right, so long as the right to do so survives. But I'm entitled to apply to the court. But please look at the situation, Lord. A will is executed.
Then 137, when does it apply?
But 137, Lord, strictly speaking, although
By your argument, it will never apply.
true, Lord. Because Lord,
Every time you will say it's a continuous cause of action.
true, Lord. And Lord, what happens is court says 137 applies.
Yes.
But simultaneously, the Apex Court also says it is a continuous right, so long as you have the right to apply. You can apply at any point in time. That
That
is,
means
the
you are-
obligation remains.
Then never 137 will apply if we accept your argument. It completely excludes invocation of 137.
At the cost of repetition, please permit to read that paragraph. That is what the Apex Court says.
Tell us when actually 137 will
In
apply.
which case 137 will apply, according to you.
Lord, according to me, it's a situation where, Lord, in a situation where probate is granted and somebody wants to seek for revocation of probate,
No.
then that is one issue. Two, Lord, insofar as the proceedings, Lord, where a right to perform certain duties already been discharged, then, Lord, the will, Lord, cannot be probated thereafter because there is nothing surviving to be done under the will. But so long as, my lord, there's something surviving to be done under the will, but otherwise, please look at the consequences. But will, my lord, there's certain obligations to be discharged. But I discharge, let us say, a part of the obligations. Rest of the obligations are not discharged. But would it mean that the will becomes redundant, my lord, thereafter? Because, my lord, as my lord rightly pointed out, will, my lord, is a continuous, my lord, right that remains. It devolves. That right remains, continues to inhere in me. Now, my lord, if I, let us say I don't perform, my lord, a portion of the obligations, I perform one portion, other portion I don't perform. But then, my lord, I may have to go to court and get it, my lord, declared by the court that I'm entitled to discharge this obligation. Otherwise, my lord, what would happen is, my lord, the entire object of executing the will, the right that comes through the will, my lord, everything, my lord, becomes, my lord, redundant. And that is why the court says, my lord, it is a continuous right so long as there is an obligation to be discharged. That is a distinction. If there is no obligation to be discharged, my lord, then, my lord, 137 will come into operation and say it is over.
What is the obligation to discharge in this will?
Not in this will, not there are few properties, not which has come through me through this will, etc. Because not I became a matadipati of not this mat. There are certain obligations which comes along with it. I have been already been not appointed as a pontiff, which of course they want to dispute, etc. I am discharging my obligations as a pontiff. There are other obligations which I have to discharge on the basis of this will. Now, my lord, that remains to be discharged. Therefore, my lord, it is a continuous right which I can exercise at any point in time. And it is not that, my lord, I kept quiet. Not I had filed my written statement and raised a specific issue in the suit of 1996, where an issue was framed. And the court's, my lord, was to consider my issue. Evidence also, my lord, was partly read with regard to this issue. Now, my lord, ultimately the court says I will not get into any of this because section 92 will not apply. Then I have rushed to court. So there is not a case where not I have kept quiet after the order was passed in the CRP.
Anyway, we have understood your point now. Any other point?
Other point, my lord, is the issue of, my lord, limitation would be a mixed question of law and fact.
That's right.
And, my lord, the learned judge, my lord, goes on to say that, my lord, once the limitation is commenced when they have raised objections and, my lord, they have contested the earlier suit, that is the date when the cause of action has commenced and it does not stop.
The squirrel is telling us to raise now.
Very well, very well. I'm sorry.
What is your point? You have also.
My submission, my lord.
Yes.
In 88, my lord, the earlier Swamiji filed a suit. During the pendency of the suit, my lord, he executed a will in favor of my friend's client. Thereafter, he died, my lord. That suit was dismissed as abetted. Then he filed an application for impeding himself, so under order 22, etc. That was dismissed. In that application, my lord, we filed denied the will, and that was taken, and that was a part of the plaint, and that was taken into consideration by learned single judge.
Registered or unregistered will?
Registered.
Registered will.
Registered.
Oh.
It's not just taking an ordinary Hindu will, my lord. It is a will, my lord, where the earlier pontiff was also having limited right. He's not the owner, but he filed a suit claiming, asserting right in himself for declaration of permanent injunction, earlier Swamiji.
Whether that pontiff andre, is he a sannyasi?
Yes, no. He was also appointed by the will itself.
Sannyasi.
Yes,
If he is a sannyasi, how can he write a will?
And that tradition is there, my lord, in this mutt.
There is a tradition.
But he filed a suit for asserting right in himself as a owner.
You have come without preparation.
Yes.
It is sixth will in this.
Apex court said, in Sanskrit, sannyasa means, of course, there are 4 stages.
I'm not
that's
prepared.
another thing. Therefore, I'm telling you that
Please.
you have come without reading.
Agwas.
Both you have come without reading
Sorry,
that
sorry.
judgment. Anyway, we'll tell you. If in Sanskrit, sannyasa means sampurna nyasaha. So he should give up everything, and law treated sannyasa as civil death. Okay. If nyasa means giving up, if he gives up everything, he gives up all his interest in the property and succession opens.
True.
This is how law is structured in Indian legal system. Number 1. Even pious obligations will go because in there is one Upanishad, Sannyasa Upanishad. There is one Upanishad on this, which Privy Council referred to. In the case of sannyasa, what happens is they just go by 4 stages: Siddha, Arudha, Avadhuta, Paramahamsa. These are 4 types of sannyasa in Indian legal system. So, pleading, so many things are lacking is another thing. But just we are giving, if he is a sannyasi, how he could write will is one thing. Of course, that issue nobody has raised.
It is
It's another thing.
We are not right.
To become a pontiff of a mutt, one need not be sannyasi. There are grahastha mutts also. There are non-sannyasa mutts also. A pontiff, Calcutta High Court said, a pontiff need not necessarily be a sannyasi. Anyway, the pleadings are lacking. Anyway, this we pointed out to you.
No, it is a tradition in this particular mutt, not that it follows not the will executed by the Swamiji. In fact, not is the 6th will, the basis of which not the
The
pontiff
pontiff is appointed by will.
Another will, earlier will.
Another will.
There are 5 successively, my lord, there are 5 wills, my lord.
Success. And died.
This has been the tradition not of this mutt.
Appointment is by testament.
Yes, my lord. By, in this case, my lord,
Very appointment.
my lord, in this case, interesting, my lord, the earlier pontiff asserted right in himself and filed a suit for declaration that he is the owner, though he claimed under another earlier will as a pontiff. And he got, my lord, all mutations in his favor, in his name, and was challenged and set aside.
Yeah, all right.
That is
How do you say if it is a continuing cause of action?
My submission, my lord, section 137 once applies, my lord. I will read, my lord, repeat my learned friend, what he has said, my lord, that
But
annexed
this is
clause
that 2017 judgment which my lords were referring to
17 judgment.
of Punjab and Haryana.
Punjab,
High
Haryana.
Court.
Give that judgment. This is Justice Rajmohan Singh's Sheila Wanti. ಇದರಲ್ಲಿ ಏನ್ hold ಮಾಡ್ತಾರೋ ಒಂದು ಸಿಟಿ
Para 9, not the court.
Para?
Para 9, not
Nine.
at page 6.
You are right. This, that's what I said, reiterate, read that. Held that.
In so and
applicability
so
of
the
rules
apex
3,
court
4 and 8.
and that applicability of rules
From
3,
the
4 and 8 of
execution
this
proceeding.
order 22 rules has been excluded from execution proceedings. The normal principle arising in a suit before the decree is passed in the context of abatement of suit is not applicable to the death, causes of death of decree holder or judgment debtor in execution proceedings. No limitation is prescribed for bringing the legal representative on record. The execution petition cannot be dismissed in default in their absence except in case where the application is not filed within the time prescribed by the court itself. In so and so, it was held that Order 22 Rule 3 and 4 of CPC. The decree passed against the persons impleaded as legal heirs binds the estate, even though other persons interested in the estate were not brought on record. Ordinarily, court does not grant a decree. So,
Not completed, but there is an exception to this rule. However, aforesaid is recognized. So.
then Lord, para 10 again, Lord.
So execution can proceed even when LRs are not brought on record.
That is it. Because
No
rights-
limitation is prescribed of making an application for bringing on record the legal representative. It is, even if all the legal heirs are not brought on record, the same would not be of any consequence, as the only requirement is that the estate of the deceased is effectively represented. You have to find that even if all the legal signs would not cause any impediment in execution of the limitation for five. Another court decided that this is not okay, wait, period of 4 months for making the payment. Right, so in that case, we show that it's simply. Okay. All right.
Lord, in this Samir Kapoor was followed by another judgment of Supreme Court.
Not necessary.
Yes.
Article 141 says,
One
law
that-
declared by the it does not say law repeatedly
Yes,
declared by the
yes.
Supreme.
Therefore, my submission,
One law
Lord,
is sufficient.
when on the date, Lord, when we disputed the will,
There the cause of action
arises,
arises.
and that was
And
considered.
137 applies.
Yes, applies. That's the only argument.
Okay, that's the only, yes. Heard reserve matter.
Right.
Anything more to be said
But
about
on
this?
continuous Lord cause of action, I'll try to place some judgment
Yes.
as to what Lord it indicates. Lord, my learned friend's contention is basically that they have a right in the property. It is not with regard to the will. Therefore, Lord, what they try to say is they have a right in the property. If it's not their case,
Not a dispute about property.
it is a dispute about property.
Property only.
Not we have been
Lord,
allowed
but
to
Lord,
contest.
here, Lord, I am
If
not
it
saying
is
about it.
a-
Please, Lord.
No, we are thinking another angle also. If, because will is defined as posthumous or posthumous,
Yes,
I don't know,
posthumous.
I don't come from English medium. Posthumous disposition of property of the testator. That's how section 2 defines this one. If it is in relation to power of appointment, then it does not fit into the definition of will. Therefore, we asked you, again we are asking you, is it in relation to property? If it is in relation to property, then alone it becomes a will. Otherwise, it transcends the definition of will. Read definition of will. Suppose if you say, my book shall not be edited for 15 more years, 50 more years, which Shirvai said, that nobody will edit my constitutional law. Whether that partakes the character of a will, we are just asking, we are telling the Shirvai said, nobody should edit my book, fourth edition, for 50 years. In his will, he wrote that. Whether that will be definition, will means legal declaration of the intention of a testator with respect to his property.
True.
Suppose if you want to write of appointment, pontiff, etc., that will not be property at all. Therefore, it will not be will at all. Therefore, then question of probate will not arise. From that angle, we are asking this question.
Of course, not that was not contention that was raised, not by either of the parties or not in the order.
But that question will not arise in this case, my lord.
Will not arise because the
Because
claim is for
ultimately
the
he has to
property.
establish. He has to
Because
establish
not
some
here.
Property.
Yes.
Property also is there. not-
Property also is.
Also
yes,
is there.
232 acres.
all right. But much of law in this country has grown because of Swamijis, including Keswananda Swami.
They contributed a lot of judgments.
Much of law, constitutional law, taxation, Lakshmindra Tirtha Swami are then section 92 suits, so many tax, income tax matters. The Swamijis have propelled not only religion, law also.
But one additional fact, Lord, when they filed an application for impleading, and the impleading was allowed, they also raised a contention with regard to limitation, which not the learned single judge had held that this has to be considered at the time of trial. Now, after which this application for rejection of plaintiff has been filed. There, that order, my lord, has attained finality. Therefore, my lord, there cannot be contradictory orders, my lord, passed in the same proceedings. In fact, my lord, evidence, my lord, had already commenced. I have cross-examined, my lord, their witnesses. They have completely cross-examined my witnesses.
But that is not.
At that stage,
that-
Lord, this
that
application is
Hibbins
filed.
case, Supreme Court said, Lord,
Any decision which says 711 is not invocable in 295 ಐದು ಏನಿದು
276, 273 to 276.
270
the learned single judge quoted, division of this honorable court.
saying
Where it says, not 711 applies.
ಯಾವ್ದು ruling
Idರಲ್ಲಿ judgment.
Otherly, the issue whether it is maintainable or not was not raised.
not raised.
Not raised. In fact, the court considers not the judgment of Allahabad High
Heard
Court.
on merits.
Page number
This
21.
application,
21 we have read that.
Yes.
It did not raise that question. Maintainability of question was not
Not
question of maintainability of the application of the kind was not raised. Both sides proceeded. It is maintainable, therefore argued on merits of that.
there's one Allahabad,
Learned single judge himself relied, Lord.
Correct.
Para 21, 19.
The Allahabad High Court.
Allahabad
No,
High
our
Court.
high court, our high court,
Correct.
our high court.
Even in our High Court judgment,
Yes.
my reading of papers, there the question as to maintainability of such application was not raised. It was not raised.
Lord, the objections filed by them, Lord, itself, Lord, regarding maintainability, Lord.
Give your write-up on this.
Please,
Both sides file
Please, please,
your
please.
written submission.
please.
But very interesting.
In Serial number 20, Lordship asks us to comply with the interim order, I mean, deposit the money. I
Ah.
believe the money is already deposited in the
Huh?
case. Money is already deposited.
You have already deposited. ಅಲ್ಲಿ ನೋಡಪ್ಪ.
It's
ಅಲ್ಲಿ
also
ಒಂದರಲ್ಲಿ
coming in page
ಹೌದು,
74.
ಮಾಡಿದೀವಲ್ಲ. Subject, consumer court ಅಲ್ಲಿ subject to deposit ಇದೆಯಲ್ಲ, ಅಲ್ಲಿಂತ ಮಾಡಿದ್ವಿ, full stop. However, if the amount is already deposited before the consumer forum,
For district court.
comma, the requirement of again depositing will not arise.
Grateful.
All right. ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು. ಹಾ. 29. ಹಾ. ಯಾರು ಅಪೋನೆಂಟ್? Petitioner, he wants time.
Please, your lordship.
No objection?
No objection.
All right, call
Interim
in the
order to
second
extend.
week of January 20.
Interim order subsection shall.
Interim order to continue.
Right.
But a very interesting point.
Yes.
Yeah.
But as my lord said, my lord, the judgment of the Supreme Court on one portion says 137 applies. Other portion it says is continuous.
Does not apply that way.
But maybe the distinction would only
There is
be.
another judgment of Apex Court. While construing the law of limitation and the judgments on that, one favorable to the dominus litis should be followed ಅಂತ ಒಂದು ruling ಇದೆ. ಅದನ್ನೊಂದು ತೊಂಬನ್ನಿ, just ಕೊಡಿ. Prepare your draft.
Very well.
Don't make it very verbose.
No,
Proposition of law, supportive ruling, a section, statute, opinions of experts like Williams on will, Jarman on will, how they say.
please,
All right,
we'll do it.
grateful, thank you.
My lord,
4 days time, 4 days time.
1 week,
Please.
all right. 1 week ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ judgment ಬಂದ್ಬಿಡುತ್ತೆ.
ಇಲ್ಲ ಮಾಡ್ಬೋದು.
my lord, serial number.
Assist me, Lord. ಇಲ್ಲ.
Yes, brother.
Serial number 31, my lord.
31.
Yes.
ಏನು?
Time may be granted.
ಯಾರ ಅಪೋನೆಂಟ್? ಕೋರ್ಟ್ ಮೂಡ್ ಅನ್ನೋದು? ಕೋರ್ಟ್ ಮೂಡ್. Wait, your friend may come. Okay. Please.
Sir. Sir. Sir, ಇದೊಂದು. ಸರ್ RFA 528 ಅಲ್ಲಿ RFA 528 ಅಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಕೊಟ್ಟಿದೆ 26 ಅರ್ಜನ್ ಆಗಿದೆಯಾ? ಬೆಳಗ್ಗೆ ಅಂತ ಒಂದು 38 ಇದೆಯಲ್ಲ, ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ.
Maker and supporter. Volume is full for me.
fact that the petitioner has reported for duty at ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ 2 ಅಂತ ಮಾಡ್ತಾರೆ, at the transferred place shall not come in the way of the said representation being considered favorable. Obliged. All. Thank you so much for standing tall at the bar. All of you stood tall. Yes. Yes, but on day 2, application ಎಲ್ಲ ಹಾಕೋಬೇಕು, petition note ಕೊಟ್ಟು. Yes, next.
For the petitioner in 25.2.
Yes. 25
liability.
3 cases are there.
Yes, madam.
How all the 3 cases arise?
No, different directors have filed petitions challenging
Challenging the very
execution
same order.
against the company.
All right.
My lord had mentioned my lord's order in a similar matter. That order we have found, where my lord has relied on Solomon, followed Solomon and said that as against the directors, this is court copy.
But I believe that is subject to doctrine of lifting the veil.
Yes, always.
It appears I have mentioned that also. I remember.
Yes.
But 4 years ago, I decided, 3-4 years ago, I decided that matter.
Signature. Malakodi signature ಆಗಿಲ್ಲ.
Some discussion also took place as to whether parties can be at the negotiating table.
That's right, my lord.
Mentioned that, huh?
May I appraise the court of what the situation is? This is a company which has a single shareholder. This is just generally context, my lord. Just bear with me. What had happened was the city had several single individual cable or service operators. Try to encourage them to become corporate and become more professional. Everywhere in each locality, one cable service operator. As technology advanced, try to encourage them. This was an amateurish attempt by the cable operators of those days. Some 240 odd cable operators have come together, formed an LLP, a limited liability partnership. And that limited liability partnership is a single shareholder of this company. So there is no one person or a set of persons who are at the helm of affairs or who are responsible for the affairs of the company. This is a conglomeration of sorts of 240 odd people who have just come together. So at the end of the day, there is a company, and behind the company are 240 cable service operators. So each one of them,
limited liability partnership is also governed by Companies Act.
by Limited
Chapter 9.
Liability Partnership Act.
Chapter
There
9.
is a separate act.
There
It
is
is
another
required.
act.
Yes, there is an act for ROC is there. The reporting authority, registration authority is
Not
the
your
company.
ordinary regular
No,
partnership.
not register of firms.
Separate act.
It comes that there is a separate Indian Partnership Act, Limited Liability Partnership Act, and Companies Act. The regulatory authorities for companies and LLP are more or less same.
Both they were under the supervision of
ROC.
ROC.
So registrations, reportings, filings, everything happens.
Okay.
So when I asked them about settlement, they said each one of us will have to contribute separately. That's all that we can do. They have tried in the past. The numbers didn't
But
seem to
he
be palatable.
said, I read yesterday, again, he says that there is sufficient asset to satisfy the decree in the offing.
That's it. I asked him about that also. That again, do we have the memo of documents?
No, he said it in affidavit.
Yes, I know. Basis for that. What is the basis? Because this company is just a company of service providers. There's no asset in terms of land or any property or anything of that sort. So I asked him, what is the basis for you having said so?
Number one.
He said the set of boxes.
Number one. Number two, what is the income he has drawn? Income from the company is taxable.
All that information will require some time to gather, because we have not had the time to sit and gather all that information. It will take some time for us to do that. It will, because my lord is right.
Your client is here.
My lord, my client is here, but I doubt
Ask him, all right, ask him whether he has derived income in under IT Act. Income of the LLP is taxable separately. Income which LLP which the partner derives from the firm is also taxable.
My lord, what we
It is
can
not
do is,
separate.
these are not questions which fairly I can ask him to expect him to answer across like this.
You kindly do not underestimate the wisdom of your litigants. Ask him whether he has drawn income from that LLP or not. Let him say yes or no. Otherwise, I will put him on term and also warn him. If he lies, the,
There is no
Pro-
question
no,
of
just
lying
tell him,
here.
tell him, tell him,
Let
tell
us
him.
not assume
We are
anybody wants to
asking.
lie here. That's why, in fact, I would rather not take oral instructions. Best is to bring records.
No, that will,
That satisfies everybody's requirements.
that will satisfy us also, but put him and put a warning also. He has to tell the truth to the court. All right, come this side. Come this side. What's your name? Eh? Kaliyappa. All right. What's your educational qualification? Educational qualification?
Because I've become
Completed, not completed. You're not a graduate. Graduate. So how long you have been in the business? Huh? Huh? 20 years. All right. Are you income tax payer? You are. How long? Since how long? 15 years. Did you derive income from the company? You have not derived. Record his voice. Bunny,
My
come
lord,
this side.
my lord will come. Pardon. Like I said, my lord, please indulge me.
He is here.
No. My
He is
lord,
not a
this
farmer.
is-
We are asking him.
My
We will
lord,
also record that you objected in the
It's
order.
not a question of objection. My lord will be just fair. See, what happens also is litigants get nervous and give answers. It may not be strictly
say,
in
I am not-
accordance.
No, Mr.
No, but
Joshi.
let us
No, Mr.
pause
Court
for a
has
moment.
got power to put any question to anybody in the court
No,
hall.
no.
That is the section.
May I request for a pause in the proceedings for a moment?
All right.
My lord is now, the court is assuming that the director is directly answerable for the liabilities of
No,
the
we are not
company.
assuming.
So let us,
We are ascertaining the factuals, which court is entitled.
therefore, my lords may give me some time. I will bring the
he is-
necessary records.
No, Mr. Joshi, that amounts to coming in the way of court asking the question.
Certainly not in the way of coming anywhere. Because
we'll
you see,
record that.
he may say, for example, I'll just give an example. And this is my genuine apprehension. Having spoken to them for the past couple of times, my genuine apprehension is this, and I only speak in the interests that they should not unwittingly make an incorrect statement. The apprehension is, a party may say, I have not received income. He may have received some 500 rupees or 750 rupees or 1,500 rupees.
We
The
will
court
not
may say, you received income and
No,
you made a statement,
No,
I've
we'll
not
make
received
that
it.
also. We'll take care of that also. We are
So-
simply asking, if he were to be some farmer, peasant, laborer, rural man coming from rural area, we could have understood. The Supreme Court said, even in execution proceedings, when things come in writ jurisdiction, the High Court is entitled to put any question to anybody in the court hall, not just parties, to anybody in the court. That is the law.
We
We
should
want
just
to
then
assert-
ask what happens to the concept of a company,
No.
you decree against the company. What are the bona fides of this creditor who has summoned the police authorities before the executing court,
Mr.
put a
Joshi.
gun to his head and ask him to pay 5 lakh rupees?
Mr. Joshi,
Let us just look at his
We-
conduct.
all right, we won't, just we'll ask him whether he said that he is an income tax assessee. Naturally, presumption is that he has derived income, only to exclude that that income has accrued from some other source. For that purpose, you should permit us to.
My
put
lord,
that-
permit.
Yeah, yeah,
My
we feel like.
concern, my lord, I know how strictly this court views conduct. And I'm
Very
conscious of.
because in
I am conscious of.
226 No,
Therefore, my
226
concern to protect him,
Joshi,
that's all.
Mr. Joshi, we have spent lot of time on legal literature. You also know, we also know. Decades have gone. Decades have gone. We have burnt midnight oil, days oil. Almost
Oh,
every time we have
Nobody
done.
comes in
In the light of that, we are telling you, you should permit us to put the questions to them.
Certainly.
If you really object, we'll record that. Everything will be available on
I
system.
express my concern to the
Very
court.
good.
Otherwise.
Now, you have to answer approximately, since last, every year you have taken income from the company? Not like that. Okay. Come this side. So that, let him up, so that everything will be on record now. Of course, everything is online, on record. You have been assessee since last 15 years. Huh?
Yes, sir.
15 years. Do you remember the last assessment year? What was the income you have derived from this LLP?
No, sir, the things.
You do not remember.
I have not received anything from LLPs.
You have not received any income at all? At any point of time? At any point of?
Sir, from the day one, the beginning,
We are running under loss.
Okay. All right. Yes, Mr. Joshi, tell us, argue the matter.
So,
All right, be seated. Be seated.
Lord, as how the judgment.
Conduct, Mr. Joshi, right from the English history of writs, law of writs, which dates back to 1527. But it goes still back to 1215 of Magna Carta. But at least 1527, the law of writ is very strictly delineated in England. We have adopted it,
That's
subject to certain modifications, favorable to the public at large. One question is, conduct of a party is one of the important factors in granting relief or denying relief to the litigant.
that is.
Kindly that also.
And once I set up this proposition that this is a decree against a company,
Correct.
I am also very clearly aware, there is no doubt in my mind,
Yes.
that it is not one permanent shield or a perpetual shield to directors or shareholders saying, company, therefore don't even look at me. And when my lord said that whatever it may be, at the end of the day, lifting of the corporate veil is a concept known to law. Yes, where there is malice, where there is an element of dishonesty, then certainly corporate veil can be lifted. Having said that,
yes.
This was the decision that my lord's own decision.
Did it travel to Supreme Court?
Not to my recollection, my lord.
Not correct.
Not.
Very famous. Because I also wrote that judgment sometime, maybe 3-4 years ago. I do not
Fairly well
much
settled,
remember.
and my lord has
But I
reiterated
remember,
the correct.
I remember.
Well settled positions in Salomon versus Salomon, and my lord has correctly said and brought in the element of lifting of corporate veil.
Correct.
That onus remains on the decree holder to demonstrate that while I have a decree against a company, I am entitled to lift the corporate veil or have the corporate lifted. That onus is on him.
This is subject to doctrine of lifting the veil.
Yes, always. Any defense to be set up about an artificial entity, always the artificial entity can never be a perpetual shield.
Correct.
There has to be some.
Correct.
This being the position, my lord,
Yes.
the impugned order is at ink page 20 of the petition. It is an order dated 1st September 2022. I stand before this honorable court on two grounds. Firstly, a plain reading of the order itself. The authority, executing court, is in Delhi. I am in Bangalore, and directions are being issued against me. Lord, fundamental principle of executing courts, court without jurisdiction. If the decree has to be executed in Bangalore, then the decree has to be transferred to an executing court, section 39, and only thereafter executed. The court, executing court in Delhi cannot issue directions against me here either for attachment or for production of money. That decree ought to have been transferred to an executing court in Delhi and thereafter in Bangalore, and thereafter it ought to have been executed. That is my submission one. Second, this decree not being against any single individual, at ink page 23, para 14, the directors were summoned. Of course, they can be summoned, for example, for disclosure of assets. When disclosure of assets of a company has to be made, an official of the company has to come and file that affidavit. At para 14, now we have called the registrar of this tribunal who is present in court. We have directed him to call for the police officer from the nearest police station. The police officer from Chanakyapuri police station, New Delhi, is present in this tribunal. Looking to the provisions of the CPC, especially Order 21, Rule 41(3) to be read with Section 55 of the CPC, we hereby order so-and-so Mr. Karyappa, one of the directors of the respondent, in a civil prison for a period of 3 months. The police officer from Chanakyapuri police station shall take into custody Mr. G. Karyappa. At this stage, counsel for the respondent again requested to adjourn this matter to 9/9. He submitted that 5 lakhs will be paid by the respondent to the petitioner by bank draft or RTGS. It is further submitted by counsel.
It is paid,
5 lakhs had to be paid. I was getting arrested.
it has been paid.
Yes. And
What
not
is the
only-
amount,
57, 60, 57, 59, 59 lakhs. 59. And not only 5 lakhs was taken from me, an affidavit I was made, coerced into submitting an affidavit saying that I'll bring forward another 15 lakhs. Since I had some time in between, that is when this writ petition came to be preferred, and this honorable court thought it fit, particularly, and that is what the order also says of this court. In the light of what is set out by the executing court in para 14, a stay is granted in respect of operation of this order. Para 20 also. my lord.
for
We de-
everyone like the same order?
My lord, para 20, we therefore direct the petitioner to join the following persons who are directors of the respondent as party respondents numbers 2 to 10. The amended memo shall be supplied by petitioner during the suit is not amended, the decree is not amended, the executing court amends the execution petition and brings individuals onto record and directs execution against those individuals. Without even, my lord, it is definitely available to an executing court to conduct inquiry. To say that, let us examine where the assets, if at all any, have dissipated. And if there is an element of dishonesty, definitely go after wherever the assets are. Not in this manner is what I'm saying.
Please come to page 51.
Page 51. Yes, ma'am.
Read from below that paragraph, para 10,
The
four lines.
para 10, page 51, my lord, I have that affidavit of disclosure where he says that, yes.
Correct. In
Without
his
prejudice.
affidavit, the judgment
The relevant
debtor
extract
possesses
of the affidavit.
sufficient means to discharge this obligation in case this honorable tribunal allows the petition filed by the decree holder.
That's right.
This is the stand which the.
That's right. I was explaining that also in the beginning.
Yes.
What had happened around that time is,
This was
other
when?
than-
This was when?
this was, the affidavit date is 2016, 4th March 2016.
Yes.
In 2015, and again, like I said, my lord will permit me some time to put together the records. ಅರ್ಧಂಬರ್ಧ ಬೆಳಿಗ್ಗೆ ಬಂದೇನು ತೋರಿಸಿದ್ದಾರೆ. What was happening was around 2015,
We'll call this matter after 4 days.
I will be able to put together a list of dates and events and documents.
Now 5 lakh, each of the directors has paid 5 lakhs?
No,
Or
only
only
this
one
man,
director?
only this man was being threatened to be arrested. So some 5 lakhs was extracted out of him. Because even in law, his liability will not go beyond 5 lakhs because of the limited liability partnership. Each one of them will be liable to the extent of their contribution. They cannot be asked to bring forth much more beyond that. That is the principle under liability, limited liability. So 242 members, whatever is their contribution to that extent.
How that act is structured on the principle of limited trading?
Limited contribution,
Limited, that is limited
among-
liability.
limited liability. So amongst the partners, they
Have that
can
act, I have not seen that.
right away, no, not here, my lord. I
But
didn't even bring my
Okay.
Limited Liability Partnership Act, 2008, I think, if I'm not wrong.
It's a new statute.
A fairly new statute. And not very popular also. In
Of
its,
course,
and
okay.
it's not in its implementation also not very popular.
That's why.
No, it is not an LLP, it is a company itself.
Company
No, no.
itself. There is
The
such a statute.
Company is a single shareholder, the shareholder is LLP.
LLP, that way. Perhaps you have also not seen that act. Earlier, it was a chapter 9 capital, 9A,
Part
something.
nine, part nine, part nine
Part
of
nine,
Companies
part
Act.
nine of-
Part 9 of Companies Act is where it used to be.
Correct.
That's right.
Correct. The very act, purpose is regulation of limited liability.
That is.
So to that extent, this is in variance with the regular
With the Indian
partnership.
Partnership Act, because under the Indian Partnership Act, partners, there is no protection.
No,
Everybody is fully liable to the fullest extent.
Okay.
To bring about that minor change, this act came into India. But in business circles, this is not all that popular.
not that. Popular. This is to trade with limited liability only, like
That's-
company.
Like a company.
All right, we'll call, because he wants to.
a week so that I get the advantage of a Saturday, so I can sit with them, prepare whatever documents are next week.
Your lordships would also allow us to place on record the conduct of the party right from the inception of the execution proceeding. My colleague is there. She has a tabulation of all the orders which have been passed from time to time in the execution application, which ultimately results in the impugned order. And if your lordship would just bear in mind one more thing, my lords, in the impugned order, it is at the instance of the deponent that order is passed. Your lordships would just have a look at Annexure A, which
No,
is the.
Mr. Mukherjee,
Please, my lords.
let him file all his papers. We have put certain questions and he has answered. That also will put so that he can put it on affidavit.
One of the answers is very important. Your lordships asked him whether you gained income, what happened. He said right from the beginning, the company was
Has
making
not
profit.
received taken
Yes.
any income from
And
that.
the affidavit
His case is that the
from-
company the partnership firm was running into losses.
That's
That
right.
also
Then, my lords, your lordship will note the 2016 affidavit before the learned tribunal was a false affidavit of this party.
Not in the least.
Why,
Where
he
are
says
2016.
assets,
What
the
there?
firm has got assets to discharge
Yes.
the likely decree. That was his stand. At that time, it may be also. We do not know.
That is
And your lordship
Anyway,
will also
we'll
have a look
call
at
this
the-
matter. We'll call this, Mr. Mukherjee will call this matter on Monday.
Yeah, of course.
on Monday, very well.
Monday.
11th Agboda, if it's convenient, 11th.
All right.
11th.
11th will call.
Grateful.
On Wednesday.
And I will make all endeavors to now ensure that necessary records are before this court. I will do.
But also tell him how this court, the writ court will view the conduct of the parties. Tell him that
Certainly.
also.
Certainly.
Okay.
Grateful.
And allow us to place on record the order sheet, my lords, that your lordship will see. It's very telling, my lords,
Yes.
on his conduct.
All right. Having
11th, Wednesday.
during the course of hearing.
Wednesday.
Yes. Or any day of whichever day you want.
My lords, 11th is fine, my lords. 11th is fine.
Mr. Mukherjee says 11th is fine. Heard learned senior advocate Mr. Joshi appearing for the petitioner and learned senior advocate Mr. Mukherjee appearing for the respondent decree holder. Petitioner judgment debtor, respondent decree holder. First up. One of the directors of the firm.
Of the company.
Of the company. Mr. Karyappa, who is personally present before the court. First up. We asked him as to whether he is an income tax payer, capitals, income tax payer. Income tax, CCE without paying also he can be an CCE. Income tax payer, first up. He answered it in the affirmative. First up. We asked him as to whether he has derived any income from the company since its inception. And he answered it emphatically in an emphatic no. In an emphatic no. First up. Learned counsel appearing for learned Mr. Joshi seeks a short accommodation to compile all the relevant papers and submit in the form of a booklet, which shall include the copies of income tax returns and an affidavit by Mr. Karyappa as to the contents of the ITRs. Semicolon. The paper book shall also comprise of the ITRs for the assessment year 2015-16 to the assessment year 22-23. That is financial year 23-24. First, petitioner and Director Mr. Karyappa are put to notice that the conduct of persons tapping writ jurisdiction also figures as a factor in its exercise.
Great.
Call this matter for further more hearing on 11.
Great.
Okay.
Grateful to me.
But I appear for plaintiff in this case.
Yes.
Yes. Suit was for partition and separate possession, my lord. My lord, the contents of the plaintiff is like this, my lord. The plaintiff. My lord, the plaintiff have approached the court of law on the ground that the suit schedule B property was purchased by her out of her own earnings. And A schedule properties are the property belonging to her father, M. Doraswamy. And now, my lord, in a family partition, B schedule property have been allotted to her, which is her self-acquired property. In A schedule property, none of the properties have been allotted to her. The defendants were placed ex parte, my lord.
Defendants were placed ex parte.
Placed ex parte. But
Two schedules.
there are two schedules.
A schedule is the family property,
Is
father's property.
Father's property, all the property.
B schedule is self-acquisition.
Self-acquired property of the appellant. Now, my lord, it is the
Plaintiff.
it is the contention of the plaintiff that B schedule property was acquired by her under Exhibit P2.
Where is that ever meant to that effect in the plaint?
My lord,
Give
may I
the
take,
paper book.
yes, my lord, may I take your lordships to the, my lord, paragraph number 7, my lord,
Page.
page number 4, my lord. If your lordship permits, I'll read from paragraph number 5, my lord.
ಅಲ್ಲ ಆ ಪೇರ ಅಷ್ಟೇ ತೋರಿಸಿ ಇದು ಪ್ಲೇಂಟ್ ತೋರಿಸಿ ಇದರಲ್ಲಿ
Page number 4, my lord. In paper book, page number 4.
Page 4.
Yes, my lord.
Paragraph.
My lord, I have one extra paper book. If my friend doesn't have, I'll supply it. The plaintiff was married to Sri Raja on 13/11/1986, and thereafter the plaintiff started residing with her husband separately in her matrimonial home. Thereafter, the plaintiff herein, out of her own self-earning and as well with the help of her husband, she has purchased property bearing number 6, situated in corporation limits so and so, wide registered sale deed dated 15/4/1991. The copy of the absolute sale deed is herewith produced and marked as document.
Take us to that document.
Blood.
Document number 1. That was
Yes.
marked as what?
Exhibit P2, my lord. Now, my lord, it was exhibit P1 before the trial court. May I just take your lordships to that one?
P1 thought. Documents P1. Paper book ನಲ್ಲಿ ಎಲ್ಲಿದೆ?
My lord, page number 81, my lord.
81. 81 is P2 ಅಲ್ವಾ?
P2, exhibit P2, my lord.
P2.
I'm sorry, my lord. Exhibit P1 is the partition deed. Exhibit P2 is the sale deed, my lord.
Deed is under which your father got the property.
Is my father's property, which was divided between the brothers. My lord,
Partition. Huh?
exhibit P2, my lord, page number 81.
Correct. What was your age at that time?
My lord, my age is 25 years, my lord.
15/4/91.
1991.
Were you married?
My lord, date of marriage.
86.
86. I was married in 1986.
86.
86, my lord.
What was your husband?
My lord, he was a businessman, my lord. He was a businessman.
Was she employed?
No, my lord, she was not.
What was her income? What is the source of income? Where from she brought the money?
My lord, she was assisting her husband. He was a businessman.
Where have you stated? ನೀವು ಹೇಳಿಕ್ ಬರಲ್ಲ. ನೀವು ಹೇಳಿದ್ರೆ ನಮ್ಮ ಮತ್ತೆ ಬಾಕ್ಸಿಗೆ ಹಾಕ್ಬೇಕಾಗ್ತದೆ. ಪ್ಲೀಡಿಂಗ್ಸ್ ನಿಂದ ಹುಟ್ಟಬೇಕು ನಿಮ್ಮ ಉತ್ತರಗಳು.
Yes, my lord. In the
Where have you
pleadings,
stated?
my lord, it is only stated the plaintiff out of her self-earning and as well with the help of her husband, she has purchased. That's what the plaint government in paragraph number 6 states, my lord.
What was husband? You said he was a
Businessman, my lord.
Where
He
is
was a
that state?
business. My lord, that is not stated here. My
But
lord.
don't say anything which is not in the paper.
Yes, my
This is a RFA, not writ petition.
yes, my lord. That, what he was doing, that is not there, my lord. That is not there. Even otherwise, my lord, if your lordship can kindly come to partition deed, which is at exhibit P1, only this property they have shown, rest of the properties their brothers have divided between themselves, my lord.
Hmm?
If your lordship can kindly come to the partition deed, which is at exhibit P1.
Ah.
Now, my lord, page number 62.
62.
Yes, my lord, that is the partition deed.
In partition deed is dated
My lord, 21/4/2005.
21/4/2005.
Yes, my lord.
Who are all parties to this?
My lord, all my brothers, that is the defendants.
You and your brothers.
Yes, my lord.
Father was not there.
Father was not there.
Only, how many brothers?
My lord, totally 5 brothers, my lord.
But here, there are 2 wives. So Doreswamy Mudliar,
2 wives.
2 wives,
A marriage contracted in which year? Solemnized in which year?
much earlier to this one.
Prior
because-
to Hindu code.
Yes.
Then that will not.
Then what has happened, Mullah, from first wife, the Shanti and Velu. There are 2 children.
We'll come to that. Wait. Whether partition deed mentions about all that? No.
Yes, yes. The
Mentions?
details are there.
ಇದೆ 2 wives 64 ಅಲ್ಲಿ ಇದೆ. The said Doraswamy had 2 wives. Last line, my lord. Last line in page number 64.
You are right.
The said Sri M. Doraswamy had 2 wives by name Sri Kasturi Ammal and Sri Ammayammal. Sri Kasturi Ammal was the first wife of Sri M. Doraswamy and they had 2 children, namely Shanti and Velan, who are the parties of the first part and third part respectively. Srimati Ammayammal and Doraswamy have 4 children by
Which
name
community they are? Are they scheduled
Mudliars.
tribes?
Mudaliyas.
Mudaliars.
Mudaliar. Mudaliar
Hindu,
come under which? Are they, do they come under
Hindu.
scheduled tribes?
No, my lord, Hindus.
They are not.
They are not
Scheduled
scheduled
tribes are
tribes. They are
also
not
Hindu
scheduled tribes. They are not scheduled tribes.
Because scheduled tribes, Hindu Marriage Act does not apply to scheduled tribes. Therefore, we asked.
May I just continue reading, my lord? Partition deed.
What all properties were comprised in this deed?
My lord, in this, my lord, totally, my lord, there are about
This house property, the property in respect of which you have filed partition suit, they are also there?
yes, my lord. Only those properties are there in the suit, my lord. The
By-
property is mentioned in this partition deed
Huh.
and the property which was given to me in the partition, in this partition, that is A comprises of schedule A and B.
B also.
B also. B really what they did is, my lord, your lordship may kindly come to the partition deed again for a while.
Control him. Tell him to ask our question.
My lord, in the partition deed, they have shown, I'm sorry.
You say there are 2 schedules to the plaint. A is family property. B is your self-acquisition. How B is treated in this partition deed?
They say that property was purchased by my father in my name and therefore they have shown that property in this partition deed to me only.
Where is that?
My lord, may I
It's
just
page
take your lordship
65,
to page number
65,
60,
65 of paper book,
65.
of the paper book.
You are a signatory to this deed.
Yes, yes.
How are you going to overcome this one?
Lord, I have stated that I except signing, I don't know anything else. Except signing in English, I don't know how to read and write.
Huh?
Except signing this, I don't know how to read and write.
What is your educational qualification? Is it a registered partition or unregistered?
Registered partition.
Registered partition.
Registered
deed.
partition.
Registered partition deed.
But then how are you going to
I,
overcome that?
if
Lord, in the
law
registered
have been played upon
partition,
me.
it is said that her father acquired one property that is with her. And another property acquired by another sister, that's also with her. That's not the subject matter of the partition at all.
In this deed, it is
No.
not.
They are residing in that, and this plaintiff also enjoyed the property of her mother, receiving 35 lakhs rupees compensation.
Huh?
Her mother had one property in her name. It was acquired, and she enjoyed the usufructs of it.
Under Benami Transactions Act.
But that is
Sir,
nowhere, it is not mentioned anywhere, my lord, and
No, but we are entitled to mention, na, because of Rajagopal Reddy versus Padmini, where apex court said whether parties have taken up contention or not, duty of the court to apply law. Whether the Benami Transaction Act applies to transactions of the kind.
Lord, there is
Section 4, what
1988 Act.
88 Act.
88 Act. But is section 6 says that if whatever property acquired in the name of the wife or unmarried daughter for their benefit, they are escaped from the offense.
They are exempted from act.
ಅಷ್ಟೇನೇ ಇರೋದು ಯಾರು ಕೂಡ ಇದನ್ನು ಮಾಡಲಿಲ್ಲ. No one has taken up the contention. But she says that I have purchased the property from out of my earnings. And no property is given so far my father's property is concerned. That is her grievance.
Suit is dismissed.
suit is dismissed, my lord. Though defendants were placed ex parte.
Huh?
Defendants were placed ex parte, they have not laid down.
They were sure of law, perhaps.
Yes, ma'am. Basing on the exhibit P1, P2 and P3.
So it does not apply to
Yes.
personals. Whether that property was acquired in which year?
1991.
99.
91.
91.
Our Karnataka Amendment to Hindu Succession Act was
1994.
1994. So act was not in force. That was not.
Even also because they were married much earlier to the 1990s. To say so, my lord, what has happened, this is not the ancestral property, it's only father's property.
No, it may be father's property, but partition question will arise.
Yes,
Ancestral or-
partition took place in the year 2005.
2005 suit was filed in the year 2007.
If father has died intestate,
Yes,
naturally the children will share the property.
yes, that is
So
one
they
of,
entitled
that
to
is
seek partition.
one of,
Hindu law may not be applicable.
yes, yes.
Hindu
The-
Succession Act would be applicable.
There are certain properties left behind by the father, certain properties acquired by the brothers jointly, and one property left behind by the second wife. These are the properties divided amongst the sons of Doreswamy Mudliya. They're all self-acquired properties.
Page number 6.
This property was never treated as family property.
No, sir, ma'am.
B schedule property was never treated.
No,
as
no, no. What has happened is already registered in the name of the plaintiff,
Daughter.
daughter in 1991. And another property, another portion of the property was registered in the name of another daughter.
Alright. Whether father died leaving certain properties?
Yes,
Yes, all the
Yep.
properties.
yes.
Did he write any will?
No,
No. During father's time, any partition took place?
no.
It was all father's self-acquired property.
Yes.
Yes.
Self-acquired property.
Yes.
Certain properties are the father's self-acquired property, certain properties are acquired by the brothers jointly. That is sons. They have got this, it is a sale deed.
Please repeat.
Brothers of the plaintiff, they have acquired certain property jointly in their names.
In their names.
Then that's also included in the partition, so as to avoid any further litigations to divide these properties among themselves. And so far, another sister is concerned, she doesn't have any objection for it. But she also got the one property. That is not the part of the partition.
Now, decree is denied. Why?
Because she is the signatory to the document,
To the partition.
partition, and in the partition decided that she got the one property through his father. That's why she is actually not seeking any share in the father's property.
Which is that decision which said where a partition takes place amongst Hindus, it is not that every person should be given a share in the property, which is that.
But not, I don't.
In the partition deed, how suit schedule B property is treated?
No. How,
Nothing
B,
is-
no, D scheduled property is not the scheduled property.
No, we know that. B scheduled property is bought in the name of the plaintiff.
Yes, that is the recital in the partition deed itself.
Whether anything is said, father gave any amount, etc.
ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
That is the para, the 565. Whereas
69 ಅಲ್ಲಿ ಇದೆ. Page
65,
65.
whereas Doraiswamy has purchased the property number 6, now bearing number so and so, situated in so and so, so and so. Mudliar through register sealed in 1971, so and so, so and so. Sorry.
ಬೇರೆ sir. ಅದು ಬೇರೆ. Page number 69, if your lordship can kindly come, Lord. Whereas the party of the first part herein had purchased the property bearing number 6 situated in Corporation Division number 35, Madiwala Village, Bangalore, measuring east to west 15 feet and north to south 30 feet by registered sale deed dated 15/4/1991, registered as so and so in the Jayanagar, Bangalore. This property was purchased.
You
from
have
the
given
joint
up
family.
your right over the rest of the properties.
My lord,
Read page 69,
yes,
middle paragraph nali.
this
ಒಂದು
property
ನಾಲ್ಕು
was purchased from the joint family fund in the name of the party of the first part herein. Since this property was purchased from the joint family
You have
fund,
retained that
the party
property.
of the does not claim any right, title or interest in any of the properties
That
in
is
the schedule
permissible,
here
right?
too. Now, my lord, that is what my contentions before your lordship, my lord. My lord, your lordship may kindly come to my plaint, my lord, for a while. I am seeking reopening of the partition also.
On what ground?
My lord, a fraud have been played upon me because they said they are going to give rent agreement register ಮಾಡ್ತಾ ಇದ್ರು, rent ಗೆ ಬಂದು sign ಮಾಡು ಅಂತ ಹೇಳ್ತಾರೆ.
ಎಲ್ಲಿದೆ ಅದು?
My lord, your lordship may kindly come, my lord. My lord, if your lordship permits, I'll read from paragraph
No,
number
no,
8,
in
my
the
lord.
partition.
ಅಲ್ಲ, partition deed ಅಲ್ಲಿ ಇಲ್ಲ, plaint ಅಲ್ಲಿ ಹೇಳಿದೀನಿ. I have stated in the plaint. In the plaint, that is my contention.
You know?
My lord, they have played fraud upon me. In the said partition, the same property which is described in, you have allotted to the share of plaintiff. She is an uneducated lady, paragraph number 9, my lord.
He's not answering what is the educational background of your client. What is your educational background of your client?
You came to know about the alleged fraud.
Yes.
Have you taken any criminal action against the fraudsters?
No, that apart.
When
When,
now you come to court and say that even though the
criminal case ಹಾಕಿದ್ರೆ.
I'm not a party to it or I do not know the contents of it.
That contention I have taken. That contention I have taken in paragraph number 9.
In this,
Only in
suit
the
is
suit.
filed when?
no other action has been taken.
No other action. In the year 2007, my lord. Immediately I am coming to know I have filed in the year 2007.
Partition took place when?
2005.
2000 partition deed 2005.
Read section 17 of the Limitation Act. Read now. Section 17 says, within 3 years.
Yes.
From the date of fraud or the date on which the plaintiff with the due diligence could have discovered the fraud.
It is within 3 years only, my lord.
Huh?
2005 is the partition deed. 2007 is the suit.
2007 is the.
7
Is the suit. It is.
What are the pleadings about fraud?
Paragraph number 9, my lord. In the plaint, page number 6.
Page number 6.
Yes, my lord. May I, my lord?
1 second, wait. But your plaint is also in English only.
Yes.
Your affidavits are in English. You say you do not know English. Where is any clause in the plaint saying that this is translated to Kannada and read out to you? Where is that?
No, that we have not.
Then you understand English only. But then courts have held, unless in the absence of that clause, you know English, or that at least you have been explained everything and you understood. Registered document. In lieu of what father did was, father out of love and affection for the daughters, bought properties in the name of daughters only. At the age of 25, it is not that you had any income. It is not that you were employed elsewhere.
My husband purchased it. That is my contention.
No, but you have said here that my father bought this property.
The partition deed, they have mentioned like that. That is my contention. In the partition deed, they have mentioned like that, stating that rental ನಾನು ನಿಮ್ಗೆ ಇನ್ಕಮ್ ಕೊಡ್ತೀನಿ ಅದಕ್ಕೋಸ್ಕರ ಬಂದು ಸೈನ್ ಮಾಡು ಅಂತ ಹೇಳಿ ಇದನ್ನ ಈ ತರ ಬರೆದು ಸೈನ್ ಮಾಡಿಸಿದ್ದಾರೆ. That is my contention, my lord.
From that,
ಈ contention.
oral evidence against oral evidence. What else?
Still, ಈ
What
contention.
else means your husband's evidence should have been there. It's not there.
You have not examined your husband also.
Yes.
Isn't it?
Not only that, that condition, section 91 of the Evidence Act says, in respect of registrable instrument, which is so registered, you cannot set up super addition of conditions. Padi, 91, Evidence Act. Padi. Unless you said that it was a separate transaction. Read 91.
But here, the defendants were placed ex parte.
ಅವ್ರ ಎಕ್ಸ್ಪರ್ಟ್ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ ಕೋರ್ಟ್ ವಿಲ್ ಡೂ ಜಸ್ಟಿಸ್ ಅಂತ ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ. ಎವ್ರಿಬಡಿ ನೀಡ್ ನಾಟ್ ಕಮ್ ಟು ಕೋರ್ಟ್. ಐ ಮೇ ಚೂಸ್ ಟು ರಿಮೇನ್ ಅಬ್ಸೆಂಟ್. ಇಫ್ ಐ ಫುಲ್ ಫೇತ್ ಇನ್ ದ ಜುಡಿಷಿಯರಿ, ದೇ ರಿಮೇನ್ಡ್ ಅಬ್ಸೆಂಟ್. ಕೋರ್ಟ್ ಕರೆಕ್ಟ್ ಮಾಡ್ತದೆ ಅಂತ ತಿಳ್ಕೊಂಡೆ ಅಬ್ಸೆಂಟ್ ಉಳ್ದಾರ ಅವರು. ಅವ್ರು ಅಬ್ಸೆಂಟ್ ಇದಾರೆ ಅಂದ್ರೆ ಡಿಗ್ರಿ ಕೊಡಕ್ ಬರ್ತದ ನಿಮ್ಗೆ? 91. Read 91. It is so beautifully drafted by Phipps and perhaps. When the terms of a contract or of a grant or any other disposition of property, Justice Gajen Gadkar says, Honorable Justice Gajen Gadkar says, any other disposition of property will include partition amongst the Hindus, have been reduced to the form of a document. It has been reduced to the form of a document now. And in all cases in which any matter is required by law to be reduced to the form of a document. In Karnataka, partition is compulsorily registrable, though not memorandum of partition. Partition deed is compulsorily registrable. Therefore, it is compulsorily to be reduced to writing. All right. No evidence shall be given in proof of the terms of such contract, grant or the other disposition of property or such matter except the document itself. Courts have interpreted. Your contention is rejected at least by 3 high courts in the country. 3 high courts in the country, including our high court. You cannot say, see the section, how it reads so powerfully that has been drafted. 91. Evidence of terms of contracts, grants or other disposition of property reduced to form of documents. You will not lead evidence also, let alone pleading. Evidence annu lead ಮಾಡ್ಲಿಕ್ಕೆ ಬಿಡಲ್ಲ. ಯಾಕಂದ್ರೆ to save the sanctity of compulsorily writable documents. Register ಆಗಬೇಕು ಅಂತನೂ ಇಲ್ಲ. And now it has been reduced to writing. A document is reduced to writing. In the alternative, a document is compulsorily to be reduced to writing. Then also it applies. Partition deed in Karnataka is compulsorily to be in writing and to be registered also. Where do you stand? ಎಲ್ಲಿದೆ ನಿಮ್ಗೆ ನಮ್ ಸ್ವಲ್ಪ ಏನಾರ ಒಂದು ಸಪೋರ್ಟ್ ಮಾಡಿದ್ರೆ ನಾವು ನಿಮ್ ಪರವಾಗಿ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀಬಹುದು. ನೀವೇನು ಏನು ಮಾಡ್ತಾನೆ ಇಲ್ಲ.
Only submission is that her property not included in the partition. She is enjoying the property.
Her property ಅಂದ್ರೆ ನಿಮ್ ಕೇಸ್ ಹೋಗತ್ತೆ.
Her property is the property acquired by her father in her name, according to the partition deed.
And this binds.
Yes.
Go to this. Read one more section. Read section 115, illustration 1. You cannot set up a case at all.
Stop.
No, my lord, the partition
Estoppel.
deed is contrary to the sale deed also.
ಹೋಗಿ ಮುಂದೆ. Read that illustration 1, which is taken from perhaps Bombay High Court.
Estoppel.
Yes.
A intentionally and falsely leads to B, believe that certain land belongs to A and thereby induces to B to buy and pay for it.
Read further.
The land afterwards becomes the property of A and A seeks to set aside the sale on the ground that at the time of sale he had no title, he must not be allowed to prove his want of title.
Yes. He shall not be permitted to contend to the contrary. You assumed a fact matrix that this property was family property. That is the text of registered partition deed.
Blood. The document at
Whether
exhibit-
entries were entered in terms of this partition deed?
Yes.
ಎಲ್ಲಿದೆ?
Although they have got all the documents, revenue documents.
ಬೇರೆ ಎಲ್ಲರೂ ಒಂದ್ ಕಡೆ ತೋರಿಸಿ.
ಇಲ್ಲ ನಾವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ.
ನೀವು
Written
ex parte.
statement to Akila, my lord.
But I-
That is why I made a submission that they were placed ex parte. The trial court ought to have believed the version of the plaintiff, my lord.
Okay.
Now, my lord, document exhibit P2, the sale deed, which is standing in my name. According to them, my lord, partition deed reads that it was purchased by my father out of the joint family funds. That is not the case, my lord. It was purchased after my marriage and so
But you are
therefore.
not examined your, my brother told you, nothing came in the way of, you were examining your husband as a witness.
The testimony that I was illiterate, etc., that too in English. What else is there?
May I just seek for.
ಏನಿಲ್ಲ ಏನಿಲ್ಲ ಇಷ್ಟು ಟೈಮ್ ಕೊಡೋದೇ ಅಲ್ಲ ಇದಕ್ಕೆಲ್ಲ ಕರೆಕ್ಟ್ ಬರ್ದಾರಲ್ಲ ಒಳ್ಳೆ ಅಲ್ಲೊಂದು there is a judgment of pre-council which said where a partition takes place in a joint Hindu family, it is not that every member of the family should be given the share anta. Even when it is not given, if some plausible reason is given as to why it is not given, partition is valid.
ಕೆಲವೆಲ್ಲ in terms of money will be paid and they will relinquish their
ಈ
right.
ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟರು ಅನ್ನೋದಕ್ಕೆ ಬೇರೆದ್ರಲ್ಲಿ ಶೇರ್ ಕೊಟ್ಟಿ ಅಷ್ಟೇ. ಇಟ್ ಇಸ್ ನಾಟ್ ದಟ್ ಯು ಆರ್ ಎಂಟಿ ಹ್ಯಾಂಡೆಡ್, ಯು ಆರ್ ಹ್ಯಾವಿಂಗ್ ಗುಡ್ ಪ್ರಾಪರ್ಟಿ. ಎಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ಎಸ್
for the petitioner.
Yes.
That the tribunal would allow the application of the DGO on the ground, not that there is a difference of opinion between the report of the inquiry officer and the Honorable Uplokaikta, which could not have taken place.
What
And
was?
thereafter penalty order is passed.
Inquiry report said he is not guilty.
Inquiry
And
report examined.
the disciplinary authority disagreed with that.
But the Honorable Uplokaikta would disagree with that and submit a recommendation contrary to the inquiry report.
It is open to him.
It's open.
Only thing is any proposal notice to be issued for.
Thereafter, yes, ma'am. Thereafter, this is the second round. In the earlier round, the tribunal had said the second show cause notice does not follow the principles of Kunj Bihari Mishra, whereby if the disciplinary authority has to differ from the,
Disagree,
yes,
it has to give
the
proposal
grounds have to
notice.
be given. So, my lord, it was set aside on the earlier occasion. Thereafter, my lord, the disciplinary authority, government, my lord, has followed Kunj Bihari Mishra, given 8 reasons why it wants to distinguish from the report of the inquiry officer, and second show cause notice was issued. Thereafter, my lord, the DGO would give his reply, penalty order is passed.
Penalty is what?
Compulsory return.
Compulsory return. What is the charge?
1,500 rupees, my lord, bribe amount.
Quantum is also a factor where they deal with the money itself, like a cashier, bus conductor. Only in that Supreme Court said a stringent action, not in 1,500. How many years of service he has put in?
As I've completed the entire, I've attained superannuation. I've retired on attaining the age of superannuation. I was in service throughout.
214, one provides for 1A,
Yes,
provides for deduction from reduction of pension.
Yes, my lord, reduction of pension. But my lord, for that, my
ಅಲ್ಲ,
lord,
compulsory service ಆದ್ರೂ after this punishment is handed after retirement.
prior to retirement.
Prior to retirement.
Yes, my lord.
How many years of service?
Prior to my retirement, my lord, I was imposed with the, yes, my lord.
Correct. It has to be prior to only.
Yes, my lord.
How many years of service he had?
7 years, my lord.
7 years.
Yes, my lord.
Qualifying service ಆಗಿರ್ಲಿಲ್ಲ.
ಆಗಿತ್ತು ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಸರ್ವಿಸ್ ಎಲ್ಲ ಆಗಿತ್ತು.
7 years ಅಂತ ಹೇಳ್ತಿಲ್ಲ.
No, my lord. When the penalty was imposed, I was 53 years.
Only 7 years were remaining for retirement.
Yes.
How many years of service he has put in?
I have totally, my lord, put in a service of, the service particulars is not available. I'll get
ಯಾವ
it.
ಡೇಟಿಗೆ
2006 is the articles of charge, my lord.
2006.
Yes, my lord, is the articles
ಏನು
of charge.
ಡೆಸಿಗ್ನೇಷನ್?
Let's the
SDA.
second division assistant, my lord.
ಎಲ್ಲಿ ಯಾವ ಆಫೀಸ್?
DC
office,
office, Tumkur.
ತುಮಕೂರು. DC ಆಫೀಸ್.
Please.
For release of check, you would demand.
The tribunal has allowed the application in the year 2019, 2006 charge, application penalty in 2016.
Who delay is attributable to whom? You went to tribunal and got the matter stayed there.
No, my lords. After the penalty, my lords, I approached the tribunal, my lords.
No, earlier also you had approached, na?
Earlier.
That proposal notice was not given ಅನ್ಕೊಂಡು ಅಂತೇನೋ ಇವರು ಅರ್ಬಟ್
Yes.
ಏನೋ ಹೇಳಿದ್ರಲ್ಲ.
2015 is the earlier order.
2015 is the earlier order. Then, my lords, 2016 was the fresh order, which I challenged. Allowed in 2019, my lords. Writ before your lordships is of the year 2023, my lords, after 4 years. my
ಅಲ್ಲ, 2016 the act, how many years it is, why it was pending so many years? ರಿಟೈರ್ ಆಗ್ಲಿ ಅವನು ಅಂತ. 2002. Retired in the year
2024, my lords.
2024 he has retired. Pension
ಅಲ್ಲೇ pension ಬಂದು ಹೋಗುತ್ತೆ. 2002 incident, 2024 retirement. Therefore, my lords, 22 years. I've put in the qualifying service.
That's all right. 22 years under full pension ಬರಲ್ಲ.
But I've served the full months, as in,
No. 29 years, 3 months ಏನಾಗಬೇಕು full pension.
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆನೂ ಸರ್ವಿಸ್ ಇದ್ದೆ. My submission was, my lords, even if the date of incident is taken into consideration, 22 years has elapsed. Therefore, my lords, I have put in service sufficient to get pension.
Get pension all right, but 1500 ತಗೊಂಡ್ ಬಗ್ಗೆ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ ಅಲ್ಲ?
My lords, yes, my lords, that enquiry
ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಅಷ್ಟು ಮಾಡಿದ್ದಾರೆ.
enquiry report, my lords, would the reasoning would start
Compulsory retired with effect from which date?
with effect from
2016.
2016.
Yes,
Now you have attained the age of superannuation.
yes.
But how that adds merits to your contention?
Now, my lords, ultimately, as on the date of the 2016 when the order was passed, my lords, thereafter it was set aside, my lords. Now, my lords,
You are in service.
yes, my lords, I was in service.
You are in service up to what date?
2024, my lords.
Till you attain
Yes.
the age of retirement?
Yes, my lords.
That was on the strength of
Court orders.
court order.
Yes, my lords.
Court order ಇದ್ರೆ ಮಾಡಿ.
Now, my lords, ultimately, if the tribunal order is now reversed, then, my lords, the order of compulsory retirement will be reinstated. Then, my lords, for the entire service, my lords, that I have put in, I'm entitled to the benefits. So, in that sense, my lords, it might become infructuous.
ಅಲ್ಲ, ಕಂಪ್ಲೀಟ್ ಇನ್ಫ್ಲೆಕ್ಚುಯಸ್ ಹೆಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ಡಿಸಿಪ್ಲಿನರಿ ಮ್ಯಾಟರ್. Because of court order, if you continue in service, how that you can take advantage of?
My lords, because the enquiry report was in my favor.
Right. Enquiry report was in your favor. He did not agree. Therefore, he gave a proposal note. It was not given and therefore matter was remanded. Thereafter, they gave that. Then they have passed that order.
No,
How it will become infructuous, brother?
in the sense, my lords, that even if the penalty is upheld today,
Yes.
from today, my lords, it will come into operation.
No.
From that day.
From that day. Because
Your lordships are upholding that.
Yes.
Your lordships are.
We have upheld that view, na? Perhaps you.
Yes, my lord. Yes, my lord. Yes, yes.
Satish Bhatt argued
Yes,
that.
yes.
ಕೋರ್ಟ್ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಆ ರೀತಿ.
But today, my lords, the ground on which tribunal grants me relief is the disagreement note. After the inquiry report, I am entitled to a disagreement note.
Correct.
That disagreement note is not given to me. Straight away, second show cause notice is issued to me. It is on that ground, my lords, the penalty.
ಡಿಸ್ಅಗ್ರಿಮೆಂಟ್ ನೋಟಿಸ್ ಪ್ರಪೋಸಲ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿರಲಿಲ್ಲ.
Second show cause notice itself contains the 8 reasons of disagreement. The second show cause notice which is issued, my lord, it contains, my lord, it fulfills the
ಮಿಶ್ರಾ.
Kunj Bihari
No, my lords, Kunj Bihari Mishra said, after the inquiry report, you must give a disagreement note, tentatively giving out reasons as to why you
want to
propose
disagree.
to disagree. After my reply,
Then
then
you
my
will have
lords,
a second show cause notice
yes, ma'am.
also.
Yes, ma'am.
That
That is the-
cannot be amalgamated.
so
in
great,
one.
sir. Yes. Kunj Bihari Mishra followed in Yoginath Babde. That was the ground.
I would not.
ಇಲ್ಲ ಹಂಗ್ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
But Kunj Bihari Mishra says if the disciplinary authority disagrees,
Disagrees,
give a notice of the disagreement.
not
Again,
not
thereafter,
second.
not again, not one more show, second show cause notice. is
No,
not
that
accepted.
has to be.
But then my research
See.
is incomplete. But then that was my understanding.
No, it's a wrong
Yes.
understanding. It cannot be like.
I'll stand corrected. Not. If what my learned friend is saying, I'll
That's
stand
the
corrected.
law now.
But my understanding, Kunj Bihari Mishra was disagreement note. This second
But
show cause notice-
disagreement note and second show cause notice cannot be in one ಅನ್ಕೊಂಡು ಅದರಲ್ಲಿ ಹೋಲ್ಡ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ ಅದರಲ್ಲಿ
ಮಿಶ್ರಾದಲ್ಲಿ ಹೋಲ್ಡ್ ಮಾಡಿಲ್ಲ.
Yes.
Whereas we held that way
Yes, ma'am.
in Dharwad.
Yes, ma'am. Because
Bring that judgment.
Kunj Bihari Mishra said tentative reasons have to be assigned.
Always,
that and
always.
When you are overturning a finding in favor of a delinquent.
One, you have to give tentative reasons as to why you disagree. Then he will show reason, he will show cause why it should not be. Then you will form your opinion. That takes the character of final report, inquiry report.
Yes.
Based upon that, if you want to take any action, again, whether a second show cause notice should be given or not, is the subject matter of some decisions. In some yes, in some no, like that they have taken. ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಮೋಸ ಮಾಡೋದು ಬೇಡ, ಯಾಕಂದ್ರೆ ಇಂಥದ ಬೇರೆ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಅದ್ ನೆನ್ಪು ಮಾಡ್ಕೋಬಹುದು. We'll accumulate those matters and we'll dispose of all those matters in this one. Anyway, he has retired now.
Yes. But my pension is held up.
That's what. ಇಲ್ಲ some pension, if you are agreeable,
Yes.
some percentage of pension.
Provisional pension.
Otherwise, 2016 ಗೆ if we give retrospective effect to the penalty order, which we have to in the event we uphold his contentions, then service rendered from 2016 to 2024 will be discounted.
Yes.
Just calculate
Yes.
what is the amount of pension you will get for that.
Yes.
If 10% is less than that,
Yes.
then you can seek that way.
Very well. I'll
Alright.
file a necessary application.
Yeah, application better. You can make that this one
Very
straight. Call week after next. Yes. ಅಂತವೆಲ್ಲವನ್ನು ಅಷ್ಟನ್ನು ಅಕ್ಯುಮುಲೇಟ್ ಮಾಡಬೇಕು.
Great.
ಅದು ಒಂದು 3-4 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಪ್ಲೀಸ್ ನಮ್ಮ ಮುಂದೆ ಬಂದು ಹೋಗಿದ್ದು. ಹಾ 32 ಪ್ರಕಾಶ್.
It's a direction.
Ah.
This is a- I'm accused before, my lord, the land grabbing prohibition court.
Ah.
My lord, I applied for discharge and my application was rejected by the, my lord, the court. My lord, this honorable court, my lord, directed, my lord, kindly see the order dated 2/7/24. Last paragraph, my lord, in that. 2/7, last paragraph.
2/7/24. Point 2, list the matter after. However, this petition.
Government AGA is,
55 Karnataka, therefore, London AGA is directed to execute report from the competent revenue authority to proceed further in the matter. AGA is directed to take notice for response numbers 1 and 3.
multiple. My case is, my lord, I am owner, my mother is the owner of 2 acres of land. My lord, that was purchased by my father under a registered sale deed. I have produced copy of this.
Dated?
My lord, sale deed, annexure A, my lord, sale deed. My lord, sale deed,
Annexure A ಅಲ್ಲ.
annexure E, my lord. E, my lord, typed copy is available at page 51. My father purchased, my lord, in the year 1968.
3468.
Yes, my lord. Well, English translation. Then, my lord, your lordship kindly see record of rights. It was, my lord, granted to my father's vendor, my lord, by the government. And the complainant alleges, my lord, that I am in possession of 5 acres of land in this survey number. My lord, it is belongs to government. That is the allegation.
What is the extent of sale deed?
My lord, only 2 acres. My lord, my objection, my lord, I have filed objection to the complainant. I said I am in possession of, that is my mother in possession of 2 acres. Well, this is, my lord, considered as a land grabbing.
111, 111, my lords.
111.
7, para 7.
ಅಲ್ಲ ಅದ್ ನಿಮ್ಗೆ 3 acres ಬಂದ್ಬಿಟ್ರೆ ಆಗಿ ಹೋಯ್ತು.
ಅಲ್ಲ, ಅದು
I don't-
specific condition. Kindly see para 7 of that act. Impugned by 111.
Paragraph 7.
Please. ma'am. Is the specific contention of the learned counsel for the complainant that the accused number 1 and 2 have admitted the 5 acres 10 guntas of the land is reserved for Sarkari Pada. It is the case of the complainant that 5 acres 10 guntas government Pada is encroached by accused number 1 and 2 and running a small scale industry and constructed a building. It is further contended that the accused person have not produced any document to substantiate this fact to Hanumanta Rao, son of Venkoji Rao, was granted 2 acres land until and unless they establish the said fact. It cannot be heard that it is a granted land. It is further contention that the Pani produced along with the complainant clearly goes to show that survey number 13, there is a Sarkari Pada to an extent of 5 acres 10 guntas. Under such a circumstance, there is no question of granting any land in favor of anybody. It is further contention that even the records in respect of the site which is alleged to have been granted in favor of the accused are concocted and fabricated documents. And as such, this is a juncture. It cannot be heard that it is a granted land.
68 ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ ಲ್ಯಾಂಡ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಏನಿದೆ? ಸೇಲ್
Yes, yes.
ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ಸೇಲ್ ಡೀಡ್ ಏನಿದೆ? ಲ್ಯಾಂಡ್.
My lord, ಭದ್ರಾವತಿ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್ ಒಳಪಟ್ಟ ಕೂಡ್ಲಿಗೆರೆ ಹೋಬಳಿ ಎರೆಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 13 44ನೇ ಪೋಡು 3 ಎಕರೆ 2 ಜಮೀನು ಚಕ್ಬಂದಿ ಪೂರ್ವಕ್ಕೆ
ಅಲ್ಲ, ಸರ್ವೆ ನಂಬರ್
13
13
ಹಾ
ಸೇಮ್ ವಿಲೇಜ್.
ಹೌದು 44 ಬ್ಲಾಕ್ ನಂಬರ್ 44 ಕೋಡ್ 44.
ಸರ್, ಈ ಸರ್ವೆ ನಂಬರ್ ಎಷ್ಟು ಮೆಜರ್ ಮಾಡ್ತದೆ ಟೋಟಲ್?
My lord, that is, my lord, 5 acres.
ಈ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲೇ 5 acres ಇದೆ.
ಇದೆ ಅಷ್ಟೇ ಇದೆ.
ಅದು ಇದರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಬ್ಲಾಕ್ಸ್ ಇದೆಯಾ?
ಬೇರೆ ಬ್ಲಾಕ್ಸ್ ಇದೆ. ಈ ಬ್ಲಾಕ್ ಅಲ್ಲಿ ಇಷ್ಟೇ. ಇಲ್ಲಿ ಕೆಳಗೆ ಪೂರ್ವಕ್ಕೆ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಕೆಂಚಮ್ಮನ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಅಪ್ಪನ, ಉತ್ತರಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 13ರ ಜಮೀನು. ದ ರಿಮೈನಿಂಗ್ ಪೋರ್ಷನ್ ಆಫ್ ದ ಲ್ಯಾಂಡ್ ಸರ್ವೆ ನಂಬರ್ 13.
You have bought only 2 acres?
Only 2 acres.
ನಿಮ್ದು ಮನೆ ಎಲ್ಲ ಕಟ್ಟಿಕೊಂಡಿದ್ದೆ ಅದರಲ್ಲಿ?
ಹೌದು.
ಯಾವ್ದ್ರಲ್ಲಿ ಕಟ್ಟಿಕೊಂಡ್ರಿ ಮನೆನ?
ಮನೆ ಇದ್ರಲ್ಲಿ ಮನೆ ಇಲ್ಲ, ಜಮೀನ್ ಅಷ್ಟೇ ಇರೋದು.
ಮತ್ತೆ ಅಲ್ಲಿ ಮನೆ ಕಟ್ಟಿಕೊಂಡಿದ್ದು?
No, that is another site. My lord, was granted to, my lord, the second petitioner by the village panchayat.
Where is that?
My lord, I have produced, my lord, the document relating to that. My lord, your lordship kindly see that those documents. My lord, page 74.
ಅಲ್ಲಿ ನಿಮ್ಮ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೇನು?
Yes, my lord.
ಅದ್ರಲ್ಲಿ ಏನೇನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ?
My lord, these documents, all these documents I have produced there.
ತೋರಿಸಿ.
These documents I have produced along with that, my lord. My lord, annexure C, my lord, page 42.
ಯಾವುದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಸಹಿತ ಹಾಕಿಲ್ಲ ನೀವು, ಬರೀ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಹಾಕಿದ್ರಿ.
Lord, I shall produce, my lord, certified copies, sir. My lord, the division bench, my lord, while upholding constitutional varies, my lord, I have the petitioners also challenged the constitutional varies of the act. Apart from challenging, my lord, taking cognizance of the complaint before this honorable court, my lord, I shall pass on this. My lord, the division bench held that, my lord, those lands, my lord, granted in favor of a person under the Land Grant Rules or Land Revenue Act or any other enactment, those lands shall be excluded from the purview of the act. That is, my lord, the judgment of this court. I brought to the-
Correct. But how the finding of fact can be entered by writ
No, my
court?
lord, the documents, my lord, the
Those
case, my lord.
documents.
My lord, your lordship kindly say, I have produced, my lord, registered sale deed. Revenue entries, my lord, revenue entries.
Documents of the prosecution alone shall be looked into is the decision of apex court. Apex court said even latest decision,
My
You
lord,
cannot rely on all your documents.
your documents at all.
That is matter
my
of.
lord, this is a
interest.
registered sale deed I have produced, my lord, before the tribunal, before the court.
The consistent view of the apex court, barring one or two exceptions, while entertaining the discharge application either under section 228 and 227 and or 339.
My lord,
339, apex court says only the prosecution paper should be looked into.
my lord, that's why, my lord, on the last occasion, my lord, dishonorable court, after hearing me, directed, my lord, learned government advocate.
ನಿಮ್
to
ಪರ್ಮನೆಂಟ್
append-
ಎಕ್ಸಂಪ್ಷನ್ ಕೊಡೋಣ ಟ್ರಯಲ್ ಹೋಗಿ. ವಿಲ್ ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು ಗ್ರಾಂಟ್ ಪರ್ಮನೆಂಟ್ ಎಕ್ಸಂಪ್ಷನ್.
Please,
ಅಗೇನ್ ಅಂಡ್ ಅಗೇನ್ ಬೆಂಗಳೂರಿಗೆ ಬರ್ಬೇಕು ಅವ್ರು. ಟ್ರಯಲ್ ಹಾಕೊಳ್ಳಿ, ಇದನ್ನೆಲ್ಲ ಡಿಫೈನ್ ಮಾಡಿಕೊಳ್ಳಿ. ವಿಲ್ ಸೇ ದಟ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಪರ್ಮನೆಂಟ್ ಎಕ್ಸಂಪ್ಷನ್ ಈಸ್ ಗ್ರಾಂಟೆಡ್ ಅಂತ. So that you can face the trial,
Only-
put all your documents in place.
Only rejected is the objection, that's all, my lord.
ಆಗುದು.
Give all these
With all these documents, or you can lead your evidence also.
Then you file 227.
Court below is only rejected is objection, that's all. my lord.
Objections to
95D to that complaint.
ಅದು ರಿಜೆಕ್ಷನ್ ಅಂದ್ರೆ ಮತ್ತೆ ಅದು ಚಾರ್ಜಿಗೆ ಹೋಗೇ ಬಿಡ್ತದೆ. ರಿಜೆಕ್ಷನ್ ಆದ್ಮೇಲೆ ಇನ್ನೇನು
Next stage.
ಬರ್ಕೊಳ್ಳಿ. ಮತ್ತಿನ್ನೇನು ಬೇರೆ ಇನ್ನೊಂದು ಇಲ್ಲ ಯಾವ
PW1 ಗೆ ಇದೆಲ್ಲ confront ಮಾಡಿ.
ಮಾಡಿ.
Limit ಆಗುತ್ತೆ.
My lord, a private complaint, my lord, with whom I am fighting litigation, my lord, he has lodged the complaint. I
We'll
understand.
give you, Prakash, we'll give you permanent exemption to you. Okay, we'll say that both you have agreed with the suggestion of the court,
Please, my lord.
therefore accordingly dispose. Because if we say something that should not affect your defense, Barkali. Petitioners are invoking the writ jurisdiction of this court for assailing the special court's order dated 23/4/2024, whereby their objection to the framing of charge has been turned down by the said court in case number LGC, ನೋಡಮ್ಮ, case number prayer ನಲ್ಲಿದೆ, ಅದ್ನ ಹಾಕೋಬೇಕು.
2684.
Next. Learned counsel counsel appearing for the petitioners vehemently argues that registered documents which his clients hold vouch their title to the subject land in survey number 13 of the village concerned, and therefore by no stretch of imagination they can be treated as the encroached land. ಎಂತದದು?
Grabber, land grabber.
Grabbed land. First up. In view of that, comma, he further submits, comma, the court below could not have turned down their objections. First, learned AGA on appearing for the official respondents opposes the petition, contending that where the criminal case is at the stage of 227 of CRPC, comma, what the court can look into is only the prosecution papers, subject to all just exceptions, into which argued case of the petitioners does not fit, and therefore the impugned order cannot be faltered. First up, he also adds that whether it is a grabbed land or the privately owned land is a matter of fact which can be ascertained only in trial, and therefore the petition should be dismissed. First, next, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned GA appearing for the official respondents, that pure questions of facts cannot be determined in a writ jurisdiction, more particularly one under Article 227, the other companion article, namely 226, having been ornamentally employed in the petition pleadings. First up. Next part. At this stage, learned counsel for the petitioner submits that his clients are entitled to permanent exemption and that they would participate in the trial once it begins. First up, trial is a turbulation in criminal proceedings, needs hardly to be stated. First, this view gains support from the apex court decision in Pepsi Cola versus AR 1998, Supreme Court page 120. PepsiCo versus not very big. All right, first up. Next up, in view of the above, this petition is disposed of without granting interference in the impugned order. First up. However, in the special fact matrix of the case, we direct the court below to grant permanent exemption to the petitioners, subject to they effectively participating in the trial if and when it is commenced. First, ordered accordingly. Can we, Mr. Raghavan, can you have this matter some other day? We have some matter.
Yes.
Interim order.
Interim order, continue order.
Interim order.
You will short date may fix it.
Yeah, we are the matter.
Because I am
Oh, of
suffering
course,
the
it's a
interim
very-
order.
For
Your lordship may have it on Monday or next Wednesday.
on 17th, we will have
Yeah.
call this matter
On 7th.
on 17th. Yes, ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ 2 weeks ಆದ್ಮೇಲೆ ಕೊಡಿ ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಎಂಟ್ರಿ ಮಾಡರ್ ಟು ಕಂಟಿನ್ಯೂ ಓಕೆ ಸರಿ ಎಲ್ಲದಕ್ಕೆ ಅಪ್ಲೈ ಆಗ್ತದೆ ನೋಡ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಮಾಡ್ಬೇಕು
Serial number 34, the Land Grabbing Act again. The charge is to be framed on 9th. It is, and mine is a case where there is a prior sale deed well before the date of the enactment.
ಮೊದಲು ಒಂದು ಡೇಟ್ ಹೇಳಿ
All I seek is an interim order till the next date, that's all.
Serial number 34, my lord, execution is coming.
ಎಲ್ಲ 2 weeks ಹಾಕಿ ಇಂಥ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡೋದು ಡೇಟ್ ಇತ್ತು ಅಂದ್ರೆ ಅದನ್ನ ಅಸರ್ಟನ್ ಮಾಡಿ ಒಂದ್ ದಿವಸ ಮೊದಲು ಹಾಕೋಬೇಕು
My lord, serial number 34, my lord.
We have said, na?
My lord, serial number 34. Execution.
Execution.
Execution ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
ಯಾವತ್ತು?
On 27th of December.
ಡಿಸೆಂಬರ್ ನೋಡ್ರಿ 24th ಹಾಕಿ 18th ಹಾಕಿ all other matters.
34. ಯಾವುದು? Sir, ಒಂಚೂರು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಮಾಡಿ ಸರ್. How come matters coming on 9? 18th ಅಲ್ವಾ ಸರ್?
24. Sorry, 37.
6th 9th ಗಿದೆ ಚಾರ್ಜ್ 6th ಹಾಕಿ Sixth ಹಾಕಿ
ಸರ್ 18th ಅಲ್ಲ?
Sorry.
35 ಸರ್ ಏನು ಸರ್ ನಮ್ದು ಯಾವತ್ತು ಹಾಕ್ತಾರೆ ಡೇಟ್
ನಮ್ದು 18th article okay.
ಅದು ಆಮೇಲೆ
ನಮ್ದು 18th.
ಮಾತಾಡ್ಬಿಡ ಸೀರಿಯಸ್ ಆಗಿ ಮಾತಾಡ್ಬಿಡ ಇದು ಯಾವ ಡೇಟ್
2 weeks ಅಂತ ಹೇಳಿದ್ರು. ಸರ್ ಒಂದ್ ನಿಮಿಷ ಸರ್ ಯಾವತ್ತು
35 5th ಬೇಡ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವತ್ತು 5th ಬೇಡ ಅಷ್ಟೇ.
ಫಿಫ್ತ್ ಏನಾಗುತ್ತೆ ನಾವೇ ಇದ್ದೀವಿಲ್ಲ ಅದಕ್ಕೆ
We are
Sir.
for,
35 ಅವತ್ತು ರೂಬಿನ್ ಸರ್ ಸ್ವಲ್ಪ ಇದಿದ್ದಾರೆ ಫಿಫ್ತ್
no, there is, at the same, they want adjournment ಅಷ್ಟೇ.
ನೋ
Court has
ಇಲ್ಲ
given the date. ಸಾರ್ ಕೊಟ್ಟಿದೆ. You come next day. We will take adjournment for you for next day.
ಎಸ್ ಸರ್ ಡನ್ ಸರ್ ವೆರಿ ಗುಡ್.
You have to file an affidavit. He need not be here for affidavit.
ಹೂ
Rubin.
he has to come no I will tell that you don't worry sir 39 ಯಾವಾಗ ಹಾಕೊಂಡ್ರಿ after vacation after 2 weeks thank you.